when I saw the X-ray thing, I had some people that were in my Discord who were they're free Karen Reed supporters, and they would tell me, oh, the same thing. Hey, these X-rays weren't introduced. Hank hid them. Hank did this, and a bunch of nonsense. To be 110% honest with you, I was like, well, hold on. Was it used in the last hearing? And because I didn't watch the last hearing, and from what I understand, they weren't. And I was like, okay, well, this seems like it was newly discovered stuff. And then it was hard to tell from the hearing, the angle of the images. But one of the things that I had noticed is that the pelvis was in there. And I think the lady, the witness even mentioned that you can see the pelvis in there. Now, I recently had arm x-rays taken because of my injury. My arm wasn't next to my body. And so it was purposefully apart. They have you twist your arm in several different angles so that way you can get it from several different angles, and that way they can see if there is a fracture, hairline fracture, those type of things. And so when I looked at the images that they were presenting, to me it looked like it was a full body x-ray, and then they cropped into the arm and then zoomed in, which I'm not sure what kind of effect that would have on the actual x-rays itself. I mean, typically when you zoom in things and blow them up, you might lose some of the finer details, such as a hairline fracture or those type of things. And so I'm interested to see how Dr. Welcher answers this question.
Jen, you were a paramedic, I believe, right, or some level of first responder before you joined the FBI. So, what kind of, if they pick up someone like this unconscious, what do you think? What is the habit here? Do they put him through some kind of an X-ray machine to get a quick idea of what might be wrong with him? What happened there, Jen?
Okay, so I did want to make this clear. I was never a nationally registered EMT until 2003, when the FBI, I became a tactical SWAT EMT. And so I went through 6 months of training and fire department training, rotations at a hospital, and was certified. And I've kept that certification. In fact, I had to just finish my testing in February. Again, every 2 years you have to be recertified. It's brutal. And so I'm a tactical EMT, and have been since 2003 with the FBI, and then now just on my own. But in answer to your question, what's going to happen is immediately, and this made all the sense in the world to me, even though the number one thing you're going to do is when they come in, it's total triage at that point, life-saving measures, right? Which they talked about. They started on the bus, ambulance, they call it the bus. And then they begin of course, the warming. They're trying to get his heart going. All of that would be going on. And very tertiary to that would be these x-rays. And I'm really surprised that they did them, because they would have little, in a sense, to do with the magnitude of the life-threatening situation they had with John O'Keefe. But it would appear, so after everything's triaged and you have the person somewhat stable, that would be when you would go have the x-rays done.
Right. Okay.
I hope that provided some clarity.
So what kind of x-rays is it done? Is they just put them quickly through a quick CT scan where they just get the whole body in, and they're looking to see, what are they looking for? Are they looking for broken bones? Are they looking for bleeding? What would they specifically be looking for?
Well, the CT scan literally would last 5 minutes. Yeah. So they would wheel them off, just put the head in there. And as far as the x-rays, even the x-rays could be done very quickly in a hospital. It's so quick. So it seems to me that they did those because obviously you're wanting to see, even though they have all the signs of the raccoon eyes and the other injuries, they want to see exactly what they have. In other words, are any bones, as an example? Is there a cracked rib that's perforated a lung? Right? Something like that. So it's smart if you're still in that treatment stage. But to me, gosh, he was such at a medical, really death. at that point. But it does make sense that they would have x-rayed. Kevin, it takes just minutes.
Somebody's saying here in chat that the doctor testified that there were no X-rays. I can't vouch for that. I don't remember.
Yeah, I went
That's
back and listened. Dr. Rice did say that they did not.
So
do
where did these
X-rays.
come from? I
It
don't-
must have been the coroner's office.
But she also, Scotty Bella testified that they didn't do any X-rays.
Did she though, or are we just imagining that? Obviously somebody did X-rays. So
Yeah.
someone did x-rays. They're all of a sudden popping up. Like I said, and for people to think that we are purposefully just not telling the facts we know, and I'm seeing that go around, it's so ridiculous. You know, I'm trying to put my fingers on where these x-rays came from too. And Kevin, I appreciate your research, but Kate, where does that bring us to fact-wise?
what do you mean?
I mean, where did they come from?
We don't know for sure. It does seem like it was probably Dr. Scorty Bello.
I need to go back and look through not only her testimony, but I need to look at the filings. I have all those filings highlighted and marked all up. I need to go back and look through there.
And why didn't the defense use this last year? Since there's no bones, it would have helped them last year too. So
I mean, I think it's always been testified to that they didn't find any fractures, and I think most likely Crosby was not shown any. I'll get rid of mine. Was not shown any X-rays, because why would he be shown a negative X-ray? And I think it's.
It also helps the prosecution, though, because remember, they're trying to say a fight. You would expect possible with a fight that was to the death like this, knuckle damage, issues in that regard. You know, they just should have shown them if they had them. I wonder if it just got sort of lost. Do you know what I mean? Lost, like in the whole
video. A lot of things got lost in this case.
I don't think it was lost, though. I think it just wasn't used.
Right.
That's what I mean. I don't mean lost. I just mean lost in terms of any importance that it would have in terms of what the prosecution or the defense. You know what I mean? When somebody says that was lost on him or lost on them, that's how I mean that.
Right.
I don't mean physically lost.
Right.
But so we would assume that these were available at the last trial too. Wouldn't the defense use this information if they were available or if they were aware of it?
Yeah, we would think so. But
I mean, even in the first trial, I didn't watch much of the first trial, so I don't know. I was listening to you guys yesterday. It sounded like you guys were saying that it wasn't brought up in the first trial. So to me, I mean, if you know, it's something that's beneficial to the defense. They didn't use it in the first trial. They hadn't used it up to this point. I mean, simple deduction means, you know, shows that it was either recently just discovered or looked into. Because if I was a defense team, I would have used that a long time ago.
Well, we have to do the unusual thing that happened here is that ARCA last time, and they're the ones that were testifying, in particular, Dr. Rensler. ARCA only had what the U.S. Attorney's Office gave them. Right. And so the Norfolk County DA's office had reached out with several letters to the U.S. Attorney's Office to say, hey, you know, if you want any evidence, we'll give you everything that we have. And the U.S. Attorney's Office didn't even reply to any of those letters. So it's very possible that I think it's likely that the ARCA guys just didn't have this material at that time. But now, since they are working not for the U.S. Attorney's Office, but working now for the defense, then the defense would have given them all this material.
Right.
So now why Dr. Sheridan or Dr. Russell didn't have access to this last year, that's a different question. Dr. Sheridan was the really old guy that was there, the doctor that they brought in to testify. That I forget exactly what he said, but more or less that his injuries were inconsistent with being struck by a vehicle, similar to their other experts. But he should have had those X-rays, I would think. When he first began practicing, X-rays hadn't been invented yet, so maybe he didn't know what to do with them. I don't know, but this guy
Yeah.
was very old.
Yeah, I just think that there's something to it. Also, the fact that the arm wasn't separated from the body when those X-rays were taken. It's not like they couldn't move the body. I mean, unless he was in some sort of form of rigor, but I doubt it. You know, why not position the arm in multiple angles so that you can get a full 360 view of it?
Yeah,
you know. So that tells me that these are probably just very basic X-rays of the entire body to see if there was anything that was noticeable from there.
right. Well, we might hear from Dr. Welcher this afternoon, right, Kate? Are we going to go right to rebuttal this afternoon? I got that sense from the judge yesterday, not specific about Welcher, but that the jury should be expected to be here today.
I was muted. So it's possible. It depends how long Rentschler takes, really.
Right.
I am searching right now through the court documents to find the X-ray stuff, whether it was even, talked about or not. I'm searching. Still don't see any reference, even though I've been through a lot of the medical stuff already.
Let me try AI. AI has been getting better at getting updated information. Let me give it a shot. I'm going to go to Grok first.
The problem with Grok is they say I'm 5'6". Ever since then, I just can't believe Grok anymore.
Well, I'll tell you.
I'm over 5'1", everyone. I'm almost 5'2". Let's call it 5'2" with shoes.
The other thing that I noticed with the X-rays is those weren't actual like X-ray photos. Those were like billboards that were printed on. I wonder how big those X-rays are, like the actual photo, because to me the images look blown up. Like I mentioned before, I think they zoomed in on the arm and then blew it up. Stretched it out so they can zoom in on it. Based on from the image that I could see from the camera, I wonder how big that X-ray, the real X-ray, is, the one that the doctor would be looking at, the one that is transparent, that's on a light. And to me, if those poster boards were blown up and printed out that way, I wouldn't be surprised if the defense purposely made them so huge.
From Grok, which is Elon Musk's and Twitter's version of ChatGPT or their AI. And keep in mind, these things aren't always accurate. In the Karen Reed trial, the X-rays of John O'Keefe's body were taken during the autopsy conducted by the medical examiner's office. Dr. Elizabeth Laposada, a forensic pathologist hired by the defense, testified that she reviewed these X-rays, which included images of O'Keefe's chest, arms, and legs. She confirmed that the X-rays showed no broken bones or fractures, specifically noting that the bones in O'Keefe's right hand and arm were intact. These X-rays were presented in court by the defense to support their argument that O'Keefe's injuries were not consistent with being struck by a vehicle, as alleged by the prosecution. The X-rays were part of the autopsy process, typically performed to identify fractures or foreign materials, and were accessed by Laposta for her analysis in the retrial. So according to this, if you can believe it, it's the autopsy. Does that ring true with what you guys remember?
No, I'm assuming it's for the autopsy. That's because I went back and listened to Dr. Rice's testimony, and I think that might be also why everybody's stuck on there were no X-rays, because we're conflating his testimony.
Right.
Yeah, I still can't find it.
I'm watching on the news the 6th day of riots in LA. Now, some troubling video came out last night that Fox News had picked up at the start of the riots, where a van was giving out very expensive riot gear to the rioters at the start of this, which it's not been identified who was passing that out. But, it's expensive gear. It was expensive masks and shields. So who was giving this out to the rioters at the start of this? And now they're supposedly planning on extending these riots to multiple cities across the country. just how organized this is and who's giving out that gear. I don't know. I'm not gonna give you a theory. I don't have a theory. I just think it's important to point this out. So.
When the riots first broke out, News Nation covered it so extensively. I know I was on for 5 hours on call and covering that. And it is unbelievable what happened and how it all started with literally, I don't know, it seemed like a dozen plus protesters, and then it quickly expanded to 100, and then it's just proliferated, and everybody's been involved. Gang members are looting, are vandalizing. You have Palestinians now, pro Hamas, all on board with their rhetoric. Nancy Liu, who was the reporter for News Nation out there, received somebody threatened to murder her with a rock because she was reporting. And then I personally saw the footage of her being absolutely harassed by another individual. It is unbelievable what's going on there. The 101 shut down for any of you from LA or spent extensive time in LA. It's unbelievable what's happening to our country. I just cannot believe we have completely abandoned law and order.
And when I always look at these kind of, or any kind of protest like this, I look at the kind of signs that the protesters have at the start of it. How elaborate are the signs? Because it takes some resources to be able to print up signs, and the signs that they had looked like they were pretty professionally done signs. So where did who had the resources to get this going and arm these guys with gear and well done signs? That didn't come from a bunch of poor people that were just illegal aliens. There's something more elaborate going on here. And again, I don't want to indicate what, because I don't know. And there's just something more interesting here. Somebody wants this to happen. And so it's more organized behind the scenes than we think. We just don't know who's behind that organization.
O'Keefe in the x-rays, I still can't find anything. But really, isn't it the point is the results? We've always known that there were no broken bones. I think for me, though, I've always wondered, were there any fractures? You know what I mean? Were there any of those minor hairline fractures or fractures?
And do those x-rays tell us? Because they seem like very superficial, like Dan said, just take the long, you slide the body through. There's no close-ups from different angles. It's certainly not an MRI. So like if you have, if you've fallen or like if you have, elderly parents and they've fallen and they want to find out if there's a hairline fracture, they give you an MRI. You don't go through just a simple x-ray. So you need a more elaborate x-ray to pick up. And I just want to respond. We weren't discussing politics from any particular side. This was not done from any particular side. That's why I made a point of I'm not going to analyze this. I'm just saying this is more organized, but I'm not saying who's organized it. Or, I have no idea. So there's nothing political about what I just said there.
Yeah, I've always said riots should never be thought of as political. That's how I think of them. It's like law and order should be from both sides of the aisle, but I'm not a political person. Anybody who follows me sees that. I'm just trying to say it's terrible what's happening in our country, and people just trying to go to work, people trying to get their kids to school, trying to go to the market. They can't do it. And right. Remember Reginald Denny, people forget in 1992, because they're youngsters and I'm old, those riots were horrible. And I'll never forget Reginald Denny just in his car being pulled out and, beaten. And so I was trying to message on my platform, listen, for those of you who are innocent, who are just in that city, please shut your doors, don't get out, lock, because they will drag you out and beat you.
And I just, even the only thing I would even say politically is I really have not been happy with the way either party or either the last two presidencies or any recent presidency has handled things like immigration and the border, so that's all I'm saying. So I'm not on either side. I don't really, I'm pretty critical of both of them, but I'm just always curious so certainly what is going on there? I don't know. We do have a Republican in the White House, and the Republican that runs the FBI and these agencies, but who is handing out this expensive gear to rioters? I have no idea, and I wouldn't want to begin to. I don't want to speculate either because I just don't know.
Republican or Democrat don't matter. They just want your money. That's my opinion when it comes to politics. They all just want your money.
I truly cannot find, I've gone through a lot of the documents regarding Scorti Bello. I haven't gone through the testimony from this trial on this, but I don't think it was discussed other than Welcher. And I posted about that. So, we'll just have to see what he says on rebuttal, but I hope this is cleaned up. The other thing I thought that was very dramatic and wrong, and even the judge said those posters are not going back with the jury. They can have the PowerPoint or the smaller photos, but they're not going to get those big blown up. Wasn't that just so demonstrative, over the top, pointing out above everything else these x-rays, even though the results have always been known, apparently, that he didn't have any bones broken.
To me, being over the top has been part of their tactics. I mean, have you seen the mistrial motions that they've had, and Alessi just screaming out the top of his lungs, like the jury, like him hoping the jury can hear him through the walls or something? Yeah. Over the top has been their MO throughout this entire trial, in my opinion. And I think it pulls to the strings of some, when, like I said, I have some FKR, Free Karen Reed supporters in my Discord, and after opening statements, they started talking about, oh, look at the flash and how well and interesting that Alan Jackson was versus Hank Brennan. And I was just like, look, I'm not swayed by what people say. I'm swayed by the evidence. I look at the evidence. That's all I've ever done, and so, I have a saying, don't pee on my shoes and tell me it's raining. And that's kind of how I feel when it comes to somebody trying to convince me on certain things, especially when I can see them with my own two eyes. Right. I'm just like, I don't need to listen to like that. But for some folks, it's very persuading. And that's troublesome to me a little bit.
Somebody was accusing me in an email of trusting the police too much. And I'm like, why do you say that? I don't give anybody the benefit of the doubt on any side. I don't, when I'm looking at something like this. And so he replied by saying, well, you trust the data that they, like the vehicle data and stuff like that. I said, because it would have been pretty much impossible for the police. Do you really think that they could have gone out and rigged data? That's just not reasonable to me. And so it has nothing to do with trusting the police, but especially when you look at the correlation between the vehicle data, which was from the Toyota tech stream, which Trooper Paul had to learn about, didn't know about it before this trial. And certainly Michael Proctor didn't know anything about tech stream data or any other kind of data. But even if they had an expert in tech stream data working for them that in theory could somehow write up those data reports, it's an extraction that both sides get. And it's the correlation between that and John's phone data that even a CIA analyst couldn't have made this up. So there's no way that anybody could have invented this. This is the thing. So it has nothing to do with trusting the police. It has to do with nobody could have been smart enough or clever enough or highly trained enough to have somehow forged that very technical tech screen data.
How did you guys think that La Posada's testimony hit? And I know you probably talked about this. I watched every second of the trial, but I fast forwarded through some of the commentary just because there was so much to get through, and I was completely tied up yesterday.
I think it did some damage, but here's the thing. You have, clearly she's competent. I mean, she was the chief medical examiner for the state of Rhode Island for several years. She's done a lot of autopsies. She knows her stuff. The issue was not to her ability. The issue was to her credibility. And I don't know what the jury's going to absorb, but she gave the prosecution a gift So Hank Brennan did what normally they do, and he said, "Good afternoon, doctor." And she said, "Well, it's not afternoon for another 6 minutes." So she was combative, even at him saying "Good afternoon," which was unbelievable. I mean, so what does that tell the jury? That this woman is going to be combative right out of the gates here, no matter what. And she seemed to resist him on everything, and to the point of being obnoxious. And I think a jury would look at this and say, "This is a very hostile witness for some reason." So so she came across as someone who was all in for the defense for some reason. So how does a jury process that? It's hard to say.
I thought she was great for the Commonwealth. The fact that she was so defensive, as you mentioned, to me, I mentioned it to my Discord. I was like, this lady is anticipating what are the questions are going to be asked. She's not thinking about what is actually being asked. She's going to get tripped up. And there was many times where Hank was talking about the blow to the back of the head, and I don't think she was realizing that she was basically siding with the Commonwealth as far as the, it being a fallback type of situation. She mentioned that the raccoon eyes was from that, not from being punched, although Alan Jackson got her to say that the cut to his eyelid could have been from a punch, but she mentioned that the black eye wasn't, that was from the brain bouncing back and forth. She mentioned that he would have died, within 20 minutes or so of being struck that way. What does that do to the theory of the defense? When do they think he was put outside? Because there's some pretty compelling evidence from a battery, the temperature, and also Apple healthcare data and things of that nature that never put him inside of the house. So, from what I understand, based on the supporters of Karen Reed, they try to put this incident happening around 12:24, earlier, not later on, not like at 3 or 4 in the morning. So what are they trying to say here as far as, okay, he didn't die of hypothermia, he died fairly quickly. When do they think he put him outside?
So Laura, who's been very helpful with us, including going back to the last trial, which I think she's from Indiana, if I remember right, but her son is 6'2", and she's the one that first gave us an image of her son standing next to that model Lexus and how the hand matched up perfectly to where the dent was. So she has sent me a video clip from Dr. Rice, the ER doctor. Unfortunately, this clip is 40 minutes long, so I can't play the whole clip, Laura. It's his whole testimony. So if you want to tell us where in the testimony this was, but he apparently says that there were no x-rays. That's at the ER. And then she follows it up with a second email, which I'm not sure what this is. I'm not sure. It says, based on the sources and our conversation history. I don't know what this is I'm reading here. This is the problem with this. Based on our sources, on the sources and our conversation history. Does this mean you had a conversation, Laura, with Dr. Rice? I don't know what that means. So according to the testimony of Dr. Justin Rice, who was involved in the treatment of Mr. O'Keefe at Good Samaritan in the morning of X-rays or a full skeletal survey were not performed. Dr. Rice explained that when a patient like Mr. O'Keefe presented in cardiac arrest and unresponsive, the primary focus of the medical team was on the core resuscitative medicine. This involves critical actions such as securing an airway, ensuring a breathing tube is in place, and correctly applying CPR. In such critical cases, because of the mind can only focus on so much, there is less focus on the injuries. So it sounds like this is his testimony, but I don't really understand what it starts out. She starts out saying based on the sources and our conversation history. So I'm not really sure what that means. So I'm not sure. Again, I'm not sure what I'm reading. Am I reading testimony? Am I reading somebody's conversation? I'm not sure, Laura. But it sounds like part of this does read like the testimony. It does ring as familiar to me. So these X-rays, I guess, were taken in the autopsy. So
that makes much more sense to me. I mean, they are saying exactly what I said. There's so much you're dealing with at that point that I would be surprised, but they don't take that long. But nevertheless, I would be surprised.
Right.
Hey, I wanted to go over, I did a top 10 list of why La Posada is incredible. And just get that today. Oh, are we starting?
Looks like we are.
Good morning.
Hello, everyone.
All right.
So Margaret is here. Boomer. I'm not sure if Alan's welcome. And, Boomer, good to see you. Margaret, you did great last night on TV, both on campus potential and on committee.
Thank you.
All right.
All persons have any business before the Honorable Beverly Kernodle, Justice of the Norfolk Superior Court of the County.
Give me the sidebar.
Draw near, give your attendance, you shall be heard.
You're right. Boomer. Was that Boomer?
You may be seated.
Oh, I was so tempted to go up with Dan's picture and start
Right.
calling
Good
him
morning,
Boomer. I was so
council.
tempted.
Good morning, Ms. Reed. Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their heads. Thank you. Can we have Dr. Rentschler again, please?
All right, Dr. Renzel is right in, so we get to meet. No sign.
Dr. Armand, you're still under oath.
Yes.
Thank you.
Good morning.
Good morning, Your Honor.
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Rentschler, good morning.
Good morning.
Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
Thank you. That'll be KK for ID.
Let me know whenever you, pardon me, let me know whenever you're ready, Dr. Rentschler.
Sure, you want me to bring up the PowerPoint? Or?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here. There we go.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay. Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike that answer. Ask the question again.
Sure. Did you seek to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing?
Sustained.
Ultimately, were you in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation?
So I'm going to see you both at sidebar for just a minute, please.
I walked away for a second, guys. Are we in sidebar again?
Yes, and I never have seen a trial with so many sidebars. In fact, I've never seen a trial with 1/8 as many sidebars.
Yeah, it's incredible.
Yeah, it seems like it, huh?
I went to get a flashlight to see if this headset is any way adjustable. People are saying that my mic is not. I don't know. I don't think there's any way for me to adjust it on these microphones, so I'm sorry.
Gee, there's not that many reporters in court today. I wish I could get in court. It's not fair. There's Sue O'Connell.
That's not Rachel Maddow?
Oh,
Sure.
I don't know. It looks like
That's
Sue.
Rex, Christina Rex on the left.
Sue looks a little bit like Rachel Maddow, I think, from a distance.
A little bit, I think. Yeah.
That's Sue, isn't it?
Yeah, Sue
It
O'Connell.
is.
Yeah, that's Sue.
Rachel Maddow is probably in Los Angeles for the riots. So.
Yes, probably.
Hey, it's good to note that Paul's here, although he's in a suit. Remember, he's facing the blogger subpoena
Oh, yeah.
quashed, and that's today. So he's in a suit, and he's never in a suit.
Yes, you're right. So
He's
he's
on call for
have
sure.
to leave to do that.
I think that's Christina Rex just to the left of Sue.
Yeah.
Seeing her hair. Somebody was saying it's not her, but that's who I think it is. And I've liked her reporting. I really
Yeah, me too. Yeah.
I knew her long before this case. Is that her though? Now she looked up. I can't tell. My pictures, I guess, is too fuzzy, but it looks like her. Mr. O'Keefe is not well. It's very difficult. You know, for those of you who may not have sat on these benches in this gallery, they are so hard. In fact, in the Delphi trial, they had special cushions that actually the victim's family brought to people to sit on. It's just really, really difficult to sit in those conditions for 8 hours a day.
Oh, yeah.
May I?
Yes.
Did you undertake to review analysis and testing that was done by Aperture as reflected in the PowerPoint that you reviewed, as well as the report that you received?
I did, yes.
Did ARCA, yourself included, undertake testing based on your review of the testing by Aperture?
We did, yes, sir.
Okay. Tell me, what was the biomechanical analysis? That's the second point on your PowerPoint. What was the biomechanical analysis that was undertaken after you reviewed the Aperture reports and Aperture testing? What did you undertake to do?
So I touched on this yesterday a little bit. A biomechanical analysis, there's certain steps that you have to do to actually perform a biomechanical analysis. First of all, you have to determine what the injuries are. What are the diagnosed injuries? Second, you have to determine what happened to the individual. So in this case, what would have happened to Mr. O'Keefe? His kinematics, how would his body move? Was it contacted by anything? Was it contacted by the Lexus? If so, what forces were produced on the arm, on his body? Were they sufficient to cause the injuries that he sustained? And in this case, it's a little more involved. We have, was he hit by the car? What happened after that? Did he somehow move into the yard? And then did something happen in the yard to actually cause the skull fracture? So in order to determine if that's what actually occurred in this case, you have to look at each of those three separate events. And you have to evaluate that from a biomechanical analysis by looking at the force, looking at the kinematics, looking at a human tolerance, and determining or attempting to determine what happened. Now, if you try to determine what happened, not only do you have to prove that that was the case and the facts support that that's what occurred, you also have to eliminate all other possibilities. Because if you're saying this is how it happened, not only do you have to show that that's true.
So next question, and I'm going to strike that. Next question.
Is there an element of differential diagnosis that goes into biomechanical analysis?
There is, absolutely.
Explain that for us, please.
Let me demonstrate. So there are several peer-reviewed articles that I reference.
Is this slide number 2, by the way?
This is slide number 2.
Thank
correct. This is injury reconstruction, biomechanical analysis of accidental injury. And that sets forth the methodology that I just described. It's well written about, well reviewed in peer-reviewed articles. This is the method you need. If you're going to opine on biomechanics, this is the method you need to do, the steps you need to go through in order to provide an actual opinion.
And describe that method just a little bit further. Does that include testing?
That includes testing.
Does that include both lab testing and field testing if it's possible?
Absolutely, yes.
Explain that.
In fact, let me explain. Let me get through here. You know, I just had a couple examples here. This third slide, another reference about biomechanical analysis. Again, it's all throughout the literature, very well established how to do this. Now, it's all based on the scientific method, okay? And the scientific method, which you know, it was really established back in the 1620s, but this tells you how to do a proper scientific analysis. So you have an observation, you observe something. So in this case, you might say, all right, there's superficial abrasions to Mr. Keefe's arm, and there's a shattered taillight. Are those two things related? Well, the first thing you do is you research the topic area. You look through the literature, you find or look for any examples of that happening. You see if there's any reports or peer-reviewed articles written about this very occurrence. Can you actually demonstrate that if your arm hit the taillight would shatter and cause those abrasions? If this occurs or is a common occurrence, it should be in the literature. You should be able to find information about it. Then you form a hypothesis. Either you say, I think this injury is related to hitting the taillight, or it's not. Whichever one you choose, that's where you then start to go into your experimentation. You have to develop tests to get data to actually back up your hypotheses. So if I said, well, I think the injury is related to it, what would you do? You would go and you would test it. You would get an arm. In this case, we got a hybrid 3 dummy arm, and we got an exemplar vehicle, and we hit the vehicle with the arm. Or we hit the arm with the vehicle, we ran into it, to determine what's going to happen when that occurs. Do we get the right circumstances, the right loading to actually occur in that case? So this, and then you go back and you analyze that. And if your results don't match up with your hypothesis, you have to reevaluate. You have to go back and see if we don't get that type of injury, if we don't get the kinematics or the force associated with what we see, you have to reevaluate if your hypothesis or what you think happened is actually true or not. So you have to continuously go through this process. And that's what experts do. That's how you perform an analysis. And that's what's important. You know, I have 3 kids. I have a 9-year-old who's actually.
So I'm going to ask you to wait for the next question.
Okay, sure.
Was there an example that you could use of sort of a real-world example that you might want to use to explain some or part of the scientific method?
There is, yeah. And I would like to explain an example of what's important with that. So I was going to say I have 3 kids, a 9-year-old who's actually turning 10 today. Happy birthday, Kai. And I have 2 older ones.
All right. We're going to stop this. Another example.
Go ahead. Less editorializing.
Minus all the personal.
I'm sorry, Your Honors.
Go ahead.
Details matter, okay? details in an investigation matter, and details matter here. You need details. You have to explain how things happen. Okay? You, as an expert, I can't come in and just say,
Sustained. It needs to be more question and answer.
Why do details matter?
because your opinions have to be based on the facts and the evidence.
Why is that?
Because that's what determines your conclusions. I can't come in and say, I think.
Next question.
What if you don't have all the details and facts?
If you don't have details, if you haven't performed a proper analysis, then you can't come to a conclusion that something happened. You can't depend just on your experience. You have to have the analysis, the evidence, and the details to come to a conclusion in a case.
How do you best get details to come to a conclusion in a case?
You need research. You need peer-reviewed articles. You need evidence. You perform testing. You have to demonstrate what you think happened is A, possible, and B, actually did occur. And in order to do that, you need hard evidence to demonstrate that that's what actually occurred in this case.
Do you get that through both lab testing and field testing?
The form. Ask it differently, Mr. Jackson.
Can you get that in lab testing?
Absolutely.
Can you get that in field testing?
You can get that in field testing as well, yes.
Are those integral to an analysis?
They are. If you don't have any other evidence, if you don't have research, if you don't have peer-reviewed articles showing or demonstrating what happens, you have to formulate, you have to get that evidence. And the way to do that is through field testing, if you have no other evidence and no other source of information to provide that type of evidence.
Let's go to the next slide. Did you undertake, and this is a placeholder, did
Yes.
you undertake the scientific method in this case?
I did, yes.
What was the hypothesis of the incident that you utilized in furthering your analysis?
So the first step, the first part of this event is contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from, these two slides?
These two slides are from the PowerPoint presentation that Aperture provided.
All right, so you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be at about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type and brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis, the fact that the individual, the surrogate, as you used the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter, so we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what may or may not have occurred. Mr. O'Keefe was wearing this sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to with what happened on the vehicle.
Is that part of a normal biomechanical analysis to evaluate clothing of the body as well?
Absolutely, especially when you look at automobile pedestrian impacts.
Why?
Because the clothing tells you or can tell you how the impact occurred, where contact occurred between an individual and the vehicle, what part of the vehicle, what part of the individual. So it either may or it may not, but it can give you very important clues about what may have occurred during the incident.
Is that part of the normal methodology that's utilized in the field of biomechanical analysis, especially as it relates to pedestrian motor vehicle incidents?
It absolutely is, yes. Look at the damage to the clothing. Look if you compare it up to the vehicle, to the ground, to other sources. It's another tool, another detail, and part of the evidence that allows you to try and determine what occurred.
Do you have experience in reviewing clothing of individuals that may have been involved in vehicle pedestrian incidents?
I do, yes.
How often has that played a part in your biomechanical analysis and the methodology that you employ?
It happens quite often when we look at automobile pedestrian impacts. That's really one of the steps that you need to do. You need to look at the clothing, you need to look at that evidence and see if that matches up with any other evidence in the case.
Would it be a proper methodology to just ignore the clothing in a vehicle pedestrian incident?
It would be, yes. I mean, it's really one of the first things you should do.
I'm sorry, my question was, would it be proper if you just wholly ignored it?
No, it would be improper. It would not be proper. It would be improper if you just ignored it.
Getting back to the slide at hand, and we're on slide, just to stay coordinated, is this slide 7?
That is correct, yes.
Okay. You've talked about the left photograph. What is the right, the short video?
So this short video is what I refer to as the paint transfer test that was performed by Aperture. And what they did was take a surrogate the same approximate height and weight as Mr. O'Keefe and had him stand behind a subject, an exemplar Lexus, the same year, make, and model. And they put paint on the rear taillight cover on the fender, and then they backed it in to the surrogate's arm. And the reason for this is they attempted to show that where the paint contacts the arm, that it's the same area where the superficial abrasions were on Mr. O'Keefe's arm.
Did you utilize these photographs and videos from the Aperture report in conducting and building the field testing and or the lab testing that you ultimately undertook?
I did, yes, sir.
Can we go to the next slide, please? What's depicted in this slide?
So this is from the Aperture report, and the third conclusion is that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and the orientation of the right taillight on the Reed 2021 Lexus LX570.
How did you interpret the phrase geometry?
To me, geometry just means shape. So the way I interpreted this is the one test that was performed with respect to the taillight. This is the only test I saw that Aperture performed involving the taillight and the arm, is that with this paint transfer test, they concluded that, again, the area where the paint was transferred onto the arm is consistent, the same shape and orientation as apparently the lacerations found on Mr. O'Keefe's forearm.
Did this test, in your opinion, establish force multipliers that were exerted on the taillight?
It has nothing to do with force. It doesn't describe the force exerted on the taillight or on the arm. It doesn't describe how the arm would have moved as it hit the taillight. It doesn't describe how the taillight would fracture. It doesn't describe how you would actually get the lacerations on the arm. Again, all this does is generally, and I made an error there. This report, and you can see the slide says laceration. Mr. O'Keefe did not have lacerations on his arm.
What did he have?
He was diagnosed with superficial abrasions.
Is there a difference between a laceration and an abrasion?
There's a distinct difference, both biomechanically and medically, yes.
Is that an important distinction?
That is.
Why?
The first step of the biomechanical analysis is identify the injuries, and you have to take the diagnosed injuries identified by a medical doctor. So it's superficial abrasions. To put lacerations on, that's simply incorrect.
So I strike the end of that.
Would you describe the injuries on Mr. O'Keefe's arm as lacerations?
No.
Would they be more properly described in another way?
It would be, yes.
What's that other way?
So they've been diagnosed as superficial abrasions. An abrasion occurs when there's rubbing or scraping of the skin, and it just rubs away the top layer, the epidermis of the skin. Now, a laceration is a jagged ripping or tearing of the skin, which gets down through the epidermis into the dermis. So abrasions take much less force, they're less severe than what a laceration actually is.
In a biomechanical analysis, if it's done properly, is it important to get the proper injury to the body as a foundation to the entire analysis?
That's core to the analysis because you're trying to determine how an injury occurred. You have to know what that injury is. You have to have the correct injury to be able to evaluate it.
Let's go to the next slide. Bless you. This is a placeholder. I want to ask you a little bit while this is up. We can turn the lights up. First step of the analysis. What is the first step of the analysis after you determine the injuries, the type of injury?
So in this step, after you determine the injury, what we want to do is we want to look at the physical evidence. So we have the abrasions on Mr. O'Keefe's arm, and we have the sweatshirt that he was wearing at the time. So the first step in any investigation is to determine, does the evidence from the arm match up to the evidence on the sweatshirt?
Did you undertake that analysis?
I did, yes.
Is that indicated in a slide a little bit later on in your PowerPoint?
It is, yes, sir.
Okay. Let's go to the next slide, please. What are we looking at in this slide?
So this explains the injuries. And this is from on the left side, that is the diagnoses from the autopsy. The right side is from the hospital. And you can see it says blunt impact injuries of head and extremities, abrasions and lacerations. The laceration is on the back of the skull, on the back of the head where the occipital skull fracture is. When you look at the extremities, everywhere where it talks about the extremities, it's superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken. Are
autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are. They are the sources you go to determine what the injuries are. Yes.
Did you see? You reviewed the entirety of the medical records as well as the entirety of the medical examiner's file, is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of three exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record, medical records or in these records?
It was a series of the x-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in apple. Do you see, have you looked at x-rays before?
I have, yes.
Have you interpreted x-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at x-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at x-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore x-rays, if they existed?
No, if x-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them.
Do you see any injuries represented or any defects represented in this x-ray of Mr. O'Keefe's right hand?
I do not, no, sir.
Can you describe what you do see or what you would expect to see if there were injuries, broken bones, torn ligaments, things of that nature, swelling? What would you expect to see?
You could actually see the fracture lines on the bones. They are evident along the hands or along the ulna and the radius. Any dislocations you see, there would be a difference in the space at the joints between the bones. Dislocation, then there would be increased space or even a decreased space if there's compression of the joints, the interphalangeal joints, the metacarpophalangeal joints, the wrist joint. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B as in Bravo with the court's permission?
Yes.
Do you see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the two bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not. And when you're viewing this on the software to look at the x-rays, you can actually adjust the contrast. So you can adjust the brightness and the darkness, and it allows you to go through the whole range to better evaluate whether there are any fractures. This is a little bright, so when you're looking at this, you would actually decrease the contrast a little bit.
In terms of your review of this particular photograph, what did you note in terms of trauma or injuries at all?
I did not note any indication or any signs of trauma or injury to the forearm or to the wrist in this case.
If we could go to 229C as in Charlie. What are we looking at in this photograph?
This is the right humerus, the right upper bone of Mr. O'Keefe's right arm.
Do you notice, or did you note, did you review this in furtherance of your analysis?
I did, yes, sir.
Did you note any defects, trauma, injuries at all with regard to the bone is the
humerus.
The humerus?
I did not, no, sir.
What about the joints associated with the humerus, top or bottom?
I did not note any injuries or damage to either the elbow or the shoulder joint either.
What is your opinion and conclusion, having reviewed all three of these x-rays, with regard to the condition of Mr. O'Keefe's right arm, starting from the arm, the forearm, and the bones in the hand?
There's no indication of any type of acute injury from the x-ray to Mr. O'Keefe's right arm, either his hand, his forearm, or his upper arm.
Thank you. We can switch that back. And if we can go back to your PowerPoint. Can we go to the next slide, please?
Maybe. Let me see if I can start back on it here. Okay, there we go.
What are we looking at in this slide?
So again, this is the hoodie or sweatshirt that Mr. O'Keefe had on at the time of this alleged incident.
Did you consider these photographs in conducting your injury causation analysis?
I did, yes, sir.
What role did these photographs of Mr. O'Keefe's hoodie play in your injury causation analysis?
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide, please? What are we looking at in these series of photos?
So let's come to sidebar for a minute and Mr. Jackson, bring your PowerPoint, please.
I'll just let you guys talk since my mic is low.
You know, again, the same question I have about the x-rays is like the hand itself looks curled up. I'm not sure if that's the appropriate way to take an x-ray to see if there's any fractures or things of that nature. And there's only one position of the hand. It's not positioned in multiple ways. I'm just curious about these x-rays and if these are the ones you would want to rely on to determine if there was a hairline fracture.
You know, I'm no x-ray, you know, I've never done that for a living, but having had so many x-rays and watching x-rays done as an EMT, do you know how they line you up where they put you in a very specific arrangement to take an x-ray to make sure exactly what Boomer is talking about? And take it from 4 different angles. Typically, if it's your arm, it's from the side, both sides, on top, on bottom. I just think this will not necessarily show hairline fractures and a full presentation of what could be harmed on him. That's just a reflection I had.
Yeah, me too. It's just weird, you know what I'm saying? It seems like that the object of getting the x-rays weren't necessarily to try to find hairline fractures, you know, for whatever reason. It's odd. But one of the things that I did notice is that he mentioned that the injuries to his arms were abrasions, not lacerations, not punctures, which kind of goes against what their own witness said the other day or yesterday.
So I think we would expect that if you actually had an MRI, you would probably find small hairline fractures in the elbow and possibly in the hand, definitely in the elbow from breaking that taillight. Would you guys agree with that?
I would agree with that.
I think it's possible. You know, at the end of the day, that's not what killed him. What killed him was the blow to the head, which I think even the defense's doctor stated that could not have happened from like a bar or a pipe or any of those things. And so it's very interesting.
How would it compare to
I'm sorry.
Jen, how would it compare to a punch?
Well, you mean a punch in the arm?
No, how would the hand, like what kind of fractures would you get in the hand?
Oh, well, it depends, right? It depends on where you landed. Did you land to the squishy side of somebody, or did you land on hard bone?
Right.
So certainly those types of, you know, hairline type fractures are possible, and bruising and swelling. You don't see any of that. And I always thought it was interesting. They tried to use where the IV needle was put in his hand to say he was bruised, which was absolutely a fabrication of what happened. And have you all seen the picture of John O'Keefe's tricep area? Huge, with a gigantic hematoma underneath it prior to that dissipating under the skin and turning into a bruise. that we see in a lot of the photos. I mean, there's a huge hematoma, and I really hope Hank shows that photo. It's an autopsy photo. I'm going to show it on my Twitter. Maybe I can bring it up here. It's unbelievable, this gigantic bruise that John suffered.
Yeah, I'd like to see it. I think I've seen it, but
I know FKR folks say that it is blood settling, that's what that bruise is. But I believe during, I want to say it was Buchanan, his testimony, Alan Jackson may have asked him at some point if that bruising underneath the arm was from the blood settling, and he said it wasn't. But I know that FKR lean on that. That's what that was.
And I sort of tag on to what you were saying there, Kevin. I didn't. There's no boxer's fracture, right? So there's no damage to the pinky finger. That's usually what gets busted up if you throw an improper punch, right? It's your ring knuckle and your pinky knuckle, and the boxer's fracture's below your pinky knuckle, your main on the back of your hand. So
I wanted to mention too, some people are bringing up lividity and rigor and all of that is some of the bruising and other things. And it is true that after the body is deceased and dies, it's amazing how it becomes all bruised. It's really something to see. But what I'm talking about, this is an actual hematoma that's very unique to just one part of John O'Keefe's body. This is not, in my opinion, and again, I'm not a medical expert. I'm not a pathologist. I do not understand why they're not showing this one. It's so in a very particular area, and I don't think that's a lividity situation.
What'd y'all think about the birthday wish?
oh,
Shout out.
so unprofessional and not like an expert.
I think
I
they
can't believe
rehearsed that. I really do. I'll tell you why I think I rehearsed that, because he dove right into it, and then there was no context to what he was even talking about. But when it was objected to and stopped, Jackson immediately came right back in and asked a question that elicited it yet again. So I think they planned that. Like, that's the thing, is these witnesses are not, they're not preparing properly. They're scripting, they're going over questions and answers and tailoring the answers to, advocate for Karen Reed's interests here. And I think that was a glaring example of, they planned that. And they probably planned that to try to make him more likable to the jury.
It's possible. Or else the guy just knows he's on TV and wanted to wish his son a happy birthday on TV. Daddy, I see you on TV, that type of thing.
I get that, but then why did Jackson immeciately know what questions to go back to elicit that yet again?
Yeah, it's possible. I don't know. It just seems so unprofessional in this context.
To me, it just seems like these, some of these witnesses on the defense team don't know where they're at. They think this is a TV show. This think is a movie of some sort. And I think it's going to end up biting them in the rear. I think they're overconfident. I think they're going into it, like you said, Kate. I think they've rehearsed some of the things that they're going to say. And I think they're going to get caught off guard with some of the questions that Hank brings with them. I think that's what we saw with Wolf, especially when he brought up Wolf's wife and her being an FKR supporter. I mean, the shock on his face and, his demeanor changed after that. Like, holy crap, what else does he know? I haven't been prepared for this aspect of it. I don't think he was ready for that type of questioning. When it comes to this witness, he seems pretty cocky to me. And, he's talking a lot, and they're getting him to open up. And I'm excited to see what Hank is going to do to him on the cross.
Me too.
I could not believe he said that or even brought his son into the conversation in any way, shape, or form, even as trying to make a point regarding his evaluation. Just so, some of the things that they have done, ARCA, so unprofessional. And I'm sorry to be so harsh on them, but it's jaw-dropping.
Did we go into morning break or something? Why are they focused on the ceiling fan?
I don't, because the sidebar is taking forever. You know, this is
Usually
crazy.
Yet again.
They usually only
They're hoping it lulls us.
but they usually only go to the hearing exam when there's an issue with the juror.
Maybe it's possible. It is. It does. You know, trying to think why do you think they went to sidebar? I can't remember. I was listening, but
She
just- it
called them to
seems-
sidebar because there were a lot of agreements about this PowerPoint and what they
Mhm.
bring up to Rentschler. And I think she called it trying to make sure. I think she's seeing AJ sort of step out of that agreement. That's how I took
That's
it.
possible, but it seems awful long.
Well, if
Maybe they're
Alessi's
going through that again, I don't know. No, that poor jury. I'm surprised. Oh, here we are.
is his tie pink?
Thank you. Who's Ty? Tori. Ow.
One moment.
Okay.
The other feed I had is still showing the ceiling fan. So I switched
Oh,
over.
really? Okay.
I switched over.
Hank objected, but she called for the sidebar, I thought.
Dr. Rentschler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this? That's
Number
on-
12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please? Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions
I
regarding
did.
this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
Can I switch through real quick?
Sure.
Yep. So we 18.
Let's go to 18. What are we looking at in slide 18?
So this is Mr. O'Keefe's right arm at autopsy, and they're holding up a ruler to demonstrate the size and dimensions of the abrasions.
And what are the yellow indicators?
Those are indicators I added based on the length of the ruler to show the approximate size, length, and width of those abrasions.
Was it important in your biomechanical analysis to measure and denote all the injuries?
It was, yes.
Did you actually count the number of injuries on Mr. O'Keefe's arm?
I did, yes.
How many injuries did he have? How many distinct and separate injuries did Mr. O'Keefe's arm present?
Conservatively, I counted 36 different superficial abrasions on his right arm.
And did you go through all the photographs in an effort to count and distinguish one abrasion and one defect on his skin from another?
I did, yes, sir.
And you said conservatively 36 separate abrasions, correct?
That's correct.
What does that mean in terms of the mechanism that you would expect to cause that abrasion?
Well, you need 36 different points of contact with to get through the sweatshirt and get to the skin to actually cause abrasion to the skin. 36 different separate points of contact to the skin.
How many defects, remind us, how many defects were noted by the crime lab in Mr. O'Keefe's right sleeve?
9 defects.
Can you scroll to slide 22 quickly, please? What is this?
This is a slide, again, from Aperture, from their PowerPoint. It's the only slide, the only photo, the only indication of the hoodie that I found in their analysis. And it also has pictures showing, looks like they try to line up the top of that taillight cover
Sustained.
Do you see there's some sort of marking on that lower left photograph with some yellow lines?
I do, yes.
How did you analyze that marking?
I analyzed that. It goes through the part of the taillight cover and then goes through part of the upper arm of the surrogate.
And there's a parallel line to it a little bit in a V shape. There's a parallel line below it. How did you analyze that line?
I analyzed that as apparently showing that the area of the taillight.
So not apparently. What did you
How did you
analyze?
interpret that?
I interpreted that represents that area of the taillight corresponds to the area of the upper arm.
And there's a red dotted line around the tail light, correct?
Correct.
How did you interpret what that represents?
That was the part of the taillight that fractured.
Did you put any of these lines on there, or are these all from aperture?
These are all from aperture. I did not put any of those on there.
You see the small, it's horizontal, I'm sorry, it's vertical photograph of Mr. O'Keefe's arm?
I do, yes.
Did you note anywhere in the aperture report a denotation of the number of abrasions, counting the number of abrasions on Mr. O'Keefe's arm?
There's no denotation, no indication that the number of abrasions were ever counted. No, sir.
Ultimately, based on your review of and all of your testing, did you come to an opinion or a conclusion as to whether or not the abrasions on Mr. O'Keefe's arm are consistent with striking the right rear taillight of the Lexus?
I did, yes.
And what is that conclusion?
That they're inconsistent with striking the taillight or being produced as a result of contact with the taillight.
Why did you come to that conclusion?
There's a number of reasons that I came to. First of all, the abrasions, the numbers don't correspond to the number of holes or...
Sustained.
Did you consider, without counting the number of abrasions and the number of holes, did you consider the abrasions?
I did, yes.
Did you consider the sweatshirt?
I did.
Was that an important part of your analysis?
It was, yes.
What else did you consider?
I considered that it was not possible to line up 36 different abrasions with
So I'm going to strike that answer, ask it differently.
Your Honor, if he could finish his answer. He was about to say contact with the taillight.
Yep, so ask it differently, Mr. Jackson.
Sure. What did the 36 abrasions, conservatively, and their interaction with the taillight have to do with your ultimate opinion and conclusion?
Well, that you have to, if those abrasions came from contact with the taillight, you have to be able to correlate them and line them up with contact, 36 different contacts from the taillight.
And ultimately, based on your understanding of Aperture's review and the photographs that you saw, you were presuming, based on Aperture's testing, that Mr. O'Keefe was wearing that hoodie. Is that correct?
Sustained.
What was the condition? Let me ask it this way. There's a photograph in the Aperture report that we're looking at with blue paint on an arm, right?
Correct.
Is that your understanding, or did you test that Mr. O'Keefe could have been hit wearing short sleeves?
No.
What did you test? What was your presumption and assumption in your testing?
That he was wearing the hoodie that was found on him at the time.
With the 9 holes in the right sleeve?
With the 9 holes in the right sleeve.
Watch the form of the question, Mr. Jackson.
Sure. Let's go to the next slide, please. What is this?
These are the top 2 and the arm in this case, and the interaction between the two.
Did you note whether in all of Aperture's data that you reviewed, whether or not there was any measurements to determine whether the abrasions were consistent with contact with the Lexus?
I did. There were no measurements at all taken with respect to that test. No measurements with respect to where the contact happened on the car or on the arm itself. There was no indication of where that blue paint extended on the surrogate's arm, say from the wrist up to where the laceration or the abrasions would have occurred.
Is that important?
It's very important.
Why?
Because you can't say that the area where the blue paint is corresponds to the area of the abrasions if you don't take measurements. If you just eyeball it, all you can say is by eyeballing it, it looks approximately the same. But that's not scientific. You can't come to an actual conclusion that where that paint covers the arm is where those abrasions actually were. They could lie outside, they could lie forward, they could lie above that painted area. You can't say with any scientific certainty that that area of paint corresponds to where the abrasions are.
In this motion video and the still photograph to the left in slide 24, is that what we're on, 24?
We are, yes, sir.
What did you note with regard to the positioning of the surrogate's arm? I think that's Mr. Welcher. As it relates to the taillight and the back of the SUV.
Yes, the positioning of the arm in the photographs as well as the one test that was performed, the arm is approximately 90 degrees, level in line with the rear taillight of the vehicle.
Did you seek to do any testing approximating the positioning of the arm as you saw it, as you interpreted it in the Aperture data?
I did, yes, sir.
What were you seeking to determine when you did your testing?
Well, if we want to determine whether the orientation and the position of the abrasions on the arm correspond to the tail light, you have to have the arm in the position that you claim it struck the tail light and then look at the abrasions. Because if you're looking at orientation and the direction of the abrasions, you can't look at how they exist with the arm. The only pictures of the arm of the abrasions are with Mr. O'Keefe's arm extended. But that's not how he would have had it according to the test. It would have been at a 90-degree angle.
Dr. Rentschler, were there any peer-reviewed articles cited in connection with Aperture's paint transfer test?
I did not see, I was not provided a single peer-reviewed article with respect to the paint test or any indication of any test or article looking at arm contact with the vehicle or a taillight cover.
Can we go to slide 25? What are we looking at in this slide?
So in this slide, the picture on the far left is the photographs provided from the autopsy in hospital with Mr. O'Keefe's right arm fully extended. Again, those are the only photographs we have.
What about the photograph in the middle and to the far right?
In the middle and the far right, what I did was actually take that arm and then rotate the forearm to put it in a position that it would be in as demonstrated by the paint test with the arm at approximately 90 degrees.
What was the import of this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please? This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm and the tail light cover.
Can we go to the next slide, please? What is this slide showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past, if there were going to be abrasions from the fractured glass as it moves along.
Go to the next slide, please. What are we looking at in this slide?
So again, this is the paint transfer test, and it demonstrates there were no measurements taken, so we don't know the exact size or location of that paint or of the lacerations. And you can see the photograph on the right basically shows that after doing the test, a picture of the right arm was put next to it and basically eyeballed to say it's the same, well, it's only approximately the same area.
So I'm going to strike that. So next question.
Do you see any measurements, any tape measures, any laser measuring equipment, anything like that? That right photograph?
Nothing, no types of measurements whatsoever.
Can we go to the next slide, please? This is on the left, the same video that we've seen several times, correct?
That's correct.
What are we looking at on the photograph on the right?
So on the right, it is the video of this test taken from the side of the vehicle.
Did you notice anything of note in this angle of the paint transfer test?
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned against the tailgate. But whatever positions it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now if the car just backed straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see even at this point, as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow all of a sudden shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of paint on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that paint pattern.
Is that, in your view, proper scientific testing?
Sustained.
Let's move to the next slide, please. What is this?
And so this is that same event, and you can see I slowed it down even more just so you can see the actual movement of the elbow and the upper arm. arm to get that pattern.
Thank you. Can we move to the next slide, please? This is slide 30. And let's go to 31.
Yeah, this is 31.
I'm sorry, 31. What conclusions or opinions did you reach or could you reach after reviewing the totality of the results of the paint transfer test?
The paint transfer test, all it can show is the approximate of where the arm was covered in paint as the surrogate jammed his elbow in and rolled against the taillight cover. So it tells us nothing about what may have actually occurred, how the lacerations were actually, or the abrasions were produced. It doesn't talk about the kinematics of the arm to actually cause those abrasions. All it does is just say, under this specific condition, if someone was to stand there and then shoot your elbow forward and lean in, you would get paint on this part, this approximate part of the arm, because we don't even have any measurements for it. That's the only thing that test demonstrates, and that's the only test that was conducted to look at the interaction between the arm and the lexus in this case.
Did you reach any opinions and conclusions regarding whether the physical evidence is consistent or inconsistent with the injuries to Mr. O'Keefe's right arm?
I did, yes.
And what are what's the basis?
The basis is looking at the number of laceration or the number of abrasions on the arm, as well as the orientation and direction of those abrasions. And they don't correspond to how the arm would interact with the vehicle if it was at a right angle and struck by the rear of that vehicle.
Do you hold that opinion to a reasonable degree of scientific certainty, Doctor?
I do, yes, sir.
Can we move to the next slide, please? Actually, slide 33. If I may have just a moment, Your Honor.
Yes.
Did any of the testing that you saw in terms of the paint transfer test or any other testing that you saw included in the Aperture report and the Aperture PowerPoint presentation indicate that there was any consistency or any results that were consistent with Mr. O'Keefe's right arm being struck by the taillight, causing 36 plus abrasions to his right arm while wearing the shirt, or the sweatshirt, with 9 holes in it?
That's sustained. You have to ask that differently, Mr. Jackson.
Did you determine, based on the testing by Aperture, whether or not it was consistent, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible. Would that actually occur in a case like that? First, you have to show it's possible. I saw no peer-reviewed articles, no research data, and the only test that was done that links the injuries to the taillight cover is this paint test.
Is that the paint test in which the arm was leaned into the car?
In which the elbow was shot forward and then the arm and upper arm was leaned into and against the cover.
Doctor, did you also go on to further your injury causation analysis by performing impact tests to evaluate the kinematics involved.
I did, yes.
Can you describe that for us, please?
Sure. So one of the steps involved in the biomechanical analysis is the kinematics, the motion. So we need to look at the motion of the arm. If the arm hit the taillight cover, the taillight cover fractured, and you got abrasions, you need to be able to show that. You need to look at how the arm would actually move if it was struck by the vehicle. I've seen no peer-reviewed articles or research to demonstrate that. So what you need to do then is do testing to look at how the arm would actually move and whether it's possible to create those conditions to actually get that injury.
Did you use an ATD hybrid 3 arm for testing?
We did, yes. We used a 50th percentile male ATD hybrid 3 arm.
Is the use of that hybrid 3 arm accepted in your industry in terms of testing?
Yes, it certainly is. As I said yesterday, it's the gold standard for testing. And the arm itself is used just for that very purpose. In fact, there's a number of studies, they use the 50th percentile arm to look at airbag deployment. One of the issues with airbags for the driver is it comes out of the hub of the steering wheel. So if you're steering and you're turning your car and you hit something and the airbag goes off, what happens? It blows right into your forearm, and it can actually cause fractures. We see that quite often. So they perform testing with the 50th percentile arm to look at the forces and acceleration on the arm as airbags go off. Very similar to if your hand was hit by the back of the arm was hit by the back of the car and propelled forward. That's very similar to having an airbag deploy. Actually, this would probably be more severe. An airbag's almost like a giant pillow enveloping the arm, and here we have an SUV actually contacting the rear of your arm.
Can we go to the next slide, please?
Sure.
This is 35.
Let's see, here's 35.
There we go. Thank you. What's depicted here?
So this was testing done at 15 miles an hour. So this is with the hybrid arm and suspended so that it was actually impacting the right rear of the Lexus as the Lexus was traveling at 15 miles an hour.
Was there acceleration that was noted on the arm, force and acceleration?
There was on both the arm as well as the hand, yes.
What was the result of the damage to the taillight based on this test?
So in this test, there was actually no damage. As you can see, it catches kind of the hand and the forearm. And if you want to describe it as kind of a glancing blow, there was not enough force at 15 miles an hour on this glancing blow to actually fracture the taillight.
Is the position of this arm relative to the SUV consistent or inconsistent with the original spot that the surrogate in the paint test was standing as it related to the SUV?
It's consistent. We lined it up so it's consistent with that original location so that it would not impact the elbow or the upper arm. So at that position, if there's impact to the arm at 15 miles an hour, it doesn't cause the taillight to fracture. And it's also important to look at the kinematics. If you look at the acceleration data below, that hand and arm is accelerated. The hand's accelerated up to the speed of the vehicle in about 2 to 4 milliseconds.
How long does it take to blink your eye?
250 milliseconds. It takes a quarter of a second to blink your eye. So this occurs if your hand's hit at 15 miles an hour by a car, it's going to be accelerated up to the speed of the car about 50.
What does that mean just to us?
So 300 G's. If you look at weight, if you say the weight of the arm is 10 pounds, 300 G's means there's 3,000 pounds of force acting on that arm.
Is that enough to break a bone?
It's more than enough to break a bone.
Is that enough to to tear ligaments?
Absolutely, yes.
What about the bones in the hand? Are those stronger or the same resistance as the bones in the forearm? Or are they more delicate?
No, the bones in the hand are, as you can imagine, much weaker because they're much smaller. When you look at the carpal bones, the metacarpal bones, the metacarpal interphalangeal joint, which is basically your knuckles, they are much smaller and it takes much less force to fracture your hand bones compared to your ulna or your radius.
Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated in this, do the same physics? Let's go to the next slide, please. What are we looking at in this slide?
So this is a 24-mile-an-hour impact with the arm of the dummy contacting the rear, again, tail light. And it shows you the motion, the dummy suspended, shows you the motion of the dummy and, again, the force and acceleration. Now, that right video I put in because that's real-time video. We've been showing the low speed, but look on the right. This is the actual speed at 24 miles an hour. That's what it looks like if you have your hand out and it's struck by an SUV.
Is the arm accelerated in this, do the same physics apply? Is the arm accelerated up to the speed of the car in milliseconds?
It is, yes. It's all about weight, right? Because you have a 6,000-pound car and you have a 10-pound arm. It's whatever speed that car is going, your arm, your hand, whatever's sticking out there is immediately going to get accelerated up to the speed of that vehicle.
The video on the right is in real time. Like you said, it's sped up in milliseconds. Is that right?
That's correct.
Is the hybrid 3 that's used in this test, is that suspended from above?
The dummy in this test is suspended from above, yes, like a pendulum, barely touching the ground.
Is the dummy connected to the ground in any way?
No, it's just its feet are barely touching.
What would happen if there were forces applied to that dummy that went perpendicular to the travel of the vehicle? What would happen to the dummy?
The dummy would swing out like a pendulum in that direction.
Based on your review of the test that was done, the 24-mile-an-hour test, were there forces on that dummy that were perpendicular to the car to such that the dummy would swing out or be forced out or be propelled out away from the car?
No, there were no forces from the testing, and it's simple physics. Your center of mass of your body is basically at your umbilicus or your belly button. So in order to move the body, you have to apply a force at that part of the body. If your arm's struck, it's not going to move your body appreciably. All it's going to do, your arm's like a moment arm, it's going to spin you around. Could there be some motion forward or backward if you take a step? Possibly. But the center of mass of your body isn't going to move. You have to get struck by the vehicle to have the body actually move in a specific direction.
Can we go to the next slide, please? What is this showing?
So this is a slow-mo of the overhead from the real time. It was a GoPro that was recording that real-time video, and this is a slow motion of that video.
I'd like to ask you a couple of questions. As you see the vehicle contact the arm, what happens to the arm as it's being contacted in those milliseconds where it's being accelerated up to 24 miles an hour?
Well, the arm's accelerated up and pushed away from the body. So whatever part of your arm or body is contacting the car, that's going to be pushed forward away from the rest of your body. So not only is it loading the arm with an impact force as it strikes the arm and the hand, but then it's actually stressing the joints too. It's like ripping imagine having a car come and 3,000 pounds of force pulling your arm forward at the elbow, at the shoulder joint. It's putting a lot of force and pressure on that appendage.
What's the G-force for the 24-mile-an-hour impact?
G-force, let me see exactly.
Could you pause that video for a second?
Sure.
Because I want to ask you a couple of questions about it as well.
Let me see exactly what that G-force was.
Do you need to refer to something?
Yes, my report.
With the court's permission?
Yes.
Thank you.
So at 24 miles an hour for the arm, the acceleration is 302 Gs. And for the hand, it's about 435 Gs.
Does that translate to over 4,000 pounds of pressure?
Well, for the arm, it's close to 3,000 if you say a 10-pound weight, and for the hand, that can be anywhere from 800 to about 1,600 pounds of force acting just on the hand itself.
Understood. Can you back this up a couple of frames?
Sure.
Pause it where I ask you. One more frame back. One more back. Right there. What's happening physically to the arm, to the right arm at the point of impact?
So there is a force on the hand, on the forearm, where it contacts. Now, your arm just isn't going to hit and the force be distributed evenly across the entire part of the arm. That's not how your arm is actually articulated. Even if it was, again, that's similar to an airbag deployment, where at these levels you would get fractures. But if it hits the hand, now, if Mr. O'Keefe's holding a glass at the time of this impact, think about that. What happens is you're holding a glass. It exposes the knuckles. So if you're holding a glass and your arm's at a 90-degree angle and the car comes back and hits your hand, it's going to strike right on the knuckles. The force is going to be applied right at that joint. And then it's going to likely hit along the forearm back near the elbow.
What's the shape of that arm in this still photograph?
Well, it's somewhat of an abnormal shape because the arm should be level with the body. The forearm should be even with the shoulder. But you can see as it gets pushed forward, it's accelerating that forearm away from the arm and the rest of the body.
Does that abnormal shape suggest anything to you in terms of what you would expect regarding the bones in that arm?
Again, certainly there's thousands of pounds of forces acting on the arm and also on the joint itself, not just the arm or the bones we have to consider and how much force to fracture, but think of the elbow joint and think of the shoulder joint. It takes much less force to dislocate an elbow than it does to actually fracture it.
Did you see any evidence based on your review of the medical records, including your review of the x-rays, any evidence of any dislocation?
There was no evidence or indication or diagnosis of any dislocations or fractures to the arm at all.
Fractures or broken bones at all?
Correct, nothing.
Can we go forward another frame? And at this point, the arm has already been struck and accelerated, is that right?
That's correct.
Do you see the taillight material?
I do, yes.
Okay. It's basically now broken, is that correct?
That's correct. It has now been fractured, yes.
All right, let's go one more frame forward. And the taillight material, did you make note of that in this frame?
I did, yes.
What direction is that taillight material going relative to the vehicle?
It's going forward.
And where is the arm?
The arm has been pushed away. Now, you have to remember, as that arm, if it contacts and fractures the taillight, it's not exposed to the fractured pieces that still exist on the taillight itself, because those pieces that fracture haven't gone anywhere because they're against the arm itself. And then as the arm moves away, the pieces then move with the vehicle.
Are the taillight pieces upon fracture moving at the same speed as the arm upon contact?
That's correct, yes.
Is that a matter of physics?
That is a matter of physics, yes.
Is there any possible way for the broken pieces of taillight to out-accelerate the arm upon contact when the arm's being deflected away from the vehicle?
It is not. I don't believe it's physically possible. That was not demonstrated in our testing, and I've never seen that demonstrated in any peer-reviewed articles. Now, you can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. you can, average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, it shatter, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest, but you wouldn't find the fragments on him because they've already been pushed forward, come to rest before he even has a chance to get to where they find him.
Let's go to the next slide, please. What is this slide showing?
So this is just frames taken from that actual video showing the interaction from the top left, then you go down to the bottom left, and then the top right and the bottom right just shows you the progression of the contact and the movement of the arm.
Is the bottom left frame the same frame that you stalled on just a second ago at my request, showing the deformation of his right arm?
That's correct, yes.
Thank you. Next slide, please. And is that just a close-up of the same?
That's just a close-up of the same, yes.
Okay, next slide. And is that a final close-up of the arm after it's been deflected out of the way?
That's correct, yes, sir.
Does this also illustrate what you just described in terms of the trajectory of the broken taillight fragments?
It does, yes, sir.
Do you see any defect at all in the right sleeve of that hoodie?
There is no defect in that right sleeve of the dummy. No,
Was
sir.
the dummy's sleeve examined following this test? Closely examined up close rather than just a photograph?
It was examined and photographed, yes, sir.
Was there any defect in that right sleeve at all?
No defects at all were noted in that sleeve. No.
Next slide, please. What are we seeing here?
This shows some of the photographs taken of the sleeve and the arm to show that there's no defects whatsoever, and it shows the damage to the Lexus. And again, at 24 miles an hour, not only do you get damage to the taillight on the fender there, but you also get damage to the taillight on the liftgate.
Was there any damage on the taillight of the liftgate in the subject SUV?
There was not, no.
Next slide, please. What are we looking at in this video?
And so this was 29 miles an hour with a suspended hybrid 3 arm.
Was the arm in the relative orientation that you saw depicted in the paint transfer test by Aperture?
It was, and in fact, in this one, there's actually contact. We moved it in so that you would get contact with the elbow and the upper arm as well. So it's in the position after Dr. Welcher moves his elbow in and rolls his shoulder into the taillight cover. We evaluated that position with this test.
And do you see any damage to the liftgate taillight based on this test?
There's extensive damage at this speed, yes.
What about the damage to, damage would you expect to see to the arm itself at this speed and in this orientation?
At this speed, I mean, we're talking 4,000 pounds of force on the forearm, and with the hand, 1,400 to probably 3,000 pounds. I mean, well above levels where you would get fractures.
Next slide, please. What are we looking at in this slide, these two photos?
This was the final test that was conducted in using a dummy, and it was impacted at 29 miles an hour. And this was a center of mass impact.
Why was it important, Dr. Rentschler, why was it important to do a center of mass test?
Because if we have an auto pedestrian impact and you want to see where the pedestrian ends up, you have to evaluate how they were impacted by the car. In order to have the pedestrian move any substantial difference, it has to be hit at the center of mass. Again, it has to be hit at that belly button area to propel the body in a certain direction depending on the speed and direction. If there's no center of mass impact, how does someone get to the point of rest? You can't correlate a side swipe where the arm gets contacted and say if someone ends up 20 feet away, there's no way to correlate that arm impact caused them to somehow move 20 feet away. It wouldn't be as a result of the actual incident. It wouldn't be a result of the impact pushing their body in that direction.
From a physics standpoint, is it reasonable to believe that your arm could be struck, just your arm could be struck as it's out in front of your body, and you could be propelled backward, say 7, 8, 10, 12 feet as a result of that strike?
No, it's not reasonable. That's not physically possible. And you look at the arm itself, and we're looking at talking about the injuries and the abrasions compared to fractures. So if Mr. O'Keefe's arm was hit at 24, 29 miles an hour, what this suggests, and there were only abrasions, what this would suggest is that if the taillight doesn't cover or fracture, you can have your arm hit at 24 miles an hour and you wouldn't have any injuries at all, which from a biomechanical standpoint doesn't make sense. If the claim is that the fractured taillight's the only thing.
So I'm sustaining the objection to that. I'm going to strike that portion, Mr. Jackson.
Let's go to the next slide. What are we looking at in this video?
So here's the video showing that strike at 29 miles an hour with the center of mass impact to the dummy.
What's the import of this particular test? Why was this important, and what did you conclude following this impact test, the center of mass impact test?
There's a couple of reasons. It shows there was extensive damage to the rear of that Lexus. So if you had a center of mass hit, you would have damage to the liftgate, to the fender, to the sheet metal. You would have substantially more damage than what we had in this case. And secondly, which I believe is just as important, it shows the post-impact trajectory of the dummy. So again, if you're struck on the corner by the Lexus, the dummy goes straight back in line with the vehicle. There's no force and no direction to actually cause that dummy to move off into the side of the vehicle. So you can't be hit center of mass with the vehicle going straight back and somehow end up 10 or 20 feet to the side of where the vehicle is traveling.
So in this circumstance, would you expect the taillight material to be distributed straight back in the same center line as the vehicle is traveling?
Yes, absolutely.
Would you also expect the body to be struck and move in the same center line as the vehicle?
Sustain is too.
Sure. What about the body? What directionality would you expect on a center mass hit?
The body's going to move in the direction that the vehicle is moving. That main direction, that main force moving straight back, the body is going to move primarily straight back.
Did you reach an opinion or conclusion regarding whether the right arm kinematics are consistent with fracturing the taillight cover and sustaining the abrasions that you saw on John O'Keefe's arm?
I did, yes.
What is that opinion?
My opinion that it is not consistent with contacting and fracturing the taillight cover.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And if I could have just a moment, Your Honor.
Sure.
On what do you base your opinion that you just told the jurors?
That looking at the kinematics of the arm, it's inconsistent with the evidence we have with the actual abrasions to the arm, the evidence on the sweatshirt, and that at these speeds, you would likely expect fractures, certainly to the hand, and likely to the ulna and the radius in the forearm, if your hand or arm was struck by the rear of the SUV.
Can we move to slide 48, please? What are we looking at in this slide?
This was a study where they used an impactor and they contacted the dorsal or top part of cadaver hands. And they looked at the force that was exerted and they looked at how many fractures were produced as a result of that.
Did you review scientific literature regarding hand injuries under this sort of impact loading? Is this representative of that?
It is, yes.
Next slide, please. What is this?
So this shows the position, and this is taken directly from the aperture paint test. You can see the position that Dr. Welcher had his hand against the tailgate right at the time of impact. And you can see that corresponds, the contact areas correspond to the areas of the hand that were actually tested in this case.
Next slide, please. What is this showing?
So this shows the forces produced during the test as well as the forces produced during our testing. And maybe the next slide here actually better. If you look at the knuckles, which are the blue middle region, and then the metacarpal bones, which are the lower one. So for the metacarpal phalangeal joint, the knuckles, on average, it took 397 pounds of force to fracture that joint. Well, the 15-mile-an-hour test produced a minimum of 483 pounds. And more realistically, that's just with the hand weight. There's going to be more weight because it's attached to the wrist. More realistically, it's twice that, so it's around 900 pounds of force. But what these tests show is that the force produced on the hand, as represented by the PowerPoint from Aperture, even at 15 miles an hour and likely below that, you would expect to get fracture of the hand bones, of the knuckles, metacarpal interphalangeal joints, and the metacarpal bones if you contacted the rear of that vehicle at that speed.
Did you see any indication in the x-rays you saw or the medical records that you reviewed that Mr. O'Keefe's hand was damaged in such a way that you would expect?
There were no indications whatsoever of that, no, sir.
Next slide, please. What are we looking at in this slide?
This was a test where they actually looked at the force on the elbow. So this is a direct longitudinal force against the elbow. Now, there's no indication of exactly the test. The paint test has the arm horizontal, but there's no indication, there's evidence of whether maybe it would be angled or if it's straight horizontal. But even if your arm's angled a little bit at the point of impact, the forces, again, on the right are what we determined from our testing, and those are minimum. Again, that's just with the forearm. If you include the entire arm, it's about twice that. So even at 10 miles an hour, you're going to have 600 to 1,200 pounds of force acting on the arm.
Is that enough to break it?
That's enough. If you strike the elbow, that's more than enough to actually fracture the different bones of the elbow.
If an arm was hit at that speed with those forces, would you expect the x-rays to show no trauma, no broken bones, no fractures, no hairline fractures?
I would not expect that, no, sir.
Next slide, please. What are we looking at in terms of this slide?
So these are just more articles that I referenced, and they look at impact force on the forearm, so the ulna and the radius. It takes, just to have a transverse blow right against the bone, it takes about 1,100 to 1,200 pounds of force to cause a fracture. We're at that level already at a 10-mile-an-hour impact.
What about a 24-mile-an-hour impact?
24, we're at 1,400 to 2,800 pounds of force.
Did you see any trauma on John O'Keefe's arm that was suggestive of an impact of that nature, of that size, of that force?
There was no trauma. There were no fractures. There wasn't even an indication on the arm of where it would have contacted the vehicle. So if there's fracture at the taillight, there's going to be a force at that point on the arm where it actually contacts the taillight and causes that, right? There's going to be a force riser to cause that damage. There was no bruising. There was no lacerations. There was nothing at the alleged point of contact which would indicate an impact that produces thousands of pounds of force on the arm. No evidence of it whatsoever.
You just mentioned this in your answer, but I want to ask a little bit further. We've talked a lot about bone fractures and ligament damage, et cetera. What about bruising? In any of these tests, would you expect to see bruising, at least bruising, all over the arm at the points of contact?
Absolutely. Bruising occurs when the blood vessels just below the skin are ruptured, and it causes blood to flow into the arm.
Was there any indication that John O'Keefe suffered even a minimum amount of bruising on his arm at all?
No indication of any amount of bruising whatsoever on the forearm.
Next slide, please. And let's go to the next slide. I think we want to jump to slide 50. What slide are we on? Is that 53?
This is 55.
Let's go to the next slide. There we go. That's what I'm looking for. What are you looking at here?
So this again is from the paint test, and it shows, even as the arm gets pushed in, the vehicle's not in line with the center of mass with Dr. Welcher here. So it's not a center of mass impact. And this is important because we've just looked at the arm, and we've looked at the kinematics and the force and whether that's consistent with what happened and the injuries. The next step is to look at what happens if the arm gets hit. How does Mr. O'Keefe end up where he does in the yard? So that's post-impact movement or trajectory of the body. You have to evaluate that if you want to link all these events. If you want to link the head injury to contact with the car, you have to know what happened in between. You have to know the details. And so the next part was to evaluate that.
Is there any indication in any of the testing that you did or any of the review of the medical records of John O'Keefe, including the autopsy records, all of the autopsy records, the x-rays, and the hospital records, any indication that John O'Keefe was struck center of mass?
None whatsoever. No indication at all that he was struck center of mass.
Do you have an opinion or conclusion to a reasonable degree of scientific certainty about whether he was struck center of mass?
I do.
And what is that opinion?
I don't believe that he was. The evidence indicates that he was not. If he was struck center of mass, imagine that. You're getting hit at the pelvis. You're getting hit on the thigh. You're getting hit at the knee. And then the body's being propelled forward. Your arm would get pushed into your body, into your ribs, into your torso. You would have very significant and substantial loading to your body, initially the right side of your body, as that impact occurred. And there's no evidence whatsoever that occurred.
Switching to a glancing blow, a blow of just the arm, not the center of mass, but just the arm. Do you hold an opinion and a conclusion as to whether or not a glancing blow or a blow to the arm only would propel Mr. O'Keefe 7, 8, or 10 feet perpendicular to the line of travel of the vehicle?
I do.
What is that opinion?
It would not be possible. Our testing demonstrates that. The peer-reviewed articles demonstrate that. I've seen no evidence anywhere in this case that would suggest or even indicate that if you get a glancing blow or a sideswipe blow, that somehow would produce enough force to push you 8 to 10 feet into the yard. I don't believe it's possible. I've seen no research that would indicate that would occur.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Can we move to the next slide, please? And let's go to the next slide. Let's keep going. Okay. What are we looking at in this slide?
So this slide, it's a paper that describes how to evaluate vehicle pedestrian impacts and how someone moves in the projection of that body.
Did you seek to analyze a fulsome understanding of whether it was possible that Mr. O'Keefe was hit on his lower extremities?
I did, yes.
Why did you do that? Why was that important?
Well, because with automobile pedestrian impacts, the lower extremity, your legs, your ankles, your knees, that's the most injured part of the body during autoped impacts. So if he's going to be impacted at that speed, especially at center of mass, there's likely going to be injuries to his leg, to his knee. The bumper lines up with the knee. That's one of the most commonly injured parts, as the bumper pushes into the knee, fractures the tibia, the fibula, or damages the knee joint.
Did John O'Keefe suffer any injuries to his lower extremities suggestive of a vehicle impact?
No, I believe the only injury was a 0.5 centimeter abrasion on the outside of the right knee.
Could Mr. O'Keefe have suffered a 0.5 centimeter abrasion on the outside of his right knee by being struck by an SUV at 24 miles an hour?
I don't believe so. I don't see how those kinematics would work.
Sustained.
Do you have an opinion as to whether or not that injury was from being struck by an SUV at 24 miles an hour or somewhere around 24 miles an hour?
I do.
What is that opinion?
I do not believe that injury is consistent with being struck by an SUV at approximately 24 miles an hour.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Did Mr. O'Keefe suffer any other injuries to his legs or his lower extremities other than that small, how big was it? How many centimeters?
0.5 centimeter abrasion.
That small 0.5 centimeter abrasion. Did he suffer any other injuries to his lower extremities indicative of being struck by a vehicle?
I don't believe so, no. Let's
go to the next slide. taking a look at the photograph on the right, concentrating on that for a second. How did that SUV get in that condition?
That was by striking the dummy at 29 miles an hour, and that was a center of mass hit with the dummy.
Were you able to review photographs of the subject SUV, Ms. Reed's SUV?
I was, yes.
Did her SUV suffer or suggest any kind of damage anywhere close to this?
No, the only real damage was to the outer taillight cover on the fender itself was fractured.
Next slide, please. We've seen this. This is the video that was the center mass impact.
That's correct, yes.
The photograph that we just saw previous, what relationship does that photograph have to this field test?
That was the condition of the SUV after it struck the dummy here at 29 miles an hour.
Can we go to the next slide, please? What are we looking at in this series of diagrams?
So this is some more recent testing that was done, and this test compared impacts between a small sedan and an SUV, and show it's looking at damage or injury to the legs as a result of this type of an impact. And these impacts are actually conducted at a speed of 24.7 miles an hour. They used cadavers, people who donated their bodies to science, set up the cadavers and struck them at just about 24 miles per hour.
Did this support your opinion and conclusion concerning the lower extremities of Mr. O'Keefe and the possibility that he was hit by an SUV at speed?
It does. If I can go to the next slide, it actually.
Sure.
So this shows you for the SUV, it's the last column on the page there. The last three columns are the injuries associated with the SUV strikes. There's fractures to the pelvis, left knee injury to the ACL, the MCL, fracture of the tibia and fibula. There's extensive damage to the legs of all three of the cadaver subjects that were struck at 24 miles an hour with an SUV.
Did Mr. O'Keefe show any signs of any of these injuries?
He did not, no.
Next slide, please. Is this, what are these photographs and diagrams on the right?
So this was taken from the PowerPoint from Aperture. And so it shows that the medical diagram shows the 1.5 centimeter abrasion. And if you look at the picture on the left of the surrogate, you can see, so the bumper would line up from the knee all the way up to the pelvis. So a vehicle at speed of 24 miles an hour, if it impacts that knee or that leg, it's not going to produce only a 0.5 centimeter abrasion. It's going to get the leg, and it's going to cause significant damage to the knee and to the leg itself.
When you say from the knee to the pelvis, are you talking about the width of or the height of the bumper itself being from the knee to the pelvis?
I am, yes.
Would that be the contact area that you would expect if there was even a glancing blow to the knee and the hip?
That's correct. You can see on that picture there where that bumper, the rear corner of that bumper, where the bottom reflector is, it extends from the knee all the way up to the pelvis.
Can we go to the next slide, please? What are these diagrams?
Again, these are just reports, peer-reviewed articles demonstrating that auto-pedestrian impacts result in lower extremity injuries and fractures.
Did you review all of these peer-reviewed articles that you've told the jurors about, the academic articles, in furtherance of coming to your opinions and conclusions?
I did, yes.
Did you see any reference in the Aperture report that you reviewed and the PowerPoint slides that you reviewed that the concomitant peer-reviewed articles were sought in the paint transfer test?
No.
Or cited?
There was only one article that was cited in that report with respect to automobile pedestrian impacts.
Did it have anything to do with the paint transfer test?
It did not, no.
Next slide, please. And let's keep moving until we get to the, yes, there we go. What is that slide depict?
So this is the opinions that were offered in the Aperture report. And if you look at the top, number 4, it says the totality of the evidence is consistent with the right rear corner of the Reed Lexus, again, impacting John O'Keefe and Mr. O'Keefe striking the rear posterior aspect of his head on the frozen ground. And when you look below that, it basically has the references or the support for that one conclusion.
I'll see you both at sidebar for a minute.
Okay, guys, I'm on a different mic, so let me know if it's too loud, too soft, or if it's working or not working. And if
Sounds
it is
good.
working, it sounds good. Thank you, Dan. Let me just give, so like a lot of people, and even you, Dan, you've missed some of the trial, and Kate's seen all of it. I think Jen's seen mostly all of it. I missed some because I was in the hospital, but I did see all of the first trial. Let me see if I can sum up things, if this sums it up, and see if you guys agree with it. So in the first trial, we didn't get the state of Mass, the prosecution didn't present any expert witnesses other than the troopers, mainly Trooper Paul. He didn't give a very specific explanation of what happened in the accident. On the other side, Karen's team had ARCA, and ARCA only considered really a couple of narrow possibilities here about the accident. Now the state has hired an independent company called Aperture. Unfortunately, Aperture determined that they couldn't really give too specific of an explanation as to what happened because they didn't know exactly what position John was in, whether he was moving, and things like that. So we don't have a very specific or detailed explanation for the accident in most aspects. And so ARCA is trying to take that on now. But what ARCA did, what Aperture did determine was there's so much other evidence that there was no other possibility except that Karen struck John. So basically,
Dr. Rinchler,
so sorry, that ended up being a
can
little
we
more
move to slide?
Come back to it on the.
Yeah, just a moment, Your Honor.
70, Mr. Jackson.
That's what was. I was just 7. Thank you. I wish my eyes were better.
We're due for a break, so we should get a 15-minute break.
Oh. Let me restart it here.
Thank you. Okay, what are we looking at in slide? This is slide 7. Yes. What are we looking at in slide 70, Dr. Rinchler?
So this was the one article that was referenced in the Aperture report with respect to automobile pedestrian impacts. And there was a chart from there that was referenced in the PowerPoint that indicates the head's the most commonly injured body region in pedestrian impacts.
And what significance did that reference have in your analysis?
Well, that's not accurate. This article was written in 1979. And the first modern SUV, the Jeep Cherokee, wasn't manufactured until 1984. So this is an article that's 46 years old that doesn't actually relate to this type of an impact. And that's the only peer-reviewed reference with respect to automobile pedestrian impacts that was cited in the entire Aperture report.
Can we move to slide 71? Do you recognize what's depicted in this slide?
I do, yes.
What is depicted here?
So this was hybrid. This is the 50th percentile hybrid 3, the same dummy that we utilized. And Dr. Welcher performed a test where
Can I interrupt you?
Sure.
So this ATD, anthropomorphic test device, was not a 95th percentile test device?
It was not, no.
Is it 50%?
It was a 50th percentile, yes.
Is that the same exact, not the same exact, same exact sized ATD that ARCA utilized in all of its testing?
It was, yes.
Okay.
And to get the forces on the head, Dr. Welcher scaled the acceleration results based on the weight, which is what I was talking about yesterday. You scale the results from the 50th percentile. That's exactly what Dr. Welcher did in this case.
Is that an appropriate way to adjust for the size of an ATD?
It absolutely is, yes.
Okay. Go ahead.
So this test, what he did, he took a 50th percentile dummy, stood it up, and then let it drop backwards and strike its head on a concrete surface.
Next slide, please. By the way, Dr. Rinchler, did the last slide include a video?
I believe it did, yes.
Can we go back?
Or I'm not sure it's on this slide, though. That's just a screenshot.
I see.
Yeah.
I see.
Yeah.
Okay, so let's go back to that slide for just a second. I thought this might be the video of it.
Oh.
So in the lower portion of the center of the screen, you see Dr. Welcher holding the ATD. Is that correct?
That's correct.
Did you review a video of what happened next? This is not the video, but did you review the video?
I did, yes.
Describe for the jurors, since we don't have access to the video, what did you see happen from this point forward?
So Dr. Welcher releases the dummy, and the dummy just falls rigidly backwards, almost like a tree, and impacts the concrete.
Can we jump from your PowerPoint to a video that I have and ask you if you recognize it with court's permission?
Is the video in evidence?
It's in Dr. Welcher's PowerPoint.
Is it before the jury? Is it in?
It is.
Okay.
Okay. Do you recognize this?
I do, yes.
Is this just look like the same screen, basically same thing that you just took a screenshot of?
It is, yes, sir.
Okay. If we could play the first couple of seconds of the video and pause it. As that video began to play, did you recognize this as being the same video that you reviewed earlier?
It is, yes, sir.
And did you utilize this in coming to your opinions?
I did, yes.
Opinions and conclusions in this case?
I did, yes.
Thank you. Let's go ahead with the court's permission. Can we play the video?
Yes.
Thank you. What did you see? Describe what you saw in this video.
So this is a passive rearward fall of the ATD dummy. So just releasing and let it fall. Obviously, it's a dummy. There's no musculature. There's no response to that dummy. So this is what would happen if a rigid individual just fell backwards onto a concrete surface.
Can we see it one more time, please? I want to ask you one other question. I'm going to ask you to take note, Doctor, of the impact location. Did you see that?
I did, yes.
What kind of surface is that floor, if you can tell?
That, I believe it indicates it's a concrete surface, concrete floor.
Did you notice if the falling backward like that, the dummy slid across the floor or was propelled across the floor, anything like that?
It did not. It just dropped and angled backwards and hit directly on the floor.
Okay, let's go to the next slide. I'm sorry, if we could revert back to your PowerPoint. And if you could pull up slide, I think it's 72.
Let me, every time we do that, I have to restart the PowerPoint. Okay.
Why did you include this video one more time in your PowerPoint here?
Because again, this is the pain test, which indicates the position, at least that Dr. Welcher had himself at to get the impact with the taillight cover. And notice, again, so it's not a center of mass hit. It hits his arm and then he slides by. So if that were to occur, he would rotate or move to the left. So if Mr. O'Keefe did that and somehow ends up falling backwards, rigid directly onto his head, he's going to have to rotate at least 270 degrees and then stop and then fall directly backwards onto his head. There's no explanation of the kinematics.
Sustained is to the end of that. I'll strike the end.
Do the kinematics support what you just suggested?
Objection. Sustained is to form.
What do the kinematics support?
Objection. I'm going to see you at sidebar for just a minute. Jurors will be taking our break.
Okay, I believe I caught at the end that she did say jurors will be taking our break. So I think we're going to get about 15 minutes to talk here. And I just want to add on quickly to what I had said there, and you guys can react to it. And I do believe that I actually am disappointed from what I saw with Welcher's explanation. I wished it was more specific and made a little more sense to me. But the center mass thing always has an issue. If you're going to say that the force of the Lexus is going to propel a body backwards 15 feet or whatever they decided it was, it has to be some level of center mass strike. It can't just be sending someone spinning like a top. This is how it came up in the last trial. So what I said last year, and Dan maybe has some accident experience, he may be able to talk about this, but is that the arm went up, the elbow, I don't know if you guys can see me, like something like this, and then it's pushed into the rib cage or in the center part of the body. And that's how you get that center mass push towards the lawn. And it would create a little bit of spinning too, where you're spinning while you're propelled towards the lawn. But I'm not sure, it wasn't really clear from what I saw from Dr. Welcher. And so just back to what I said before, I think maybe Dr. Welcher erred on the side of caution where he says we can't say for sure exactly how this happened, just that we know that it did based on all the other evidence. Do I have that wrong? Do you guys want to add to that?
No, I think he did. He does not. He repeated that a million times. It is the responsible scientific way to do things. He is not an advocate. He is an expert witness. He's only going to testify to what he can. And he repeatedly stressed there are too many variables that are unknown to be able to do what ARCA is attempting to do. Right. There's just and that's why they're doing it, because there's too many variables unknown. So they can do this a million times and get a million different results, and they're all going to be different and they're not going to be consistent.
Okay, so we're in agreement. So do you like the theory, Kate? I think when we talked about it a long time ago, you did, but that the arm or the elbow got pushed into the body, and that's how you get that center of mass propulsion. I think for this, like I said, I don't think
possible. We don't even know that he was propelled, though. That's another part of this too. We have no idea where he was standing. We have no idea what angle he was hit at. We have no idea how he reacted. Did he brace? Did he try to jump out of the way? Did he just stand there dumbfounded? Nobody knows. So, like, I mean, and again, I think that once they get Welcher on rebuttal, that's probably going to be something that's attacked quite a bit. It's like this is bullshit what they're doing. It's absolute bullshit. There's not enough information.
Okay.
I think it was put in Discord today. Somebody made a comment, and I don't want to take credit for it, but it is brilliant, and said, you know, if a house burns down, you don't need to know the origin of that fire. You see the ashes, you know? Right?
You know, to me, no, sorry about that. Go ahead.
All right, man. I was just going to say, I think, like, okay, first off, him saying that there's 32 points of contact for the abrasion and trying to simplify it as needing 30, was it 32 or 36? 36 points of contact. Yeah, and he's trying to reduce it down, saying, well, then you're going to need by de facto 36 objects to strike those points. I mean, just to overly simplify it, but if I hit you with a rake, all those little tines on there, right, and say 6 points caught you, and it raked down your arm, okay, it skips on the skin. It moves around. So 6 points can cause 36. 2 points can cause 36 if it's moving around on the body, especially through clothing while it's breaking apart. Is 1
broken
point breaking, creating 2 points of contact? Like, he's just overly simplifying that just to confuse the jury. I thought that was pretty weak of him.
That you just reminded me too that in one of the pictures they showed, some of those abrasions on the upper arm looked a little road rashy from that angle.
Right. That, you know, the last point is everything he just said. It's like, Rentschler, dude, did you not watch your test example E that you guys did? Did you not watch it? Because pretty much everything you're disputing, you proved in your own report or your own video. So that's also ridiculous.
Yeah, and to me, I mean, have any of you guys ever played pool? What happens if you hit the ball off centered? It goes off to the left, to the right.
Yeah.
You know, that's one of the things. The body isn't a square. It's not flat. It's more rounded than anything else. And so getting hit off center would cause it to go to the side as well. The other thing I noticed, he keeps mentioning 20 feet. I don't recall ever reading that John's body was found 20 feet away.
But he wasn't. 7 feet from the roadway. The guy is 6'1".
Thank you. Dr. Welcher, based on your review of everything, did I do that again?
That's funny.
This is Dr. Welcher in the video, correct?
Correct.
All right. I was staring.
Rescue
at that.
Rentschler.
I apologize. Dr. Rinchler, based on your review of the video in which Dr. Welcher is positioned, as well as the drop test that you saw, as well as the discussion of being of the body placement, where you discussed the body placement. Do you have an opinion as to whether or not the testing that you reviewed from Aperture is consistent or inconsistent with John O'Keefe being struck by the vehicle, propelled perpendicular, backward, say 7 to 10 feet, and falling straight back onto a hard surface, as depicted in the drop test?
The testing's inconsistent with those types of kinematics or that type of scenario.
On what do you base that opinion, sir?
That's based on the testing that was performed, the evidence available in this case, and the kinematics of how somebody would move post-impact after being struck by an SUV.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes.
Can we go to the next slide, please? May I have just a moment, Your Honor?
Yes.
Finally, Dr. Rinchler, do you have an opinion,
He almost did it again.
or did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
Thank you. That's all I have, Your Honor.
Okay. So now we'll take our break, folks. We'll see you in about 20 minutes.
Please rise for the jury. Jury break this way.
That's why I left this
You
on the
are
screen, because I
muted.
knew we were going to the break.
I've already identified parts of his testimony that I anticipate Hank will be able to fuck him over on and pit experts against each other, by the way. So the bruising, right? They keep wanting to go back to the bruising. Well, you have Dr. La Posada yesterday claiming that he died within 15 minutes of that head injury. Dead people don't bruise. There's no mechanism to bruise. Once your body stops pumping blood, there's
Good
no
point.
blood.
Good point.
Yeah, right. So
Yeah.
if we've got one expert saying that he was deceased within moments of this head injury, then he's not going to bruise at all.
Although I'm not sure if any of us on either side really believe her testimony on that. As I pointed out on Court TV last night, it's really inconsistent with theories of both sides, and it doesn't match up at all to what the paramedics. So the idea that these paramedics arrived.
I think it is possible. I mean, we have no idea to know exactly when he passed away. And
Yeah,
I
but do
think,
we really think the paramedics wouldn't know that someone's been dead for 5 or 6 hours?
I mean, at first they were pretty much ready to call him, right? And then it was Flamati said, no, we can't. We have to warm him up. So there's no indication that they did or didn't know, really. They're working on him because they had to, because he was too cold.
Is Jen still here? I guess Jen left because Jen worked as an EMT. I'd be curious to see if anybody here in chat worked as an EMT or a paramedic and what their thoughts on there. Because I think what Kate's saying is they may have, even though they may have determined that he was dead and could have been dead for a while because of his body temperature, they can't officially pronounce him dead until they warm him up to a certain degree.
I do think that the
rule.
elements, right? I do think that the elements play a role in that. I don't know. Is there any document saying that he had a pulse, or was he breathing when they found him?
No, they testified that he didn't have any signs of life. So
Okay.
they were pretty much, from what I understand, they get there, they find him, he's cold to the touch, they can't find any signs of life. I believe that he had started to be like a little bit of rigor mortis had started to set in, from what I recall, that he was stiff and cold and no signs of breathing or pulse. And so Nuttall was pretty much like, all right, we're going to call him. And then Flamati said, no, he's too cold. We have to warm him up. We're going to keep working on him.
Flamati also told Proctor on the phone that he estimated he had a 10% chance of survival.
Yeah.
He may have just been being optimistic. I don't know, but
I think the elements play a role. I mean, if you find somebody outside in the cold, you know, they may have just died, even though they're cold to the touch. There's no way of telling because of how cold it is outside, and I'm not sure how the cold, how that would behave, like rigor and stuff like that would behave in the cold. I'm not familiar with that.
Same with frostbite too. Like you can't get frostbite if you're dead.
You can have an imperceptibly, low heart rate, and I don't think they can call it on just the fact they can't feel it. You know what I mean? I think they have to err on the side of caution, and they work on pretty much anybody until they get the call. The death is called, right? And that's usually at the hospital. So,
well, so how important is rebuttal here? Margaret, how important is rebuttal to come in here and fix this stuff up? Because these have been two pretty powerful witnesses. So
yeah, it's really important. Yeah. Hank, first of all, Brennan, I think will do a very good job on cross-examination, but thank God Welcher has the last word because, this guy came across pretty credible.
Yeah.
Trying to play devil's advocate here. So, yeah, it's key, in my opinion. This is their best witness. That's why they're putting him on last.
Right. Yeah, I agree. He came across as credible, knowledgeable, and it's if it's him versus Welcher, he doesn't have to win. He just has to create a little bit of doubt. So Welcher has to really come in and win by a KO here.
Yeah.
And I'm saying that, not to ignore the fact that the jury's going to look at the totality of all the evidence, all the rest of it, which I think Welcher's going to emphasize and through the questioning.
Right.
You have to look at all the other evidence.
Right. God.
So, but this guy was an impressive witness, though. He was, he comes across as an honest kind of like, and I think Kate was correct in that they did try to establish that him talking about his kids and stuff like that. I thought the same thing at the time, that this seemed like practiced a little bit, and
too much so, especially the way that like you have no idea where he's going with that diatribe that he's on with the children. I mean, I guess you could kind of surmise, but Jackson picked it right back up with a question prompted again.
I know.
Well, do you recall the ID documentary, The Scenes in the War Room? Karen's sitting there saying, like, I think it was in reference to Brian Albert, I believe. She's like, it's like at the Ponderosa, she's trying to paint everything in like cinematic angles there. It's like, that's just ridiculous. Everything they do is performative. It is. It's completely contrived, all of it. Even the scripting. And so I agree. I think the comments about the birthday, I think that was probably well thought out. I don't think it was clever, but it was well thought out. They planned it ahead of time. Everything is optics with these weirdos.
I mean, it's going to be optics, I'm sure Margaret will tell you, for both sides. You're instructing your witnesses to look at the jury, look at the jurors, and make contact with them. So that's fair game. That's part of it for both sides.
It is.
Sure, but
and
your argument should, but you should have substantive arguments first. Understanding optics, I get that, but the theatrics, like this is not a play.
It's a murder trial
for cameras, right? Yeah, it's denigrating the whole process. Not to get too
somebody
serious,
died. John O'Keefe died. You got to keep remembering that.
That's right. Yep.
So I do like how.
I'm looking at your private comment saying, "Did you hear a cat?" I did.
Oh yeah. So she's sleeping now. I have an elderly, and she meowed during the first live segment. I was like, "Oh no," but she's asleep. Yeah, people noticed. I love animals. I know. Well, but when she wakes up, I'll have to put her out of the room.
Yes, I'll have to see it.
Because she's loud. She's louder than your dog, I swear.
I don't know. We have a cat like that too. He's actually at my feet right now, so he's not.
Yeah, mine is too.
He's 10. He's about 10 years old, and he's He's an orange cat, so he talks a lot. He's my daughter's cat, technically. His name is actually Cat.
Oh, that's
he had
funny.
a name. His name was Baron. We rescued him. He was like a barn cat situation. Him and another cat. I got roped into it from the kids, and they both had names. And my daughter was probably 9 or 10 at the time. Yeah, I think she was 9. She'll be 19. And she's like, nope, his name is Cat. And I was like, really? His name is Cat? And she's like, yep, his name is Cat.
Oh, that's so funny. Yeah. Yep. Mine's so I have to rub her head with my feet when I'm on the live stream so she doesn't meow. So she's right under my feet right now. But anyway, up there we woke her up. Oh gosh. So yeah, I'm really looking forward to the cross-examination. Hank's very good at it, as we all know. But geez, I wouldn't want to have to cross-examine this guy. I'll tell you that. I think you made some good points, Kate, earlier about some of the things he's going to hammer away on.
Well, that's the thing is, it's like, when you have infinite possibilities, right? And so many missing factors, you can really kind of guide your presentation in any direction you want. And that's what they're doing. They're taking advantage of what we don't know. And they are purposefully trying to kind of ignore what we do know. I mean, at the end of the day, I think that the hardest point for the jury to overcome, that I don't know that they can, is that she backed up her car at the same time that he stopped moving forever, and consistently across the board. Because again, when I'm looking at an argument, I like to look at what everybody agrees on first. What are the uncontested facts, right? Because that's sort of the foundation. So everybody agrees that Karen Reed was there. Everybody agrees she was drinking. Everybody agrees that she was the one operating the motor vehicle, right? So anything past that point, we can absolutely attribute to her. Nobody disagrees with that. And so everybody agrees that this vehicle data is the data is what she said. They're not contesting it at all. So now we know that she was the one operating, that she was intoxicated, that she was angry too, that she's not that either. And that this backup maneuver coincides when he stops moving forever. And we have all sides agreeing that head injury was pretty much instantaneously happened. Oh, that is loud.
Yeah. Nope, not me.
No, I think Kevin's mic is just nice and sensitive.
I can. There's a guy cutting the lawn outside, so I can.
Probably that's. That's not at my house though. I need to cut my lawn.
What do you guys think about the fact that this witness brought up his son, because the only thing that the jury knows about any other family is that Dr. Wolf's wife is free Karen Reed? Do you think this could be a way to introduce other members of his family that, trying to offset that optics of Dr. Wolf's wife being free Karen Reed?
Probably not. I think it was probably just to be cute and relatable, and possibly because he wanted to wish his son a happy birthday on television. There's no value to that, and to his credit, up until I think this point, Rentschler's been a pretty straight shooter. He doesn't have the same sort of sketchy credibility issues that Wolf did. He did not use Signal. He did not delete text messages that I'm aware of. He wasn't really in charge of any of that. And he doesn't have any family members going on free Karen Reed forums, bragging and interacting with everybody and being supportive. So I think that it what probably wasn't tactical in that way. It's just to make him likable. It's just, so if anybody else has a 10-year-old on the jury, they can relate and go, oh, I have a kid and I love my kid too, and I would want my kid to see me on TV wishing him a happy birthday. That's so sweet, right? Like that's I think pretty much it. As well as personally, he may have wanted to just wish his son a happy birthday on television, because how often are you on television? Most people, right?
Well, here's the thing though. If the television is going at his house, is he watching it? Because he's under a sequestration order.
I would
just give me a quick sound check, make sure it's I turned everything down. I just want to make sure it's my noise still bothering you guys.
No, I don't hear it at all.
Okay. I turned the gain all the way down. And no, my TV is not on. I don't know why someone's saying that. No, it
sounded like someone's running a lawnmower outside.
That's all it is. Yeah. And the person who said that is violating one of our number one rules here, is do not post in all caps. if that just ruins chat if people post that, because everybody starts doing it. It's like screaming. So the rule here: do not start posting in all caps. You can put a word in caps, but not your whole post. So, anyways, I'm sorry. Go ahead. Didn't mean to interrupt. I just want to make sure my noise wasn't bothering people.
No, I was just going to say, I do not believe that his 10-year-old son is watching this trial in real time. Hopefully he's in school today. Like, I'm assuming he's in school today. My kid's in school today. So I'm assuming that, and my kid has finals this week. Oh, shoot. That reminds me, Kevin, I got to just run out for a couple minutes at 12-ish because I got to go pick him up.
Well, I get I get the idea of saying happy birthday to your kid on TV, but during a murder trial just seems kind of, I don't know.
Right.
I don't think it's going to move the jury one way or the other.
Yeah.
Oh, school's out for a bunch of people. Well, go ahead and just brag about that, because we got another week to go, and the poor kid has to go back to school on Monday for one day, but it's finals. So, like, whatever. He has mostly half days, like, when they finish the test.
I bet he's watching his dad. I guarantee it. If that television is on in their house.
You'd be surprised. My kids would rather die than see me on TV or any of this stuff. Like, they have absolutely no.
Oh my God! Yeah. Friends and family. Holy hell! It doesn't matter.
Boomer knows my kids, right? Boomer knows my kids. Can you imagine my daughter? Right?
I'm telling you, you could have the coolest gig on earth, play the raddest show ever, and your family and friends couldn't care less.
Yeah, right.
They never cared. Oh yeah, cool, yeah.
No, my son follows the live stream.
Oh wow!
Yeah, so he does. Like, he's on and off. He's working, but when he has a break, he'll hop on our live stream. That's how I knew my cat was meowing, because he texted me and said, "Mom."
On second thought, Margaret, my friends and family are rotters. You're all rotters. Look, Margaret's kid cares. Come on.
He does.
We've had a very unpleasant internet experience, my family, so I can understand why my kids just don't want to.
Yeah.
It seems too that kids that are like 12 and under are hooked on YouTube too. They consider YouTube like our generation might have considered TV.
Yeah, my guy's older though. My guy's like 20. He's 26, but he loves true crime, and he's really into the Whitey Bulger and those characters, and. When I covered the case, all of my kids came to trial with me, except for him. He's like, "That's my biggest regret, Mom. God, I could have gone to that trial." I'm like, "Yep." But he wasn't interested at the time. So,
well, much younger then, right? I feel like teenagers are never interested in anything.
Yeah.
Right.
I know that, like my teenagers, when this whole Karen Reed thing happened, and at first I was trying to kind of explain in conversation, they were both so mystified as to why anyone was interested in this at all, and like, clearly she did it, who cares, right? Like, which I think is such a healthy attitude. That makes me feel better about the jury being younger too. I feel like a lot of younger people, it's like, this is so obvious, they don't have this like whatever midlife crisis is pushing a lot of this along, or whatever it is with the free Karen Reed.
I don't know about that, Kate. I think a younger jury might buy into some of the conspiracy theories, or
You think so?
I don't know. It's a possibility.
I always assume younger people are smarter, more savvy. But
There's a mistrust of authority with younger people.
Right. That's
really.
Yeah.
I think so.
Yeah.
It's hard to say.
I could see that. But there's one difference that in my opinion anyway. Like, and you see it with the sort of the following of celebrities. It isn't what it used to be, like back in the day, everybody cared about actors and actresses, and everybody was just couldn't get enough celebrity this and that. Right. And now it's so fractured and so niche that I just don't think the culture is the same with the adoration of celebrities. So maybe Karen's celebrity status, the way, even though it's insanely contrived, the following seems to be older, right? I don't think the youth really care about that adulation like maybe our generation did.
On TikTok, I see the youth.
Right.
For for pro Karen Reed. So it's hard to say. I don't know.
Right.
Because I'm judging by what my generation, my son now, as I said, he's 26. he's been on everybody's channel on this case. So he's been on, the bloggers channel and everything. And he thinks she's guilty, interestingly.
Right.
So I don't know.
Well, you got a smart mom.
I'll get him on. I'll get him on sometime if I can. See what a 26-year-old, how they feel about the case.
Right.
Well, my guess is he's probably, if he's someone that is inclined to weigh evidence in a logical way, like a lot of us are, that's probably how he was when he was 16 and 26 and how he'll be all his life. It's just kind of his nature.
Yep.
If he's someone, now some people, the way they look at these cases, they make a decision based on whether they like Karen or not, whether, so people that looked at that Discovery ID documentary and she came across as so unlikable, particularly in the first couple episodes, I think a lot of people just said, she did it just because they didn't like her. And I don't think that's the right way to look at these cases, but I do think that's unfortunately the way a lot of people do.
Yeah, it's true. First impressions are huge. That's why opening statements are so important. It's a first impression. And we were on Court TV last night. We were actually talking about the going back to Jackson's opening statement and how many promises he just didn't keep. It's incredible. So,
and Hank's gonna
Wayne Dennison. I was
gonna say, so. You'd think he would capitalize on that, right? I mean,
and so Wayne Dennison, who represented Johnny Depp, was on with me last night, and as a defense attorney, he agreed. He thought, you just don't want to make promises you can't keep, and that's the way I felt it. I learned in law school. I learned as a prosecutor and then as a civil trial attorney, had to be really careful with that. So it blows my mind how many promises Jackson made that, he's talking about Brian Higgins and Albert and the phone and them getting rid of their phones. I mean, there's no evidence that came in on that.
Do you think that's commentary to how desperate the defense team is that they, shamelessly just kicked it all off with, lies and empty promises?
Well, I think Hank took him by surprise by not calling on those witnesses, all those witnesses that were
That's
called on
true.
in the first trial.
Good point, Kevin. Yeah.
And Kevin, when I was on with you, you remember I was on with you and maybe a couple of weeks ago, we did a live stream on the weekend, and I was convinced that they would call Higgins and Albert and Proctor, and I was wrong on all of it. I couldn't believe it. So I'm like, nobody go back to that. But strategically, I still think they should have called Albert, because then they could have gotten all, more information on Chloe the dog. She was rehomed and she, did bite somebody in the past. And then, all the strange butt dials and why they didn't come outside. So I'm really kind of surprised on Albert, but it was a risk they decided not to take.
Right. Maybe because they feel, so we're seeing a couple of pretty good witnesses here. Maybe they felt confident in that they had enough that they could just hold it,
I think it's just a game of hot potato. Nobody wants these people on direct. Everybody wants them on cross.
Yes.
They don't have anything meaningful to offer to either side really on their own. They have nothing to offer the prosecution, period. They saw nothing.
No.
They do next to nothing. It has nothing to do with the elements of the crime that Hank Brennan is trying to prove. So it makes perfect sense to me why he said, nope, not falling into this trap again. We're not calling them. The defense, these witnesses on their own, like narratively, have nothing to offer the defense because they didn't do anything. They didn't see anything. They didn't conspire. There's no evidence that they can be confronted with about any sort of conspiracy or any sort of malfeasance whatsoever. So they need them on cross because they need to be able to lead them into their narrative. And they can't do that if they call them. So it was really like, Brennan just played chicken with them pretty much and said, yeah, you want to blame these people? Bring them up and do it. They didn't want to do it because they can't.
Yeah. Yeah, he's at the I guess he is. Okay. I can picture him at the table. God, going through his papers. That is, that's tough when you really have to perform. But he's good. He's good at it. So I can't wait. I just wished him good luck. I'll be honest.
I'd like to think he's listening to Eye of the Tiger right now. That's just me.
he knows about the yellow cottage tails. He knows about the support here. I keep telling him I'm neutral.
Well, I'm not.
Well, I mean, I'm trying to be.
Neither.
I'm not. Yeah, I'm not neutral. I'm kidding. I try to explain that I'm trying to, when I give my coverage and I see something that the defense did well. For example, yesterday I did mention on Canton Confidential that Jackson did do a good job in pushing Kernodle to get evidence in. Hey, can we at least say it's an animal attack? So that was brilliant lawyering by Jackson. So if I see something that I see that's good lawyering, I'm going to point it out.
And then she exploited it fully. She got in a bunch of things that the jury was told to ignore, but she still got them in.
Yeah. Yeah. So, I'm trying to, and if Hank makes a mistake, or there's something that I'll point it out.
I can see the problem in, like, so you're kind of like Catherine Loftus, that no, my objection is in a similar position to where you're really looking to offer like legal commentary, right? And that's appropriate, and you're certainly more than qualified to do so. But I think that where the issue gets so polarizing and confused is there's two different issues here. There's what Karen Reed likely did, and then what the state can prove, right? And
Absolutely.
It's not always the same thing. So I think people get upset sometimes with the fair legal commentary, right? Because they don't want to give any points to the defense at all, or even face the possibility that, just because she did it doesn't mean that she'll be held legally responsible. I think it's a very slim chance that she's not held, but it still exists, right? And a lot of people don't like to see that, but there's two separate issues. I shouldn't say plenty, but guilty people do walk away. That does happen.
Yeah.
And
again, the government has to prove its case beyond a reasonable doubt, and there's a reason for it. They have to dot the I's and cross the T's. Thank God, right? So. But this is a highly
objective. It's
objective is the word. I shouldn't use neutral. Try to be objective.
Right. You could have conclusions about the case and still be objective about the individual components or the performance or the issues that come up during the case. And I think it's an important part of avoiding confirmation bias is to try to make sure you're not just cheerleading the side that you've already decided that you're close to, or that you support, or that are consistent with your conclusions. It's human nature to have that confirmation bias, and you all have to really, everybody, every day, to watch for that and make sure that you're not just being unobjective about it. It takes effort.
I just wanted to address Dirty Clean real quick so I can take this down because this irks me. I literally said that I believe that younger people were smarter than I am. So you completely flipped that around here. I was making.
She did say that.
Yeah, thank you. Yeah, like I was being optimistic and assuming that, as generations go on, people are, smartening up, not dumbing down. I don't know. That's just my assumption, though.
Yeah, and I think a lot of them take law classes in college now more than ever. That would be because I remember I taught at Boston College since 2005. So people seem to be really interested in the law, when they're college age, and even high school. They have some great teachers in high school these days on the law. So maybe they have a better understanding of the law as a result. Of course, we grew up with Law and Order, right?
Well, as I explained recently, so in the 2000s, I owned a bar, and I owned a bar on 9/11, and a lot of college kids, and they all came together on 9/11 in support, for the most part, in patriotic support of the country. But about 6 years later, I forget exactly what years was. This is when Hillary Clinton and other people were pushing the conspiracy theory pretty hard, and there was a slow night when there was maybe 20 people in the bar, all in their early 20s. And I said, how many of you believe that 9/11 was a conspiracy? And I think there was maybe one that didn't. So like if there was 19 out of 20 raised their hands and believed that there was a conspiracy behind 9/11.
Mm-hmm.
So what does it mean? I don't know. But they were vulnerable to hearing that kind of conspiracy talk and this thinking that, I don't know, that mistrust of authority that young people naturally have, and thinking that there's something bigger going on that explains things. But yeah, it was
Oh,
overwhelming.
You also had like fun stuff in the media, like Jesse the Body Ventura talking about the thermite paint and stuff like that.
Yeah,
Like there was
yeah.
a lot of entertainment based
Right.
conspiracy
Oh, yeah.
stuff going around too that kind of appeals to the younger crowd.
Yeah.
I'm not
What
saying
are-
he does specifically, but like
Right.
that media does for sure.
I will say this though, Operation Northwoods did happen, or was something that they wanted to do. If you're not familiar with what that is, this may have had to do with what happened with JFK. Obviously, the America was going to hijack a cruise ship, pretending to be Cuban, so that we can go to war with them, and Kennedy turned it down. That was something that was real, that was wanting to be done. So I don't, when it comes to those type of conspiracies, I don't buy into all of them, but 9/11, I think there might be something there.
Well, Gulf of Tonkin incident, all that stuff is real too. Of course, there are real conspiracies. Absolutely.
Hey, somebody just asked a very good question in the comments, asking for the state of Massachusetts, I think if I'm correct, I went by so fast, how do they select the jurors, like the 12? And, from the 18 to the 12. And in Massachusetts, what they do is they just, it's random. And then the judge chooses the foreperson. So in other states, I believe the foreperson is chosen. I guess I've heard sometimes by the jurors, but in this case,
I never heard that, but
and it's
sometimes by seat. In some courts,
Yep, sometimes. Yep.
Yeah.
Yep. It's all up to the judge.
Right.
Yeah, and so in my experience, I don't know, it was very often that the judge knows who the jurors are. They have the jury sheets, and so they usually pick. I don't know. They do put some thought into who the foreperson should be.
They got someone very intelligent in the first trial here, just based on the notes that came from. That was the very, very intelligent person.
But it is random, and they don't choose alternates until after the closing arguments and after the judge's instructions, because if you knew you were an alternate listening to the trial, you might not pay attention. It stinks though to sit here for 31 days and then be chosen as more than that, be chosen as an alternate would stink.
Yeah.
Oh man.
Well, I guess
that'd be awful.
If I'm hearing correctly, I guess the dismissed juror, the second dismissed juror from the last trial, is going on Turtle Boy's show tonight. And I hope she tells the truth, because I know the truth, and she better tell the truth, because I'll tell the whole. I don't want to tell her story, but I'll tell the whole story if she's going to use this as just a format to try to destroy other people.
Not to be too negative, Kevin. I don't think a lot of people with good intentions, let alone wanting to tell the truth, or gravitate to that show. I just, I would be so surprised, but you know what? I'll try to stay optimistic, but I hear you.
Right. And of course, there was the alternate juror who showed up the next day in court dressed in pink and crying.
Yeah.
It's crazy. That's nuts.
It's malarkey, I tells you.
It's malarkey.
Mm-hmm.
I can't wait for the cross.
This court is in session. Please be seated.
Oh, there was a question for Margaret, and I don't know.
All right, Mr. Brennan.
Oh, well.
Dr. Rentschler, facts matter, don't they?
They do, yes, sir.
You've said it many, many times. Facts matter. Isn't that correct?
I think it was details, but facts matter too.
Do details matter, doctor?
They do.
They're critical, aren't they?
If you want to prove that something happened a certain way, they're critical, yes, sir.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, so, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
I'm asking you, not nobody.
Yeah,
Excuse me.
So go ahead and ask the
You,
question.
Dr. Rentschler, before this jury, have no idea where the point of impact was of this collision, do you?
That's correct. There's no evidence.
Play exhibit 2, please. When you were giving your estimate 10 to 20 feet, Dr. Rentschler, did you ever see this photograph before or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you look at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rentschler?
The way I explained it to you, yes, sir, 10 to 20 feet.
Details matter, don't they?
They certainly do, yes, sir.
Take that down, please. Did you speak to anybody today before you testified about Dr. Welch's testimony in court?
I did not today, no, sir.
Before today, did you speak to anybody about Dr. Welch's testimony?
I did not, no, sir.
At any point, did anybody discuss certain issues with you today that they said would be particularly important?
I don't believe so, no, sir.
When you began your testimony yesterday, before you even finished your credentials, you began talking about your work with the NHL and how important it was to use a 50% hybrid 3 dummy. Do you remember that testimony?
I did, yes, sir.
And you hadn't even finished your credentials yet. Was it brought to your attention that there was an issue in the testing because you or Dr. Wolf or you and Dr. Wolf chose to use a 50% dummy?
Not at all, no, sir.
In your preparation for your testimony, was it discussed at all that at the beginning you should get ahead of the issue and talk about the 50% dummy?
I didn't know it was an issue, no, sir.
Well, you know that the 50% dummy represents somebody who's 5'9", correct?
Approximately, yes, sir.
Approximately 173 pounds.
171, 172, somewhere around there.
And Mr. O'Keefe, how much did he weigh?
216, I believe.
How tall was he?
He was 73 inches, I believe.
So that is not a representative height and weight for Mr. O'Keefe, is it?
That height and weight, no, sir.
And so if you were making projections or analysis based on limb weights, they would be inaccurate if you didn't make adjustments, correct?
Well, they would certainly, the force on the limb would be less if you use a lighter limb. So if Mr. O'Keefe is heavier than the hybrid 3, and I use a hybrid 3, the forces I calculate would be an underestimate of the actual force acting on his body.
If you didn't make an adjustment, but you relied on the numbers from the test 3, the hybrid 3 dummy, ultimately the conclusions would be off, wouldn't they?
They would be an underestimate. Yes, the actual forces would be higher.
And so did you make any conclusions, or did you know that when Dr. Wolf did his tests using the hybrid 3 dummy, he didn't make any adjustments?
What do you mean? What adjustments would he make? You get the acceleration, but the acceleration's not going to change, and that's what we utilize. Then you can scale the weight of the body, but I'm not sure what he would have made adjustments for.
When you looked at the ratio, force and mass, if you use a lighter weight, the mass changes, doesn't it?
If you use a light, sure, yes.
And that changes the force equation, doesn't it?
That can, yes.
And so when you were discussing yesterday at the beginning of your testimony about the 50% dummy, had that issue been raised with you?
No, sir, it had not.
You had testified before, hadn't you?
In this case?
Yes.
Yes, sir.
And you knew there was a sequestration order?
Prior?
Yes.
Yeah, I didn't discuss the case with anyone, no, sir.
Well, you didn't discuss it with anybody, you said?
I did not, no.
Before you testified last year, you were receiving information from your employer about issues and testimony in the case.
The party that retained us told us things. I didn't break any sequestration. They were the ones in contact with the court. So it was my assumption that whatever they were telling me was allowed by the court. They were the client. I didn't discuss anything with them or tell them anything, but yes, they told us certain things.
Before you testified under oath last year, you were getting updates from your employer about details of this case, weren't you?
Maybe we can approach briefly.
Before you testified last year, you were receiving information, not from the defense, from your employer, about other witnesses' testimony during the event, weren't you?
I don't know if they told us about witness testimony. They told us about certain evidence. I had no contact with the court, with the prosecution, with the defense. I had no idea what was going on. We were retained by a certain organization, and they contacted the court. They were in talks with the court about, I guess, what we could or couldn't do. Anything I got was from that organization.
Voir 2, 118, line 15. Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you Are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare.
Yes.
It didn't make a difference to my analysis or conclusions.
Made no difference at all?
It did not. No, sir.
Would you agree it helped you understand what was going on during the trial?
I don't think it made a difference at all. No, it doesn't change the facts that I evaluated or the analysis I conducted or the conclusions I came to.
And so as you sit here today, you are denying that that information certainly helped you prepare.
How did it help me prepare? It didn't change the opinions I offered. It didn't change what was in my report or what I'm opining to or testifying to today. It hasn't changed anything I've ever testified to.
I'm going to ask you a very specific question. I want you to give me a very specific answer.
So just go ahead and ask the question.
Are you denying that receiving that information certainly helped you prepare?
Honestly, I can't remember. It didn't change my opinion. I don't see how it would help me prepare. I remember there was evidence about trace DNA found that we didn't know before. That didn't change my opinion then. It doesn't change my opinion now. It doesn't have anything to do with my opinion.
Details matter, right, sir?
Details can matter.
Details matter. So let's talk about detail.
Sure.
Are you denying that receiving that information certainly helped you prepare? Are you denying it?
I'm going to allow it.
Yeah, I don't think that it did. It's been a year, but certainly it didn't change any of my opinions or what I opined to. It didn't change anything with my testimony.
I'm going to ask you one more time. I'll ask you a different question. Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
I don't even think that it did. I don't understand that. I understood what was happening. I understood what the theory was. So saying that there's trace DNA doesn't change anything. Doesn't affect what my understanding of the trial was or what was happening or what allegedly occurred.
When you were traveling out to testify last year, you had phone conversations with the defense, didn't you?
I think I had like 2 phone conversations, 2 or 3.
So that sounds like a yes, you did.
Yes, there was one right before my qualification, my voir dire, where I talked to Mr. Jackson, and that was it. Other than that, I think it was just planning and scheduling.
Mm-hmm. Was there any discussion on how you could portray yourself as independent?
I don't believe there was.
So you don't believe?
Yeah, there was no need to.
That's not the question. Details matter. Was there any attempt?
So the objection's sustained. I'm going to strike that, folks, okay? Questions, Mr. Brennan?
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
Did you have a conversation about that you were thinking about taking an Uber?
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
No, did you have any bias for in you?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people. And so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich. Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
When you sat at the table and eat, did you just eat your ham sandwich, or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
Did you laugh along?
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
I don't, at this point, I don't even remember.
Let me alert you to something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea, possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year ago?
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change. You remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
And after you finished your ham sandwich and then you told us you stood in the corner, you got a ride back to the airport?
I did, yes, sir.
Yeah. After you got back to the airport, ultimately your company billed the defense for your time preparing and traveling and testifying?
I believe they did.
Well, you wrote your bills down, didn't you? You wrote your time down?
Well, I don't know who gets billed to it. I think it was actually, I wrote my time down and it was the same time code for the original employer that we had. I'm not involved in billing. I don't know who the bill goes out to. I just put my time in and do my work.
Do you know that the defense paid that bill?
I have no idea if they paid it or not.
And then now you have a new contract with the defense. Or I should say you have a contract with the defense, don't you?
I assume ARCA does. Again, I'm not involved in that. I don't do any part of the financials. I just do my job.
Do you keep your billing?
I enter my billing every week, yes.
Do you know how much you've been paid so far in this case?
I haven't been paid anything. I'm a salaried employee for ARCA. I have no idea how much ARCA's been paid.
How much has ARCA been paid because of your work so far?
I have no idea. I'm not involved in the financials, sir.
You have no idea how much time, how much compensation your company is going to get for the work that you've done and continue to do on this case? You have no idea.
It's not my concern. It's not my department, so I don't.
That's a no?
That's a no, sir.
Now, when you communicated with the defense, you texted, didn't you?
When?
At any point.
There were some texts, yes.
And at some point, there was a court order for you to bring a copy of your text?
I believe so, yes.
But when you say you believe so, details matter.
Yeah.
Do you know whether there was a court order for you to bring your text?
I believe there was, yes.
Did you comply with that court order?
I complied with whatever I had.
Did you have any of the text messages?
I don't believe so.
What happened?
Well, there were like 2 text messages about where I could get my ride and what time. And so after that day, like I do many times, I'd probably erase those texts.
When you say probably, did you delete the text that you had with the defense last year during the trial?
Again, I had like 2 texts about scheduling, and I'm sure I deleted them like sometime around that time, like I do with most texts.
Did you ever use Signal?
I did not, no, sir.
Why not?
I have no need to.
Why would you have a need to?
I'm going to allow it.
I wouldn't have a need to. That's why I said I don't use it.
What's Signal for?
It's for, I think, for encrypted messages.
Do any of your colleagues use Signal to have conversations with their clients?
I'm going to allow that you're aware.
I have no idea what my fellow employees or cohorts do.
One of your fellow employees is a gentleman by the name of Dr. Wolf. Yeah. You worked very closely with him on this case, didn't you?
I've worked with him on this case, yes, sir.
And working with him on this case, were you aware of his habits, of whether or not he used encrypted apps like Signal?
I'm going to allow it.
I'm not aware of Dr. Wolf's habits, no, sir.
When you worked on this case, when you began, you worked with a gentleman by the name of Mr. Klein?
But Scott Klein is another engineer at ARCA that worked on the case, correct?
And you worked with Dr. Wolf?
That's correct, yes.
You worked as a group?
Well, I mean, we all worked on the project together. I'm located in the Pittsburgh office, and Mr. Klein and Dr. Wolf are in the Philadelphia office. So we didn't physically work together, but we worked on the same project, obviously.
When you first began your testimony yesterday, you said that you were restrained in what you could do. Do you remember that testimony?
I do, yes.
And when you said you were restrained, were you attempting like a preemptive strike because of certain things you didn't do to try to ward off any questions about that? Objection.
Sustain.
Let me ask it this way. Were the rules different regarding your initial investigation for you as opposed to Dr. Wolf?
I don't know that they were. I don't believe they were.
Did Dr. Wolf have free reign to do whatever he wanted? Objection.
Sustained.
Were you given free reign to do whatever testing you wanted?
I don't believe we were, no.
You, though, were you?
Was I?
Yes. Were you given free reign to do whatever testing you wanted?
I mean, there was budgets and we had to stay within certain values. So I wouldn't say I was given free reign because I couldn't do whatever I wanted.
Did anybody tell you what tests you could or couldn't do?
I don't think there was a list of specific tests or not, but you would discuss what would be done or what we could do and what the cost of those tests would be.
Were you free to suggest any tests that you wanted to?
I'm assuming I could suggest whatever I wanted to, sure.
Were any of your suggestions denied?
I can't remember. I don't know that they were. I mean, we had what we were constrained is what the client wanted to know. And so we tailored our tests to do that and tried to keep the budget and the cost of what we did in our analysis down for that very purpose.
Could you have suggested crash tests?
Probably could have suggested whatever I want.
Did you suggest crash tests?
Honestly, I don't know. I mean, it might have been brought up, but pretty sure that would not have been within the budget. So
I want you to be detailed. I don't want you to guess.
So without that preamp, go ahead and just ask the question, please.
Did you suggest doing crash tests last year?
I can't remember. We obviously didn't, but I don't know if that was brought up or not.
Do you, since your memory is difficult?
Sustained. Okay.
to remember things, do you write them down?
That's one of the ways you can do it, sure.
Do you do it? Do you write down things so you don't forget?
Depends what it is.
Okay. You provided a CV, which is a resume.
That's correct, yes.
Resume outlines your education,
Yes, sir.
areas of specialty,
Correct.
and then it highlights your accomplishments as far as the focus of your specialty or the focus of your profession, what you like or what you do a lot, right?
Some of it, yes, sir.
So, for example, you have a number of publications that are peer reviewed.
Correct.
And peer review publications mean that you've written something that's been evaluated and considered by other experts in the industry and have been adopted or recognized, correct?
Well, that it's been published, yes, sir.
You have a long list of peer-reviewed articles dating back to 2003. Is that correct?
Yeah, as I said yesterday, most of my peer-reviewed articles are all written when I was in graduate school. Correct.
Have you had any peer review articles since 2003?
Probably not. No.
And your peer review articles, 2003, deal with the evaluation of selected electric-powered wheelchairs.
That was one of them. Yes, sir.
The next one, intelligent walkers for the elderly.
Correct.
Comparison of fatigue life for 3 types of manual wheelchairs.
Yes, sir.
Evaluation of a pushroom activated power assisted wheelchair.
Correct.
Displacement between the seating surface and hybrid testing dummy during transitions with the variable configuration wheelchair.
The hybrid 3. Yes, sir.
Assessment of manual wheelchair ride.
Correct. I was looking at forces and accelerations on the body. Yeah.
Fatigue life of 2 manual wheelchair cross brace designs.
Yes, sir.
Evaluation of selected ultralight manual wheelchairs.
Yes, sir.
Augmentation of 100 key ISO wheelchair test dummy to accommodate higher mass.
Yes, sir.
Okay. And so you would agree that all of your peer review articles deal with wheelchairs?
Well, wheelchairs and the kinematics and kinetics forces associated with propelling wheelchairs and injuries associated with that. Yes, sir.
Do any of them deal with pedestrian collisions?
No, they don't.
You've written a book chapter?
Yes, sir.
Smart technology for aging?
Yes, sir.
And again, nothing on pedestrian accidents?
That's correct.
Expanded abstracts, you've written a few?
I have, yes, sir.
Suffice to say, dealing with wheelchairs?
And assistive technology, that's correct, yes, sir.
Any have to do with pedestrian collisions?
I don't believe so, no.
Looking at your CV, you can note any area of specialty you'd like, correct?
You can put down whatever you like, I suppose, sure.
Sure. Have you listed any specialty as pedestrian collisions?
Well, not specifically. That actually falls under impact, biomechanics, biomechanical injury causation. So I didn't list it specifically, but it certainly falls under the actual expertise that I perform.
Now, doctor, when you worked with Dr. Wolf, did you have a chance to look at his report?
I did, yes.
If you saw anything in the report that was off or mistaken, would you have an opportunity to discuss that with him?
I'm sure I would, yes, sir.
Did you find anything about his report that was wrong as far as data?
I don't recall. If I did, I probably would have talked to him, but I don't recall.
You and Dr. Wolf were collaborating together, weren't you?
Yes, sir.
And when you collaborate, you relied on each other's data at times, didn't you?
To some extent, yes.
Some things Dr. Wolf did, you relied on ultimately for your interpretation and your conclusions.
I did, yes.
Did you write a report and talked about the acceleration of the ATD, the test dummies, regarding its hands and arms?
I did, yes.
When you wrote your report talking about this very specific data, do you remember what you determined was the acceleration for the ADT right hand at 29 miles per hour? How many G's that was?
Let's see. Accelerations for the right hand.
Page 6.
Yeah, it looks like 863 Gs.
And when you were comparing data with Dr. Wolf, if something was different or off, would you correct it?
Oh, I'd talk to him about it, sure.
Okay. Did you ever talk to him about his collection of data regarding peak acceleration that the arm and hand experienced at a 29 mile per hour collision?
Well, when I think that 863 is from 1,000, the CFC 1,000 hertz low pass filter. And in his report, he used a lower number from a 180 hertz. So they're both accurate numbers. It's just how you actually filter the data.
So you know what I'm talking about, right?
I do, yeah.
Yeah.
And I ended up using a lower number than when I did my calculations.
Could we have Exhibit 1, please? You've talked a lot about this photograph. Do you see it?
I do, sir, yes.
And you described, well, you didn't describe, you read that these were superficial abrasions, correct?
That's the diagnoses, yes, sir.
Any of those wounds a puncture in your mind?
I don't make medical diagnoses, so I'm not going to comment on that, sir.
Well, you talked about x-rays and injury. I know you don't make medical diagnosis, but you were very careful to be detailed about what this was. Not a laceration, right? It is a superficial abrasion.
That was what was diagnosed by the medical records, yes, sir.
And you were very careful to make that distinction when you were critiquing Dr. Welch. Correct?
Sustained in that.
And so you also looked at x-rays, didn't you?
Yes, sir.
And when you looked at them, did you try to give the impression that you've read them, even though you're not a doctor and you can interpret them?
Sustained.
Were you trying to interpret them for us?
No, it was actually interpreted by the medical examiner that there were no acute injuries.
So when you were giving all that information to the jury about the x-rays, was that your personal opinion or were you just regurgitating something you had read?
That was the medical examiner's opinion, but certainly you can look at the x-rays and see that there are no actual fracture lines or space displacement between the joints. But it's the medical examiner and his diagnoses that I rely upon.
So when you were going through an explanation of all these different photographs and x-rays, you weren't trying to portray that you were giving your own personal opinion about it?
I don't give diagnoses, but if there's no fractures on an x-ray as diagnosed by an MD or physician, you can look at the x-ray and then you can see why there are no fractures. You can look at the x-ray and see where the fractures are if there's a diagnosis. So the diagnosis was no fracture, no acute injury, and that's certainly consistent with looking at the x-ray itself.
So when you were looking up the x-ray and holding it up, was that just a prop? I mean, were you simply just regurgitating what you read in the report, or were you doing a certain kind of, were you doing any kind of analysis yourself when you were sharing with us what those x-rays showed or didn't show?
The analysis is that there's no fracture or acute injury, and that's what the medical diagnosis is, and that's what the x-rays showed.
Are you giving us your opinion, or are you regurgitating what you read in a report?
That is what the medical diagnosis is, that there's no fractures and no acute injuries. That's what the medical opinion is.
So you're regurgitating what's in the report?
Sustained in that form.
Did you see any MRIs?
I don't believe any MRIs were taken or performed.
In x-rays, does it depict deep soft tissue damage?
Normally, it does not depict soft tissue damage, no.
How about muscle tears?
No, it does not.
How about tendon tears?
Not normally, except you can see laxity in the joints if there is tendon or ligament tears. Normally, you can see laxity in the joints, but it doesn't show the ligament or the tendon itself.
Nerve injuries?
No, sir.
Avulsion fractures?
Yes, sir.
People sometimes get MRIs to see if there's a fracture that doesn't appear in an X-ray. Yes?
Sometimes X-rays are the best for looking at bony fractures. MRIs looking at soft tissue injuries.
Speaking of wounds, you've cited a number of references, a number of materials in your reports, haven't you?
I have, yes, sir.
And one of them that you've cited is forensic pathology.
Yes, sir.
This is a legitimate source to you, correct?
Yes, sir.
And you've relied on it for at least part of the basis of your study or opinions.
Well, I relied on it because it speaks and looks at the difference between, for instance, a laceration and an abrasion.
A person could be struck by a motor vehicle and not indicate any bruising to that area, wouldn't you say?
At what speed, what part of the vehicle were they contacted, what part of the body were they contacted? It depends on the amount of force associated with that. There's a number of variables involved.
Okay. Does the absence of a bruise indicate that there was no blunt force trauma to the area?
I'm going to allow it. Can you answer that?
Well, the absence of a bruise, can you repeat that again?
You were talking about bruising.
Yes.
Does the absence of a bruise necessarily indicate there was no blunt force trauma to an area?
No, you have to look at all the evidence and you have to look at the force. If there's 4,000 pounds of force applied to the body or to the arm, then certainly you would expect a bruise. And if there's no bruise, then you would have to question if that impact or contact actually occurred. You don't just look at that by itself in isolation. You look at all the variables and facts involved with the case to determine if an injury occurred.
Have you ever seen collisions where more than one person was hit or struck by the vehicle?
Multiple pedestrians, you mean?
Yes.
Yes, sir.
And have you ever seen in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience.
I'm going to allow that.
Have you ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different or in some cases no injuries? Has that ever happened in your study?
Sure, because it depends where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people in different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries? In another case where you look at where there was a similar type collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cards? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring.
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1,
Have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. The testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
Well, we'll get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
Okay. You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
Rise to the jury. Front door break.
I think any
Wow.
other lawyer but Jackson needed to make that statement. If Yannetti had made that statement, I'd be a lot less pissed off. My mind's just going back to the first trial when Alan Jackson was mocking Jen McCabe during his moment with her there. She was talking about being harassed, and he's like, "Oh, I bet that was terrible, being a snarky jerk." I've seen enough of him and his bullshit. He's the last guy I want to hear with his opinion about comments. Whether it's fair or not to call out the comments, I just don't want to hear it from him. Oh, Jeff, don't mess with me, bro. This is not the right time for a Lessitas latex gloves, man. No.
I don't know. I guess they're just taking their lunch now. Or no, it's a sidebar.
Yeah.
I mean, he's got him. He really rattled him right out of the gate. And it's interesting. He asked him about the question about taking the Uber because that was very specific.
So how do you guys think the cross is going?
Brutal. Brutal.
It is brutal.
Yeah.
He's certainly bringing out the bias of the witness.
Yeah,
And the chumminess with the defense.
Yeah.
I think that question about should I take an Uber so I look more.
So it will be the lunch and recess, and we'll take an hour.
All right, so court, please.
Yeah, when he said he would have taken an Uber if he was wanting to appear
Mm-hmm.
more. I know, that was rough.
that
Instead, I
was a lot
just
of
hung out
stuff.
with the defense and had a sandwich. And
Well, no, that was a very
he's
pointed
just
question,
so he does not come across objective at all. He comes across so anti-prosecution. Talk about confirmation bias.
Right. No, I think that that question, going back to it, though, was very pointed. I suspect that Brennan must have video of
I
that
assume
conversation.
that.
Yeah.
Yeah. Did you know there were cameras there?
Well, for the lunch,
snapping?
definitely, but I'm assuming that the conversation they had must have been when ID was in the room with Karen and her team, so they must have captured it.
Right. And he deleted his text messages too, hey? So it's not just Wolf.
Yeah. I butt dials are a big deal, but everybody coincidentally leaving. And I'm sorry, but if you only have 2 text messages, what's the urgency to delete them?
Right. Yeah, like that takes up a lot of data.
Right.
You know, I needed the storage, the two text messages, all 5 kilobytes.
Yeah. Yeah, but 3 messages, someone says 3 messages, not 100. Well, I mean, Wolf did delete 100 messages. Wrenchler is saying he deleted 3. I'm going to take him at his word, and I'm going to say that arguably deleting 3 text messages is stranger than 100 even. Because 100, I guess you can kind of hide behind the plausible deniability of why I was freeing up storage. Not that I believe that, but it's a lot more plausible than why, coincidentally, your coworker who is working on the same thing with you has to delete their communications with the defense team as well, and they only have 3. Everybody deleted them. Everybody deleted them. The defense deleted them. The ARCA, both employees from ARCA deleted them. Everybody deleted them.
Yep.
Can you guys hear me okay?
Yeah,
I can hear you.
Fine.
Okay,
Yep.
I'm not hearing Kate, I guess.
Oh.
You know, this could just be wackiness with StreamYard. It's been doing some weird stuff lately. It might be that.
Yeah, I can't hear Kate at all. So if she's saying something, I can't agree or disagree. Weird. Boomer, I can hear you fine.
And I can hear all of you guys. Yeah. It's strange.
That's
Margaret, weren't they compelled to hold on to those text messages if you're a witness, an expert witness? That was mentioned to me. I don't know if that's true or not. I was told that you're sort of compelled to hold them for like a minimum of a year, just for moments like this.
Geez, I'm not sure. You would think it would be possibly part of discovery. I haven't run into this before, though. On any of my cases, obviously, it's a new issue.
Maybe it's unwritten. You know what I mean? Maybe it's not a policy, or it might just be professional practice, like sort of an unwritten rule. But
well, there's an issue where, if it's part of discussion, if it's part of a discovery or not, it depends on what the discovery order is.
Gotcha.
Right?
Are you still with us here, Kate?
Yeah, I'm still here.
Do you hear Kate?
Yep.
I do. Brother man
Yeah,
Dan is in the back there.
Oh, okay, great.
Hi, Dan. I don't hear you. Oh,
No, I'm
he's in
bringing
the.
him up.
Yeah.
Of course you do. I'm right here.
No, there you are. Hello.
Hey, how's it going, guys?
Good.
What's up, man?
Not much. Just interesting. I think Hank is just a superb attorney, and I think he's showing off at this point.
Is Kevin in or not?
No, I'm not.
I can't tell who's in and who's not.
No, I don't appear so. What do y'all think about the whole X-ray thing now that Hank kind of talked about it?
I think it's pretty harmless.
Well, I just can't believe still that I thought they might have been fake or the X-rays of the wrong guy, because it's crazy that this is the first time I'm hearing about it. But I do like the fact that he took it to another level and said, no, there's no MRIs showing soft tissue damage and all of that. But still, the X-rays are bizarre. I mean,
they were interesting X-rays. I mean, the hand was in a weird position. It appeared that, I don't know how many X-rays they had, but it didn't appear that they had multiple X-rays of the same body position or the body part. For instance, I had X-rays on my arm, and when they did my X-rays, they moved my arm in like 4 or 5 different positions to get the appropriate photos to determine if there was any damage to the to the bones and whatnot. And it didn't appear that they had that. It appeared that they just had one of the hand, and that was it.
yeah. I mean, how often do they actually X-ray like that in the hit and run case? I don't know.
That's true.
Yeah, I had multiple views. I broke my wrist actually a year ago, this past week, and multiple views. But of course, that's because they want to fix it. Whereas if you're already gone, they're not going to do that. No.
Yeah.
They're not fixing it.
So I'm even seeing in our chat here, there's a few people. I don't think they're all trolls. They're saying they're thinking Hank's going a little too far. They're not liking his approach here. I personally am. I kind of like to see him, serve it up to that ham sandwich dork. But that's me. I'm biased is all hell. But what do you guys think? You think Hank's going a little too far, a little too aggressive?
No. Because the witness came across as confrontational from the get-go.
Right.
And he's not like this old, frail man or woman. He's You know, you can go after this guy, absolutely.
Right.
And challenge his findings. I think Hank has to do it.
Yeah, I agree. I don't think he's being too heavy-handed at all. He's just doing what he's there to do.
I mean, he's calling out the obvious. There's questions they don't want to answer, and he's asking them, "Why don't you want to answer them? Do you not like these questions?" You know, those type of things. But he's only calling out the obvious. He's not adding to. You know what I'm saying?
Yeah. What do you guys think about all of Hank's little comments? He did that in the last trial as well, the Whitey trial. You know, what is something funny?
Yeah,
I love it.
I don't mind him. I don't mind him given the subjects that he's putting these characters that he's treating that way. I have no sympathy for them. I mean, my opinion is they're mercenaries. They're not to be trusted, but that's just me. I don't mind it at all. I just hope that my enjoyment of this isn't, me not looking at it critically, like just because it's entertaining me. Is it working with the jury is all I really care about. And if it isn't, I would say we could do without it. But on an entertainment level, I'm enjoying it. I don't know if it's going over well or not. I'm not in the room.
Yeah. I also found that the witness was very argumentative, so Hank was recently trying to get out, with each experiment, how the plastic pieces would break differently. Now that's natural, right? If you throw a glass against a wall in the same spot, it's going to break differently every single time, but the witness wouldn't even give him that. So, I mean, I don't think anything ever would break in the exact same fashion. No way, right?
No.
So I thought it was a good point that the witness could have conceded on, yet argumentative. And I don't think the jury's going to like that. That's common sense. It's not going to break exactly in the same way every single time. Even it just won't.
Yeah. Yeah. And, I think there's also a difference in how Hank is also like treating these witnesses. We go back to, like, for instance, Jen McCabe. The judge had to tell Alan Jackson that, the witness was responding in kindness. That's not the case with these witnesses. These witnesses aren't responding the way Jen McCabe responded. These witnesses are deflecting, they're defensive, and in some ways just flat out trying to avoid answering the questions.
Oh, absolutely. Absolutely.
Or like Lapisato being a nerd right out of the gate. Like, she was snarky. It's not noon, 6 minutes away. Whatever. Darth Lapisato.
I know.
Get out of here.
Oh. But at least, I think an objective witness, and I know he was hired by the defense. Everybody knows that, but concede on demeanor is important, right? So you can still testify for the defense, but, concede a few points where, everybody's common sense would say, that it would break differently, and be a little more courteous than that. That's what I would instruct my expert witness. I would say, listen, don't be combative. Just, I respectfully disagree. It would happen this way. And I think he'd receive more points with the jury. But I think Hank's doing a great job too. I agree with the commentary so far.
And I'm seeing, statements like, well, not there's a lot of them, but there's a few. They're assuming that the jury isn't liking what Hank's doing, or maybe less strongly, they're worried that maybe Hank is not impressing some of the jury. But honestly, I mean, that when it's all said and done, as somebody else pointed out, unless he screamed about his hands, I mean, I don't think anything Hank does is going to be topped by the madness that we saw with the defense, and especially with Alessi. There's no way they're going to remember Hank being a little snarky with Sandwich Guy and totally forget about Alessi wigging out. It's not happening, man. Like,
I love how you called him Sandwich Guy. That's funny.
Well, I mean, yeah, whatever. Yeah, that dude, right?
Now from now on, I'm going to think of him as sandwich guy.
Right. But I mean, you're gonna be taken away, like your opinions of the defense and the prosecution, right? You mean mulling it over. I can't see anyone going, man, that Hank he's uncontrollable, he's out of line. In contrast to Alessi, like, dude, he's unhinged.
Unless he does come across unhinged, yeah.
Oh yeah.
Very passionate.
Smitty Lee asks me if okay.
Will
I be covering trials in true crime? Will I be covering trials in true crime on my new channel? Honestly, I don't know. I'm trying to figure out what my new channel is going to be. Honestly, I wasn't even going to do one until you guys said, hey, you know what? I'm sick of not seeing one. So I threw one up. I'm not even sure what I'm going to do yet. I have videos that I'm making.
Good.
I'll put some of them up, but we'll see.
I keep trying to put out content, and it's so hard to watch the trial all day, be on the live stream, and then do court TV or something. Yeah. I'm not complaining, but prepare for that so you sound halfway smart, and then go and put out a video. Like I've got a video almost ready to go, but I don't want to put out something that's not quite ready yet.
Oh, I know. I've got this weird Canadian content. Sure. I mean, honestly, anything I do is going to be a little odd. I'm definitely a different character here than I am in other environments. Like I've said before, out of full respect for Kevin and what he's got going here, I'm working a lot cleaner. So I'm assuming some of the people that subbed from here might be like, no, I'm not cool with this. But I am working on a video I've re-edited a few times.
Good.
With sort of you guys in mind. I'm taking out some more objectionable parts. Like maybe I'll have to do 2 versions. I'm not.
Yeah, maybe you do 2 channels.
Honestly, yeah, I think
that's not a bad idea because people really like you on this channel. So,
right. And it's a different vibe here. So I might, I don't know.
That's not a bad idea. And then you can still have, Yeah. You could still have you can have a naughty channel and a nice channel.
Right. Exactly. I'm going to have to. I think I'm going to have to. Thank you, Dr. Russell's Lemon. Meow. Because like most of the things I've done, especially like with Kate and Masshole, I mean, it's been bizarre, sort of trolly, prankish, bit weird stuff, and it gets a little dark. It gets a little weird. So we'll see. Yeah, rated G. I mean, I think I'm like PG to 13 here a little bit once in a while.
No Cyrax re-uploads. That's all.
Yeah.
No, I'm not gonna. I'm not gonna be doing none of that though, for real. Yeah. But it's a little in-house. But Kate, I got a short video of the professor. He's an unhinged streamer as a character, another Canadian. And I'm doing a version I think that I will put up on the Boomer channel maybe by the end of today.
Oh, good. I'll look for it.
Yeah.
What's the topic?
Yes, Kate, that did work. Sorry. Yes, I heard. Did you hear Kate just now, Margaret?
No.
Oh, bummer.
I did not. Did she ask me a question?
It's got to be on her end then. Yeah.
I'm hearing everybody but Kate. It's weird.
That is weird.
I hate to leave the studio because I'm streaming to my audience on It's a Crime Media. So I don't want to.
That won't disrupt it. It won't disrupt it.
Oh, Kate's saying that won't disrupt it. And also I would try that last case, but go into your settings. If you look in the bottom in the backstage.
Yeah, settings.
And then click over to audio.
Yeah.
Where it says speaker, maybe turn it to something that you're not, like if you're using speakers, like change it. If you have 2 options, change it to the one you're not using and then back to the one you are using. Sometimes that helps.
I'm going to try that.
If she has to.
Sorry, I can hear Kate now.
Oh, good. There you go.
There you go.
Now I'm going to do my
Boomer solving problems every day.
Yo, I'm going to do Geek Squad stuff on my channel, guys. We figured it out.
That's
We
Kate.
found
Your
his
headphones
niche.
suck.
Thank you.
I'll help you out.
Yeah.
Thank you.
No worries.
So, Kate, I wasn't deliberately ignoring you. If you asked me any
No,
questions,
that's fine. It's been happening to me. I think it happened the other day on here. It's happened to me on
Yeah.
TikTok. I'm not sure. It's on my different devices, so I think it must just be a glitch with what's going on with streaming. I'm not sure, but
so what did you think, Kate, about the cross-examination so far? You've probably been talking about it, and I don't know what your opinion is, but I'd like to hear it again.
I mean, blistering. I think what I was trying to say is that he asked a very specific question about the use of an Uber, the suggestion that an Uber would make Rentschler look more independent. And I'm surmising that there must be video of that conversation because the camera crew was with them in their war room. So I'm assuming that they must have probably documented that phone call. And then he followed it up with the lunch, which we were all aware of. The pictures have been circulating, but obviously because of that documentary crew, Hank Brennan has access to more than just pictures of them together. Actually, the contents of their conversations, including mocking the prosecution and laughing about how they got one over by focusing on physics. Right? Oh, physics don't change. Ha 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 ha. And Rentschler's reaction to that was very, very weak and defensive.
Mm-hmm.
Hmm.
Mm-hmm. Yeah, he's very defensive. He's just, yeah. I think it's going to hurt him. I mean,
And he
his
denigrated
direct
his
was
memory.
Yeah.
Too. He got him so worked up that now Rentschler is starting to chip away at his own credibility by denigrating his own memory and saying, I don't even remember what I had for lunch. I don't remember my conversation. I don't remember anything. Like that.
I know.
Yeah.
It's actually effective cross-examination because Rentschler, he was good on direct, and let's admit it, he had a lot of statistics and blah, blah, blah. But this is hurting him tremendously. It's what the jurors may remember, I think. We shall see.
Yeah, until Hank starts pounding his fist and screaming to the ceiling, I don't think he's gonna really tip any of the jurors negatively towards him. I don't see it. He doesn't behave like a maniac. I mean,
I don't know much about cross-examination, but I talk to a lot of people on the internet, like in this, like a panel or whatever. And, sometimes I think you can ask questions in a pretty calm and level way and just throw people off. Like, so my frame of reference, I'm sure you remember, Boomer, when I was talking to Jeffrey Sutton, for instance, right? Yeah. So he was a registered offender who was caught taking videos of children at a park and posting them on the internet. So we had a conversation about his charges and, what happened, what got him convicted, what got him charged, what got him registered, and what he was doing now. And so obviously, if you're a registered offender with those proclivities, you probably don't want to talk about it in public that much. But I was able to get him to do it because it's like, if you can calmly and kind of ask very pointed, measured questions and then box somebody in, you can start to kind of move them around, right? And I think he's very good at that, Hank Brennan. So, he's not asking the question. Jackson asks questions and he wants the jury to take away the question more than the answer most of the time, right? Whereas I think Hank Brennan is more understated and he wants to use the question to get to the answer and any sort of reaction around that, right?
Yeah.
It's masterful.
It's again, not to be like too hyper focused on boxing, but really it's I know that better than I know law, and it's like he's not telegraphing when he does that. Like you say, Kate, if he's asking an explorative question to get further down the road to get where he eventually wants to be, the subject being asked that question, they're not seeing it telegraphed. They're not following it like they would Jackson, who, like you said, it's like as if his question is what he wants to be resonant. It's interesting.
And by the way, somebody on the comments, I just answered a comment. Somebody asked me if the defense is allowed to coach the witness during lunch, absolutely not. They're under a sequestration order. So
Right.
that's the answer there. Absolutely not.
They're not supposed to, but are they doing it?
Well,
Kind of looks like it, doesn't it? Yeah.
I know. Who knows? They're probably in a conference room behind closed doors. Although no, then somebody could see them. So they have to be very careful because there are a lot of eyes in that courtroom area, in the hallways. They all go into the same places for lunch. So they have to be very careful. Yeah.
I just want to say thank you to all the awesome comments in the comment section
Yeah.
about me. I appreciate you guys. Somebody had asked me, what do I think about the prosecution in Boise for the Bryan Kohberger case? I don't know. I've never seen any of these guys in trial or anything like that as far as the Idaho goes. I probably don't think it'll be to this level of what Hank is, just because I think Hank is, he was a defense attorney for some pretty prominent people. And, you don't become that way without being very good at your job. I'm not saying that these guys aren't, just saying that, my expectation wouldn't be as high as Hank's, but the difference there is I think Hitler's a much better judge than what we're seeing here. Just my opinion. Although I do think that, I think that like the sidebar stuff is very distracting. Like I think Kevin mentioned it earlier. She has no control of the courtroom, and in certain times it does seem like that way. I had on Anjanette Levy from Law and Crime Network on my channel last night. We were talking about the Idaho case, but we first started off with Karen Reed, and I was surprised that, to me at least, she seems to based on what she said, it sounds like she thinks that it's pretty obvious what happened, and that Karen Reed may have hit John O'Keefe. I thought it was interesting from somebody from a network that large.
That's interesting.
Yeah, she said the evidence seems a lot more clear than what people are trying to make it seem, is exactly what she had said. And I was like, I couldn't agree with you more.
So Dan, can you put in the comments or somewhere the name of your channel for people that might not know you?
Yeah. It's well, if I put it in the comments, for some reason it only shows up on my.
Yeah, I know. Well, or yeah.
But it's the DT show, or you can search up Drunk Turkey Show.
Oh yes, okay. Yep.
I'm gonna add this to my name, DT Show. Drunk Turkey Show.
Yeah, that's what I do. Yeah, it's a crime media. Yeah, that'd be nice because I would love to watch that live. Was it live stream that you did?
It was live stream last night. Yes, ma'am.
Okay, I'm gonna go watch it. I bet it was good.
It was good. It was good. It was a great conversation. She's very informative, well versed on the topic, and so it was an awesome conversation. And yeah, we started off with Karen Reed, and then we kind of talked a little bit about the supporters for Karen Reed and the supporters for Bryan Kohberger, and then we went into Bryan Kohberger. But I was I didn't know what her stance was, when I brought up Karen Reed, and I was pleasantly surprised.
Wow. Yeah. I'm surprised too. I can't wait to watch your channel now. People are saying, "Oh, he's so good." Can't wait.
Well,
he really is. Yeah.
I've had some pretty interesting guests, especially as of recent. I've interviewed Steve Goncalves, the father of Kaylee Goncalves, one of the murder victims.
Wow.
I've also interviewed Howard Bloom a number of times. He's the author of When the Night Comes Falling. And most recently, I interviewed him right after the Dateline special, where he had a prominent role in. And so we got to the bottom of a lot of the stuff that came out there. And today I just found a survey that was sent to me that correlates with Bryan Kohberger's email address that we're going to break down tonight. And so I'm looking forward to that one. Yeah.
I'll have to catch up on that case. Karen Reed just takes all of my time and energy.
No, I hear you. I understand. There are some times like where, because I've been I'm the type of person that gets hyper focused into something, and I end up tuning everything out. And when I get intrigued by something, I dive deep. And I was kind of worried because I've dived really deep into this Karen Reed case, and kind of just talked about some of the things that have broken in the Bryan Kohberger case. So last night when I had Miss Levy on, I was like, man, everything in my brain right now is Karen Reed. So
Right.
hopefully I can pull up some information, and I think I did all right.
Yeah. I tried covering Diddy and I'm like, I can't
Oh
do it.
God.
No way.
Have
Can't cover
nightmares.
both, you know? If it
Yeah.
wasn't on
That's
the same
nightmare fuel, that
time.
Diddy stuff, man. And like,
I
I don't want to
know.
hear that about Busta Rhymes, man. I used to listen to him. Like, what the hell?
Yeah, I know.
Yeah, right. Not Buster. What?
Well, now you know
I
why
see
they
G-
call him Busta. Just kidding.
Oh no, that's horrible. I see Jihad Gina saying, yeah, but have you interviewed the Dark Lord Chuck Stegall? Jihad Gina, no, he interviews
I have.
people who have heard of. That's more, yeah, and yes, definitely.
I have all the best guests. I have
I would be-
every weirdo on the internet you can imagine.
That's
I would
great.
be lucky to
Released
get
my
Chuck
channel,
Stegall.
possibly
Yeah.
flash their genitals at some point in a fit of
Oh my
anger.
God.
Like,
It may have happened, yeah. You know,
once or twice, yeah.
Yeah, yeah.
More than
The
one
internet's
occasion.
a strange place. That's really my interest with the Karen Reed case, like the Diddy case.
Yeah.
I'm not a true crime person usually because I find it to be, and like this is not any disrespect because I know most people here are true crime people, but for my taste, especially when they're like open and ongoing cases, it feels a little too voyeuristic for me most of the time.
Yeah.
You know what I mean? Like I don't love the idea of like people involved in like a criminal proceeding becoming like daytime TV that much to me. Like I just think that like the caveat, and I definitely am horrified about what happens on social media with it. Most of the time,
God.
like my intersection with the true crime community has been heavy criticism about a prominent member, such as like Bullhorn Betty or Benny
Right.
Keys or Doug Hutton. And so I don't really have any other intersection with the true crime community than like identifying, or Jim Terry was another one that I went pretty hard at, you know,
Oh,
just
yeah.
like these people that I consider to be kind of like nefarious bad actors. Because
Right.
you know, I just like I think it might be a Massachusetts thing too, like a Northeast thing, like that stoicism. Like I really, really, really think that people need to start respecting other people's and their own privacy more in today's digital age, you know?
I agree. I know somebody asked me about the name Drunk Turkey Show, where did it come
Yeah.
from? I was not, when I created the podcast, true crime was not anywhere near on my radar. I created the podcast to talk about things like conspiracies and aliens and 9/11, the things that Kevin was
Nice.
referencing earlier.
Yeah.
Yeah, dude, I went hard into that stuff for years, man. Yeah.
Yeah.
I like that kind of stuff.
Yeah, that was, in fact, on July 2nd, I have Mark from Wandering Wolf Productions on. He's done a lot of the ancient civilization type of ventures.
Nice.
He's gone out to Egypt and to Göbekli Tepe and those type of things. He's actually worked a lot with Graham Hancock and Jimmy Corsetti, and I'm going to have him on my channel. We're going to talk about what was found underneath the pyramids of Giza.
Oh, God, I'd love
That's
that.
awesome.
Yeah,
that's
so-
cool.
Yeah, we're going to go into that.
Cool.
Yeah,
Wow.
that was my bread and butter. I had Jon Stewart, not the comedian, but he spells his name the same way. But he was a politician that ran for governor in Chicago. He actually ran for president as an independent at one point, but yeah, it was more of a publicity thing. He believes in aliens and things of that nature, and he had some information about it and stuff. So we had him on the channel. But what ended up happening was Richard Allen ended up getting arrested. And I told the guys, because I was kind of interested in that case a little bit when it first happened, the Delphi case. I told the guys like, "Hey, let's cover it." You know, I used to be in law enforcement. My one of my best friends, Jaime, he was like super fascinated with like serial killers and things of that nature. And then my buddy Blue, who was also on the channel, he was in the medical field. And so when we started covering it, it just was kind of second nature almost, and everybody kind of liked it. And they're like, "Hey, cover true crime." And then Bryan Kohberger, the murder there in Moscow, Idaho happened, and we started talking more about it, and that became our niche, so to speak. But
Right.
yeah, no, the name came from, so when I decided to create the podcast name, it was around Thanksgiving time, and I was watching the movie Rocky. And there was a scene where Rocky's told that if he takes another punch, he's going to be punch drunk. And so I took the holiday and the line there, and I actually came up with, we're going to initially be called the Punch Turkey Show. I looked it up to see if anybody had anything like that, and there was a channel called Slapped Ham, and I was like, man, that's too close. So I took the other word, drunk, instead of punched, and I put that. In fact, my first logo that I had created for the channel, it was a turkey with a black eye to kind of pay homage to being punched. And so yeah, that was initially what it was going to be, but we ended up going with drunk turkey. I don't even drink very much. Like maybe once every 2 months I have a couple beers, and that's really pushing it. But yeah, I've kind of, since we've talked more true crime, I've adjusted the name to just the DT show. But that's the story behind it.
Okay, I love that story.
Thank you.
I got Rocky stuck in my head. I'm not punchy. And he's getting all upset about it. Yeah, man. Yeah. That's a rad movie. I'm into those movies. It was. Do you guys remember? This is way off topic, but the evil David Letterman. Do you remember that character? I think he was on Howard Stern. His voice sounded just like David Letterman, and he would come on and say the most foul stuff because it sounds just like David Letterman, right? I'm so tempted to do that to you, Dan. The evil Dan. Oh my God!
Don't do it.
Oh,
Don't do it.
Yeah, right. Evil Dan.
Evil Dan.
Yeah.
Delirium tremors. What?
Yeah, that's what the DTs are if you're quitting alcohol.
Oh, that's right.
That's if you're real bad off, though. You got to be really bad.
Yeah, that is what DT means. God, you never know.
Yeah.
Well, if I'm delirium, then what does it make everybody else? Especially those that think like Bryan Kohberger's innocent. That's one of the things that the pro-burgers will say, that I'm a foul turkey or a drunken person on the thing. And I'm like, well, if I'm drunk and I'm still getting this better than you are, what does that say about you? So,
right.
I
roll
like
with foul turkey. That's a good play. I like that.
Yeah.
Foul turkey.
That could be your channel, buddy.
Yeah, right. Shiz Havin says, I'm like, wow, I never knew that about. Yeah, I was not in law enforcement. No. I don't know lots of stuff about lots of things. I play the guitar and I make fart jokes. That's me.
I play the guitar too. What kind of guitar do you get? Well, I used to. I'm not sure how much I can play now with my hand, but
what kind of guitars do I got? Oh man. Yeah. I'm telling you, dude, I got R1 Jackson US made. I got a Soloist SL2. You know it. I got some of the good stuff. Yeah, man.
Nice. Yeah, I got a my baby is a 68 Les Paul Gibson Black Beauty custom. Full body.
Nice.
Yeah.
That's the old Gibsons. Yeah.
Yeah, that
Just
one's
for
my
those
baby.
who don't know their guitars, Gibson used to be an insanely well-built product. I don't know about now, but they took a slide for like at least a decade. The old ones, though, if you get them in the 60s into the 70s, my God, they were built different. Like that's
heavy guitar, man. That's why I think I have arthritis in my back, to be honest.
Oh no.
Just playing it. Yeah. I have that one. I have Ibanez bass, a couple of Ibanez, other guitars. I have an Epiphone Gibson that's from like the 70s or 80s. Right. Yeah. So I got a few older ones. I got a couple of newer ones, but I haven't played since my arm injury. So what kind of music do you normally play?
Kind of it's kind of the cop-out answer, but it's true. A little bit of everything. But I focused more. I spent more time playing like extreme, I guess like extreme black death metal, shred, that really radio friendly stuff.
Yeah.
There you go.
Yeah.
Nice. Yeah. I like rock,
man. I like everything, like rock, blues. I can fake a little jazz, but I can't do any justice to it. I'm not good at that, but yeah.
There you go.
Yeah, that's right, guys. We're starting a band. We're starting a band. Yeah, that's right. Dan and Evil Dan. We're starting a band.
There you go. Yeah, I had a friend of mine that told him we should start a band. We're going to be a country band called Broken Dunn instead of Brooks and Dunn. And
right on.
It was just
do a YouTube video together. I like that.
There it is. Maybe we will.
You should.
There you go. Confuse
Collaboration.
everybody.
And
right?
Kate, you and I'll be the dancers in the background.
Nobody wants to be dancing. Nobody wants
Me
to
either.
I don't know. Come on now.
That's funny. That is funny. Let's see.
Oh,
We're like
here's
running
the
out of
funny
things
question.
to talk
though.
about with this
Yeah,
trial.
no
It's like
doubt, no doubt. I'm gonna bring it to this, man. All right, Dan.
Margaret can
All right.
sing. I really can't sing.
Van Halen or Van Hagar?
Well, my daughter is named Halen for a reason.
All right.
Oh, gee, that's a nice name, though. I like it.
Nice.
My oldest
We're
daughter
cutting
is
it
named
down.
Halen.
We're cutting it right down to it, man. Is it Van Halen or Van Hagar? Which is
You
your
just answered your
preferred
question.
era? No. That's
You know, the
you said Halen. Halen is in both bands. Hagar is only
right,
in one.
right.
So I'm gonna pin you to it.
It's
controversial.
That is controversial.
It is. Lots riding on this, Dan.
I like Sammy, but I'm gonna have to go with the other guy. I can't remember. What's his name? David.
All
or
right,
something?
we're starting a band. It's official. Yes, we respect Sammy. Sammy was amazing in Montrose and as the Red Rocker, killer material. But in Van Halen, no one touches the Roth era.
Roth,
I
there
agree.
you go.
The band is gonna happen. It's gonna happen.
There you go.
Yep.
There you go. Yeah, no, I named my oldest daughter Halen, and my middle daughter I wanted to name her Journey, but her mom didn't allow that.
Oh yeah, what was put down?
It was put down. There was that or Iris. I from the song Google Dolls. I like the name Iris, and so there was a couple of names that I wanted. I took out of some music, but yeah. No, I love music, man. Most of my stuff that I listen to is like, well, I mean, now I guess it's mainly kind of like rockish country, not the pop country stuff that's out there, but like the rockish stuff. Some Whiskey Myers. I don't know if you're familiar with who they are.
No, I'll check it out.
I am. Yeah.
You like Hank 3? I like Hank 3. I like his dad and his grandpa too.
Yeah, there was a song that I think he wrote that I found very interesting because he was talking about musicians who don't write their own songs. I believe it was
right.
him. And I had a friend who was like in love with Jason Aldean. And so I sent him that video of that song, and I was like, this is what I think about Jason Aldean because he don't write his own music. But I was just to take a dig at her. It was fun.
Well, the case is almost over.
Yeah, no doubt.
So let's think. Today's Wednesday. We have to rebuttal witness. So Thursday, Friday. Don't forget we have a holiday next week too. We have Juneteenth next week. So I wonder I think that's on a Thursday. So I wonder if the jury will be off Thursday and Friday for a long weekend if they're deliberating. I have a feeling they will be.
Yeah.
If she's found guilty for any of the charges, does she get like the cuff slapped on her? Then does she get to go home and then sentencing, and then that's when they do it? When does that happen?
It depends. Sometimes they wait and they have sentencing another day. Depends on what the judge wants to do. For the run of the mill people like us, we would get the cuffs slapped on right away. But in this case, I don't think they would do that. I don't see them doing that.
No,
What's
I
the
know,
possibility that she darts and they got a taser?
Maybe.
Well, I don't know if I
Chase
would
her, do an
go.
OJ.
I mean,
Chase.
she's got too many resources to be able to flee, honestly.
Yeah.
I know.
I think they might have to remand her right then and there. I think they might have to sentence her and, take her into custody because, I would assume maybe not because she's got a large bail though. But I could absolutely see her network of psychopaths planning to get her out of the country or something at that point.
You know what? It'll be interesting if she's found guilty. It'd be interesting to see what happens out there in the streets of Canton, around the
Well,
courthouse.
I'm pretty sure that most of them are paid, so probably not a lot. Honestly, they'll probably just clock out and go home.
I don't know. I think. Go ahead.
Well, I was gonna say, I'm not like too well versed in like trials and what happens when people are found guilty and stuff. The only one that I'm aware of that there was something was this is back in '95. Tupac, he ended up getting convicted for an assault, and then he got out on bail while pending the appeal during that time, and that's where ultimately he was on bond. When he met his untimely demise, but he was out free because he was on bail pending the appeal. Do you think that is that normal in most cases? Is that just because he was a famous guy? And do you think that there's a possibility for that in this case?
I think there's a possibility for that in this case. I do. Pending appeal. We shall see.
Yeah, that's one of the things that I was wondering about. Like, when did she get the bracelets and when did
I know.
she?
Everybody's wondering about that.
Yeah.
My son asked me that same question. Will they put her in handcuffs and lead her right to jail? That's what they do in TV. So I don't know.
That's what they do for a lot of people anyway.
Yeah, all the regular people out there.
Yeah, no kidding.
Well,
it
maybe
should
not.
be the same for everyone, though. It should be the same for everybody. I am
It's
very
not
annoyed at what money can buy you in the criminal justice system. That's
I agree.
The real corruption.
100%. 100%. So we shall see. Anybody have an update on what's going on with Turtle Boy's trial today? That's a good question. Anybody?
I don't know. I've been on this. I don't think it's streamed anywhere or anything. And frankly, I don't think it should be because he's just trying to do whatever he can to embarrass the victim in that case.
I know. And have you noticed in the courtroom if Paul has left or is he still there?
I saw that he wasn't there.
Okay.
Before the camera cut off, I was looking at that. He wasn't.
I'm going to see if there's anything online on that.
What is that going on with Turtle Boy? Is that like a hearing? Is it a pretrial hearing? What's going on?
Bench trial.
So his trial is starting?
One of them.
Oh, dang. How long is that one expected to go for?
I don't think very long, right? Kate, you know more about it than I do.
No, this one's short, is it not?
It should be, but
Is it televised as well?
I don't think it's televised, but I'm looking. Okay, here's some news. Hold on. Never mind.
Yeah, misdemeanor restraining order violation.
Yeah, nobody cares about Turtle Boy as part of the thing there. Like, this is not related to Karen Reed. He really has to either connect himself to Karen Reed or just live in obscurity. There is no middle ground there. Like, his stuff is boring.
Let's see if there's anything on Facebook.
I see some people saying that it was on Zoom and that they're on a break till 2 to 4. They'll be back between 2 and 4.
So we can watch that on Zoom?
I'm not sure.
I don't think Dedham District has Zoom. Brittany, no, Turtle Boy is running the risk of literally 0 jail time on a misdemeanor first offense if convicted.
What district court is it in?
Dedham.
All right, let's try it. Dedham District Court live feed. All right, that's what I'm checking it out.
When is the second trial? The one that he could face some prison time. When is that scheduled to start?
Not yet.
It hasn't been scheduled at all.
No, nothing. They're playing games with phones and yeah.
Yeah, I don't see anything. I don't think they have a live feed at the district court. It'd be interesting if they did.
The Claire of the Young Jerks. I think that was supposed to say Grant is listening to. They shouldn't be broadcasting that. They should not be broadcasting that. You're not
No.
supposed to broadcast the Zoom, especially the audio part of it. And like that's a case that involves a restraining order. It's sensitive. It's just
true. It is sensitive. You're right. Yeah. You're right. So we won't be able to know until we have a live Turtle Boy show later or something.
Yeah, see, I just think that's shitty and probably like not what I don't know. Because it's a very simple technical case. He was in the exclusion zone. He had probably about 20 minutes to leave once he was asked to leave, and he neglected to do so, and then followed this woman to her car and then posted the pictures on his blog. Like, I mean, I don't know how much clearer you can get. It's a bench trial. I don't think it's going to work out for him. Can't imagine that it would. But who cares? Like, respectfully, like, it's just all he's going to do is use that as a platform to try to dredge up as much embarrassing stuff on this woman as he can and frame her in the worst light possible. And whether he is convicted or acquitted, that's his win.
Mm-hmm. Yeah. Publicity.
I think the support for Karen Reed has dropped off tremendously from trial 1 to trial 2. I think that if she's convicted, even though she's fighting appeals, I think the support will drop off even more afterwards. What do you guys think?
Well, I think you might be right. That's what my son thought. Like he's been all over the, various feeds, the 26-year-old, and he thought there are more supporters that have come out. I mean, more anti-Karen Reed people out there now more than ever. So I think those numbers have grown. I don't know. I just see that I see this case, at least in Massachusetts, you're either pro Karen Reed or you're not. There's no middle ground. I haven't seen it
Dan,
unless you have no idea what's going on.
I think what'll be left over is going to be the more mutinous, like your Toms and, the ones that look like they're, manufactured in the Henson factory. Like there'll be a handful of those clinging on, I think, probably forever. And they'll wonder why nobody watches their content anymore, but they'll still probably keep putting it out, to like an audience of 3. But yeah, I think the more.
What does the chat think? What does the chat think about that? I'm curious. Do you guys think that there is more or less support for Karen Reed? See what they have to say.
I've heard a lot of people, reach out to me or have talked to me, say that they've thought that Karen Reed was innocent, and they no longer think that. I have not seen very many people do the opposite in this trial. Go from I thought she was innocent, now I think she's guilty.
See,
or I thought she was guilty.
People are saying less, but then Beth said more, a lot less. Okay.
I think what happened was it probably evened up a little bit more. So I think there's just more people vocal against the whole thing now.
Mm-hmm.
And I think it took, unfortunately, about a year, maybe 2 of the few of us out there just consistently standing firm and showing people that, like it's not going to ruin your life to speak your opinion online. Although I can understand why it's intimidating, because God knows those people will try. Like they will do the best they can. I don't know, people like, myself, Boomer, Kevin to a certain degree, certainly not saying that pejoratively about Kevin or any of us really, but we don't have a lot to lose, so it's like.
What are you trying to say, Kate? What are you trying to say?
I'm just trying to say we're not people that are terribly
I'm in
down
agreement.
by our reputations that much, right? Like, I think
Yeah.
you hit certain bumps in life, and what other people think of you becomes dramatically less important. And I recognize that that's not how the whole world feels. So I guess we're just kind of crash test dummies in that sense, which is why we do it
Test dummies
over and over. And
Randy's.
Yeah.
Oh my God.
What are you, Ms. Randy and Mr. Randy
Dude.
there?
You can call me Randine. Yeah.
Hey,
You
Randy.
can call me, macho rescue Randy Man
R-A-N-D-I.
Savage. That's what I'm gonna be. Oh my God. Rescue Randy Man Savage.
That's funny.
It's happening.
People think that Jackson was asking for an admonishment. His outrage, the way that he treats his witness, the state's witnesses on cross, especially last trial. I know he toned it down a little bit for this trial, but or checked out. It depends, I guess, your perspective on that. The fact that he is, would possibly be this faux outraged about Hank's comments and sarcasm is just like hilarious to me. This is the same guy that told a alleged grape victim that grape is, or regret is not grape. Like, you know what I mean?
There's somebody in the chat asked what we thought about the ham sandwich remark as far as was Hank being too snarky with that. What are your thoughts?
I don't think so. I think probably at this point, at least it's something interesting for the jury to watch.
Yeah.
They're probably ready to just jump out the window, run home.
Yeah, they do like a little humor now and then. They really do.
Well, I mean, I feel like they were probably pretty disengaged the last couple days at minimum,
Oh God.
And
How
after
could
a
they not
while,
be?
you just
Yeah.
listening to all the angles of how the body, and all that stuff and the dummy and stuff from Rentschler. It's after a while, it gets, you have to really focus. I have to focus to listen to it all.
Ham sandwich 2.0.
Yeah.
Like
Wonder
all
if the
free-
jury's up
free
back there
Randys.
eating ham sandwiches.
Right. Yeah.
I think that whole line of question was incredible, honestly, because
I liked it.
It starts Rentschler starts out by saying, I just had a sandwich and sat in the corner the rest of the time, sort of like, oh, I was just eating out of convenience. And which again,
Right.
like, none of that is necessary nor normal. Usually these experts, like I guarantee Dr. Welcher probably eats his lunch alone that he buys himself, may or may not be on a stipend, the daily whatever they give per diem, but he's actually physically purchasing it himself. He probably goes to somewhere alone and sits and eats it, and then he gets his Uber or gets in his rental car that he arranged and drives back to the hotel that he or his company arranged, and that's that. Like, I guarantee he's not hanging out with Hank Brennan, eat lunch, chumming it up. Right. Like,
I think Hank Brennan's eating lunch in the courtroom in a conference room.
Probably looking at papers. Yeah. Yeah.
Yeah, because they have their own little, I did go to court and they have their own little conference rooms that delegated to each party, the defense and the prosecution. So I guarantee Hank is with his little team there behind closed doors eating his lunch. He probably is hardly even eating it, He's not, once he gets in the zone of a case, he's 100% in that zone.
You can tell. You can tell.
Yeah.
But my point being is, no matter whether it's Hank Brennan or you, Margaret, or any attorney, but especially a prosecutor, I mean, it's just like you're not socializing with your expert witnesses.
No.
Right. It's just not normal. Like,
You're not wait a minute. You're not socializing with your clients. Most of the defense, every defense attorney I've spoken with, okay, which is a lot about this case, they can't believe how much the defense team is socializing with each other. They're seen out in the seaport. They're seen out buying what were they buying? Grey Goose or whatever it was. I mean, my God, it's such a bad look.
You're not grocery shopping with your clients?
God, no.
It's not the norm.
No, but I mean, it's just at some point, and I think that really speaks to the objectivity. And Dr. Marie Russell sat and ate lunch with them too. What Hank Brennan is showing is these supposed expert witnesses that are supposed to maintain a certain level of objectivity, right?
Yeah.
Are encompassed in her legal team.
Mm-hmm.
They're not just independent experts that were asked to perform a task that fly in or drive in or whatever and testify to that and then go home. That's not what is happening here. They are actively involved in Karen Reed's defense team. And if you're on the defense team, then you have an objective. You have a bias. You're serving a purpose within that team.
Yep. It's just optics. Like, you know, that's what why open yourself up to even one question on a cross-examination about eating lunch with your expert witness? Like, separate it so you don't have to, that takes that question right off the table and that apparent bias.
But I'm going to disagree with even that and say that that's what Rentschler was trying to deflect off to. He was trying to essentially minimize it and go,
yeah,
optics might not be great, but it was just a meal, right? When in reality, we know that there's video footage that suggested he was an active member of that team, discussing testimony, reflecting on it, laughing about it, eating lunch, taking a ride from them, staying in a hotel probably that they arranged. And the same for Marie Russell. We know that because we see in A Body in the Snow that they're discussing Lucky Laughran, which has nothing to do with her testimony at all, but they're discussing Lucky Laughran and how he's not going to have to buy a drink in this town for 6 months. And Dr. Marie Russell is seen laughing and agreeing with it.
I know.
That's not just and that's in the middle of trial. In the middle of trial. They're not just discussing their own testimony, they're discussing other people's testimony. That's being part of the team. That's being part of a team. That's not just oops, the optics are bad. That's like you are actively engaged in this woman's defense. You're not objective. You're not independent.
Right. No, it's not good. Yeah, the media does make it look like Karen has a lot of support outside the courtroom. Yeah, of course.
Well, this is what I was saying yesterday about my feelings about astroturfing, because it's not just the media. This entire trial, no matter what has happened with the buffer zone, whatever goes on, you've had consistently 8 to 12 people there, a dozen at most. As soon as documentary crews come back around, and I know for a fact they're back around.
Oh, yeah.
All of a sudden, that number overnight swells to 50. Like, you have to be. But how did they even know that they were there? I know that Karen knows that they're there. I know that Karen's supporters probably told her they were there because they know that they've spoken to some of them.
Yeah,
right.
Make a showing. That's what the Karen would
get on TV, you know. And and the same thing with, she had hundreds of people there until her documentary crew packed up and went home, and overnight it shrunk down to 30. So how many of those were there because they support her? How many of those were there to get on TV, get on a documentary? And how many of those were there because they were being paid to be there? You know? I always say this case is like if social media came to life, right? And started walking around, because just like on social media, you can put a filter on your face, you can tweak this, you can change that. You can take 1 million pictures of your life and curate just the best ones, just the nicest ones, and you can create an image online. And that's what Karen Reed has been doing. And she's taken it offline and put it right in the street. So she's creating this image that she is a celebrity. She is an innocent woman. She is a hero. And it's all carefully curated by her and her team, and people really need to understand that this is deception. This is bordering on fraud.
Yeah,
it sure is weird. I had a comment from one of my viewers asking me if you guys are aware, but obviously Karen's gonna have to go through some civil litigation after this trial is over. When do you think that starts, and do you think that is dependent on the verdict?
Well, no, it started. So there's a wrongful death suit filed in Plymouth District Court right now by members of the O'Keefe family against Karen Reed. So those proceedings have been stayed. They got right up to the deposition period, and then they stayed the depositions pending the outcome of not the outcome of the trial, pending the conclusion of the trial.
Yeah.
So the only thing that would be kind of contingent is what if it was hung, then presumably that stay would be extended. Because she has Fifth Amendment rights and all that. Once the trial concludes, she no longer has those Fifth Amendment rights, and that's whether she is acquitted or convicted, right? Because it's no longer in jeopardy. So at that point, pretty much as soon as this trial concludes, as long as there is a disposition of some kind, that civil case will pick right back up. As far as the defamation suits, I would assume that they're coming shortly thereafter, and Karen Reed will not be the only person named in that.
Right. Well said, Kate. Well said.
Yeah. Good deal.
Explaining the civil side. And remember, the civil standard is lower. It's not beyond a reasonable doubt. It's preponderance of the evidence, just like in the civil, the OJ case, right? They not guilty on the criminal charges, but responsible on the civil case. So a lesser standard, a conviction helps. So you can put in your civil case, you can actually put that into evidence. And if it's a guilty, it really helps. But the other side will put in the not guilty as well. So the conviction goes in, certified copy of the conviction.
Yeah.
But this time you'd have depositions, where in a criminal trial, you don't have the depositions because of the Fifth Amendment rights. So a lot of people don't understand. So I would teach trial practice at Boston College. A lot of people didn't understand really the differences between the civil cases and the criminal cases. So, criminal cases, the discovery is a lot different. So, no depositions. Your civil case, you're going to have, 3, 4, 5 hour long depositions under oath for all the different witnesses. So, anyway, well, how much time do we have until they're back?
9 minutes. Someone asked what we think about Karen yesterday saying the jury is not fed up.
Oh.
She also said that she didn't strike John with her car. I don't believe anything she says. She's pretty much.
The rules of evidence. Somebody just asked me a question. Are the rules of evidence different? As far as in civil cases, you still have to abide by, the hearsay rules. But in discovery, as far as you can get a lot more as far, out of, again, and that would go to the depositions and the discovery period. So there's quite a big exchange of information, and you get a lot more as to what you will expect your witnesses to say. So if you're in a criminal trial, for example, let's say I'm a prosecutor and it's an OUI trial for the first time. The defense is almost, I don't get to see what really the defense witnesses are going to say, or it's pretty much trial by fire when it's a criminal case in many instances. But civil case, you're going to know everything ahead of time. And you also have interrogatory questions, which is in the state of Massachusetts, it's usually 30 questions. After the interrogatories, you get your depositions, and plus you get all sorts of medical records. You can subpoena all sorts of records. So it's very different. And it takes a lot longer, usually, I don't know, 3 years. Something along those lines. Did I answer the questions? I don't know. I kind of went off on the difference, but
just kind of touching back though real quick on what Karen said yesterday about the jury not being feeling fed up or whatnot. To me, I think that if the jury was, that means that it's probably towards the defense. Because I think that if the jury was getting tired or fed up with the prosecution, that would be something she would jump on. So by her saying that tells me that if the jury is fed up, it's in the direction of the defense.
You think she would pivot off that, use it to spin? If
exactly.
I get you. Yeah.
Oh, Christina Rex said a juror's not feeling well. Huh. That's interesting. How would she know that?
Yeah.
Right? At this point, right? How would she know that? What time is it? It's 1:54.
Karen is delulu. Yeah.
Huh.
Rentschler sandwich. You're right on point.
Maybe she ate the Rentschler ham sandwich
Oh no, like the Homer
with
Simpson
bad
sandwich.
mayonnaise.
Right. Yeah, it's still good. It's still good. Big time. Yeah, it could be.
Hit the like button, guys. Absolutely. Hit the like button for Yellow Cottage Tales.
My God, yeah. I was just thinking of a stupid sandwich now.
I know.
We're just burning down
You
the
are
last few
unmuted.
minutes, right? Yeah.
I'm starving. I haven't eaten. So now I would
I
kill
know,
for a
I
ham
know.
sandwich right
Yeah.
now. Oh, here we go.
Now open, maybe seated.
All right, while the jury is on their way in, I need to see counsel at sidebar.
Okay.
Oh, I wonder if that's
Oh,
the issue.
sidebar.
OMG.
Sidebar.
All right. Hold on. I'll be right back. I have to use the ladies' room.
Oh no, raisins with potato salad? No, don't put raisins in there.
That's white people shit.
It's not though.
It
I'm
is
white.
though. I
I'm,
swear to God, that's the stereotype.
I glow in the dark. I'm so white, it's unreal. I don't put raisins in my no. That's just weird people stuff. That's what that is. That's weird people. Yeah, no raisins. Why? Why'd you do that?
I don't know, man. I'm from the South. I've never heard of that before, but maybe
I swear to God, that's the stereotype. Right
That
there.
in her hood, that's what it's like. But us Dans, we know, man. We don't do that stuff. That's weird. That's weird behavior.
Never heard of raisins and potato salad. Yeah, that one's interesting.
It's weird. Way too many sidebars.
All right, we're back.
Are we? Right to
Yeah.
the fan. Some more malarkey. I will not
Back.
stand for it. Yeah. Well, you're back in time for the ceiling fan.
So I like raisins in my chicken salad and cranberries.
I like cranberries in my chicken.
Yeah. That's what I'm having for lunch today if I ever get to eat lunch.
I might tolerate the cranberries, but the raisins, I'd probably be flicking them out. I don't know.
Well, I like the golden raisins.
If you do a
It's still
curried,
a raisin.
You curry.
a
Yeah,
curry
that's
chicken
what I
salad
have.
or a curry tuna salad with golden
Great.
raisins is delicious. Oh, there
Mr.
it is.
Brennan,
Okay.
Oh,
jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Dr. Rentschler, you wrote a report back in February 2024,
That's correct. Yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did. Yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct. Yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder. Correct. And the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle.
That's correct.
No ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same, no, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the pink test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were, let's see. Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where that it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve, as well as the abrasions to his right arm. Did you write that?
Yes. And which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those three sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those three articles or three papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the three that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't. And that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It looks at, it tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cutability and its relation to lacerations, severity, indices. You know that, you cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cutability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct. And that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure. I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
Not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that?
Inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose. But if it's not, again, then I'm not sure what that test actually accomplished or represented.
You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident. You're correct.
Do you know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So
if you don't have the
you
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm gonna, very briefly.
in reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement on it that he was trying to reenact the actual collision.
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that.
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash tests with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before the impact?
I have, yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
Maybe if you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion. And you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Renschel's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Okay. Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions because that is the majority of pedestrian collisions, the front end, isn't it?
The majority,
Yes.
it is, yes, sir.
And so there is a difference between fender valves and a center of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour?
No,
Good
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle?
So ask the question again.
Okay. You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand.
Yes.
Could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with a hand.
So
But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis, you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow
Did you consider phone temperature, battery temperature data?
it. I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's in a,
In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight was shattered?
I have, yes.
In fact, in your videos, yes or no, after the collisions in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of an
Exhibit
individual.
73, please. Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none. So, no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 99D. Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight?
Yes.
That were recovered from Mr. O'Keefe's sweater or shirt?
Objection. I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat it than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and t-shirt was scraped?
Objection. I'm going to allow that. I need to see the voice. Jurors, this will be brief.
Sorry, guys, I fell asleep for a bit there, so for a long bit. I don't know if anybody wants to jump in. So this
Sorry,
seems to
I
me
didn't
like,
realize. Yeah, this is bad. This is bad.
I mean, this seems to me like the whole issue here is whether or not any defense witness, and there seems to be a pattern here, any defense expert is trying to give objective opinion based on their expertise, or is just trying to help for their own reasons, whatever, the defense team. And more, this seems like they're bringing out the fact that this expert witness, even this guy here, just seems to really be trying to help the defense team. Am I wrong on that? Or
No, I think he even threw in that, you have a theory about planting evidence you want to share with us? Like, called him right out on it.
I mean, it was interesting how he didn't want to answer the question. He didn't want to he didn't consider the taillight piece, yet he had right away a question as that it wasn't ever calculated how far that taillight piece was from the body. So he knew that.
Right.
You can't know that unless you've considered the taillight piece.
Right.
Was it Dan? Were you about to talk? Or sorry if I.
Yeah. I was gonna say, man, I thought the other ARCA witness was a bag of something. This guy is worse, man. Deflecting, trying to throw in other things like when he made the statement, like how it was collected, throwing in the leaf blower, those type of things. It's really odd, why he's not just sticking to his expertise.
0 taillight pieces were found with a leaf blower, by the way. That only turned up the cocktail glass and some blood.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Leeds' Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Based on the question that was asked. For the same reason I just indicated at sidebar. You just reformatted. I'll try again.
Okay.
When you looked at these taillight shards that were projection.
Go ahead, Mr. Brennan.
When you looked at these taillight shards that were consistent with the break in Miss Leeds' Lexus, did you consider how they got into Mr. O'Keefe's clothes? Objection. Same objection.
I understand the objection. Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Leeds' Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess, apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well,
that?
if that's what you're telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic. Is that something you would want to consider in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
We'll take a look. Objection.
Sustained.
If you look at that for me kindly, you tell me whether you think those pieces of broken plastic are sharp. Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Let's go back to
looking at the normal eye.
Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass, no?
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the breaks in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you moved the arm angle, do you expect that the break would look different?
That the break would look different?
Yes.
It could look a little different. I mean, certainly the breaks looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
Objection. I'm going to allow that.
You do not
How
know
he was
how
standing
John
that-
O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Objection. Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or
Is
different?
it all going in the same direction or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
Objection. I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor. Yes. I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults in the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you
Yeah.
if he did somersaults in the front yard.
No, there's no evidence of what he did.
Your Honor, to come sidebar quickly before I start.
Okay.
Oops. This guy's bias is
Oof.
on full display
Dr.
here.
Baloney. Yeah,
Right.
he's awful.
I mean,
and
if we're to take him at face value here,
Then
Mhm.
anything that occurs without an eyewitness just never happened.
that's right. Yeah, if you don't see it, it didn't happen. That's right. It doesn't exist.
Which again
Didn't
goes
happen.
back to, if a house burns down, do you need
Mhm.
to know how the fire started to know that it burned down? No.
Mhm. What type of accelerant was used? No, you don't. The aftermath is right in front of you.
Oh wait, I think Kevin's trying to talk.
Sorry, I forgot. Is there a problem here? The bias is established, but is there a problem with a jury that's already described yesterday by the judge as fed up? That is there a point where these questions are just making them, it's dragging on and making them more fed up? They get the point. The guys, and I think they've already accepted the point. The guy is a defense witness, and he's biased. And at some point, these questions maybe risk pissing off the jury. It's been going on for a long time. I know no one can really answer that, but I think it's worth asking that question.
It's possible. It's possible, but it's also just as likely, if not more, in my opinion, that the jury is sitting there and they've heard all of this BS from the defense, right? They looked at the data, as Kate's pointed out, the data that the defense doesn't even argue anymore, that puts her vehicle where it was, puts John where he was and not moving after that vehicle incident. That's all firmly in their minds, right? And at this point, yes, they could be checked out, they could be tired, and they could be bitter even.
Yeah.
And I think it would be more at the defense, because it's like, look at your dog and pony show. It's so transparent. Hank is ripping you apart and we just want to go home. You liars have kept us here far too long. I could see the acrimony growing towards the defense.
I mean, isn't that some of our own bias, Nat? We've
It
covered this case
definitely
from one
is.
side for a while. So if you're a juror and you're sitting there neutrally and you're just sitting there, okay, we get it. These guys are on somebody's side. That's just common sense. Now wrap it up.
Right.
Let's go home. You know.
Oh, that's my point though. Is it like you're saying? It's very apparent. It's very evident that this is BS, and if they're upset, they've already been there too long. That acrimony is going to be pointed right at the defense. Like, you are the jokers that are keeping us here. We want to go. That's how
I think under normal
super biased for
circumstances,
sure.
usually that frustration goes to sorry, but I didn't mean to talk over you. My bad.
No, I'm done. I'm done.
I think that usually that frustration goes to the prosecution. However, in this case, I think that it becomes abundantly clear who's objecting, who's getting sustained, who's demanding the sidebars. They can probably infer who's responsible for a lot of the delay, and they have a lessee. A lessee is really a gift to that, because, if they're annoyed with Hank Brennan now, and I think that's a big if, by the time that a rebuttal hits and they're at the home stretch and a lessee drags it out for 45 days, oh, they'll be annoyed with us.
John, are you here? John DePetro? Sorry, my voice is still. John is. We've brought him into the room. I'm not sure if he knows that we have. John DePetro is multitasking, probably.
I'm here.
Oh, hey,
I'm
John.
here.
So,
Nope.
what do you
I'm
think
here.
about
You
the
can't-
how do
Oh
you-
my God!
Oh.
What a condescending asshole this guy is! Holy cow!
Hell yeah. No.
He's maybe it seems long, Hank, but what? Don't swear like that. But he clearly has a deal with Jackson. He's just such a snake, condescending, smug, and it just keeps saying, he wasn't hit by a car. So I think Hank would like to wrap this up. But how can you this isn't an elderly lady with labored breathing. He is
right.
All right. Well, they're coming back.
I mean, maybe at some
Cyber
point he's
Exhibit
not going to give you any
166,
more than he
please.
has. So
Right.
True. Fair enough. I think he's got a
Did
bit
you see
more.
this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection. I'm going to allow that. I'm going to allow that. So, hold on. Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection. Are you aware of that?
That's not the evidence. That is not the evidence.
So,
Glass.
hold on, Mr. Jackson. Mr. Brennan.
I
do
can
you have a
reword
quick-
it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
Okay. 98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it
back
look like
here.
a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
And you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
While I evaluated certainly for my report for this case, I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. May I approach?
Yes.
April 20th, 2025. Page 124, line 16. Yes, 124, line 16. May I approach?
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. You asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
I have no further questions.
All right, Mr. Jackson. Okay.
Hey, I think you guys are here. Was just waiting on Margaret.
Yeah.
I think John DePetro is here. John, are you here?
I am. Yes. Hey, Kevin.
Again, sorry about my voice. It comes and goes.
No, it's fine. Listen, I think it's listen, Hank would like to wrap this up, but this is their final witness. If you don't rein this guy in, he could be damaging because he's on a mission. I think he had to do this, and I think he's done a good job showing that certainly, as you had talked about, that last spring they certainly were not. I mean, it's almost laughable now that they were allowed to testify and they were just independent and not biased. I also want to point out, and this is something that an attorney mentioned to me, but notice that Hank is using this opportunity to once again remind the jury. There's the mannequin, there's the tail light, there's the sneaker found, there's the straw, there's the drinking glass. By this guy being so difficult, it does give Hank a chance once again to go over with the jury all of the evidence. And I think it comes off preposterous of, him continuing to just insist there was no collision.
Yeah, when Dr. Rentschler keeps, I was just going to ask that, when Dr. Rentschler keeps finding
Yes.
opportunities to
Thank you.
insist there was no, is there a point where that actually
Rentschler,
starts to damage
You were just asked
Rentschler's
a couple of
testimony?
questions about
I mean, his credibility?
I think so.
they
Because he's looking for
provided
reasons to get
information
that
about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just
you.
answer the question.
Sorry,
And-
Ron.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay. Wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rachler, where is as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up. If it was coming right at you and it hits you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Rentschler, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Sustained, you have to watch the foreman question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that, Your Honor.
In your view, was there evidence of a collision with John O'Keefe?
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Okay.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered. That's correct.
Do you know or understand that? Did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass?
Yes.
Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
Well, there is evidence that he left the bar with a drinking glass.
Yeah. Well, and Kevin, Are we about to see? Did he just open the door for the video? I don't know, but of Karen saying John got out of my vehicle with the glass. Didn't he just open the door to that?
They have video of him grabbing the glass, and they have her
Yeah.
statement, and he's already accepted her picking the glass out of his face.
Yeah.
This is like, I mean, Karen, don't hurt yourself
Yes.
tonight, girl. Like,
Yeah.
oh my God.
It's definitely notable how there were certain items that he had no memory or didn't consider worth analyzing, but yet these other more random items he was fully aware of, like strange, like a piece of glass in the nose and several other things. It's striking.
Boy, I want to see where they go with this with the video. Kevin, by the way, before I forget, fantastic job last night at Court TV. Nick, how do you feel about them sending you out there? And now that was really good TV. That was classic. Congratulations on that.
Put him on the spot. It had to be done, right?
Yes. Yeah.
I thought he was impressive last night with his ability to dance around those answers. I really did. I think Nick is good at what he does. I do think that, I have to say.
Oh. I don't. I think if I sent you some talking points and said, just make sure you got this down for tonight, I'm pretty confident you could do that. I think anyone could do it. I think it's kind of funny. Anyone can do it.
It's kind of funny though. I mean, he sits with the family every day in court. He's referred to as a Karen Reed insider, and he drives to and from court in the limo with them.
Yes.
And not only that, further, we know from just the way this story first broke out with Turtle Boy, all of that was fed to Turtle Boy by Karen and by both Jackson and Yannetti.
Yes.
So we're supposed to not know what's going on here.
Yeah.
I think Rescue Randy could do what Rocco does.
Thank you, Boomer. Exactly.
Right.
I mean, we have to piece all this together. We watch it, break it down. I mean, he's sitting in court now, but I was contacted by someone affiliated with the salon that's like, a lot of times he's working, he's doing different stuff, and then he gets the text message with the talking points, that night before he's going to go on. So that's what I had heard. He got really upset when I mentioned it. But I think, and as I told you, Kevin, that night when he was saying Proctor swabbed it, when you go on, this is when Kevin is presenting, this is work that Kevin's observed and listened to and followed. But the fact that he was saying that and then couldn't back it up, to me, that it's like he got caught because someone else did his homework on the way to school.
I get my talking points from the McAlberts.
Yeah.
Oh yeah. And my furniture.
That's the chair you're sitting in, right?
Yeah, that's right. Yeah.
And I see Margaret, fantastic job last night.
Oh, thank you.
Yes.
On Canton Confidential, you mean?
That one I did not see yet. I didn't see that, but I thought I did.
Yeah, she was on Court TV
now
at 9
I'm getting
with
confused.
Wayne.
Yeah.
I was on Court
you were
TV
with
at
Wayne.
9
Yes.
and Canton Confidential at 7.
Okay.
Canton Confidential, I actually, I was the only one pretty much with the opinion that I didn't think Dr. La Posada did a good job. Actually, the lead legal analyst there agreed with me about her attitude.
Coyne. Yeah.
Coyne. Thank you. Michael Coyne.
Yes.
Yeah. So that was good. That she had a very condescending and snarky attitude from the get-go, and I think that hurt her credibility. That was it.
You guys, you know what else is? We know how the other side, how they pick up on the littlest detail. Can you imagine if Hank had someone on the
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
So when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it. Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a 0.5 centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the 0.5 centimeter. It's not a bruise. It's a 0.5 centimeter abrasions, about an 1/8 of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics, it's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary, was one of your answers that you were all celebrating. Objection. Isn't it?
The objection sustained.
How'd that taillight break, sir?
How did it break that way?
How did, I don't know. There's no evidence of how it broke.
I have no further questions.
All right. You're all set, Dr. Wrenchler.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I'm going to see counsel for a couple minutes over here.
Oh boy, a couple minutes means a long time.
Yeah.
Yes, it does. Half an hour.
I think so.
Oh boy.
So what were the best, I missed some of it. I did fall asleep. What were some of the strongest indicators of bias? So the object of the prosecution here was to show not that Dr. Wrenchler wasn't qualified. He's qualified. The question is, was he biased? Did he already make decisions up before this? Or was he hired to prove something specifically, as I think he was by the U.S. Attorney's Office with certain winks and nods? What were the strongest areas that Hank was able to show that today?
Well,
was
I'll
there any
go
particular
first.
moment that stood out? Yeah, go ahead.
I like how he brought up that he stopped by the party and had a ham sandwich with them and then went through the whole thing of just standing in the corner, only because I think that type of stuff, it breaks through and it's relatable to the jury. And if you're in the jury, like, well, wait a minute, this guy's trying to say, oh, I just stopped by to have a sandwich on the way, but you're doing it with that side. And, why are you in there mingling with them in that fashion? So I think, and the thing about it that I like is, Hank is just so effective. I like when he does the whole thing, and Margaret, maybe this is common, but I like when he'll ask a question they don't answer, and then he'll say, "Well, you don't like that question?"
I love that. Or is that
Right?
funny?
Yeah.
He's he's great at that.
He is.
And I think
Yeah.
he did he brings out, I think he does a great job in his questioning of bringing out the biases of a witness. Because
Yes.
he makes the witness like tense, but I think the witnesses deep down are afraid of him and they kind of know what's coming, But this guy came across extremely biased. He had an attitude, and I think that's going to come across, for the jury. I mean, he just wants to help the defense, just like La Posada did.
Yeah, and La Posada, I just want to add two things about it. One, can you imagine if Hank put someone on there on the stand who said that John O'Keefe was 7'2"? I mean, there'd already be a T-shirt for sale at the, whatever. Someone selling that as merch. They would laugh it off. The other thing, I caught some heat because I mentioned the labored breathing. But to me, I'm just saying, when I did the Hernandez trial, they brought in that guy, Alexander Bradley, and Aaron Hernandez. They had a fight, the two of them. They were in Miami at a strip club, and Aaron Hernandez shot him in the eye.
I remember.
And when he got up there, and I just found it tough to focus on anything other than he's sitting there with the glass eye, and he seemed a little odd. And then afterwards, I did get a chance to talk to one of the jurors, and they said, I couldn't get past the eye. So when I said that about Marie, she's up there with the labored breathing, and she's saying he's 7'2", and John died within 15 minutes. I'm saying collectively, if you're in the jury, I would look at it as though this lady seemed like she did it haphazardly. So I'm not going after the elderly, but I think all those things come into consideration. And I think the Commonwealth witnesses have been better, tighter, and they present better.
I agree.
And as it goes to Darth Lapalato, whatever, man, she at first I was like, nah, I'm gonna be chill. I'm not gonna call her Darth and all that, right? But then when she apparently, I mean, in my opinion, right, she really pumped the brakes with the breathing when she was speaking to the defense, and she seemed to, ramp it up when she was speaking to the prosecution, almost like it was controllable. I mean, maybe I'm just assuming too much there, but yeah, I lost a lot of respect for her when she became, snarky and all that.
Absolutely, right off the start.
To John's question,
go ahead.
Sorry, I'll be
ahead,
real quick.
Omar, I'm sorry.
You were saying what do you think was evidence of him being sort of showing his bias? I would say his resistance to common sense, parlance, like when he says, "What do you mean by backing up? What do you mean by falling backwards?" It's like, dude, what do you, Bill Clinton? What does the mean? Like he was just too resistant to basic conversational English. I thought that was unreasonable.
Yeah.
For me, I thought when he started mentioning the manner in which the evidence was collected and just really not taking into consideration any of the evidence from the taillight as part of a factor for a collision, I was dumbfounded by that. I was like, how do you not take evidence of the taillight broken into consideration when the objective is that there was a possible pedestrian strike with a vehicle and that the taillight was involved? It was wild that he didn't want to take that into consideration.
Yeah.
How about the contrast between Dr. Welcher saying that there are just too many variables here that you can't know to know exactly how the injuries happened to John, what position he was standing in, whether he was moving. Contrast that with Dr. Rentschler, who said those variables don't even matter.
Yes.
Well, how's the jury going to process that? That's right. Which position is they going to find more credible?
Yeah.
That's maybe a key thing.
Oh, I had a feeling.
Done for the day.
See you tomorrow morning.
Full day.
Oh boy.
Same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, to the jury.
So who did you guys get the email from Court TV? Kevin and John, are you on tomorrow night? I'm on at 8.
I'm
on tonight
Friday.
at 9.
Well, I'm not even sure if I'm on Friday, but
No,
I'm on
Thursday.
I'm on tonight
I'm
at
not
9.
on Thursday.
Yeah, I'm on tonight at 9.
All right, cool.
I think at some point he does he has them in studio, and when Vinny was in town, he said he actually likes that because he doesn't like people in the box. But the problem is those attorneys, I just find they don't exactly know the case inside and out. They're talking more just in concept.
Right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
No, you're right, John. That's a huge problem. This has been a problem since I first started watching Court TV a couple of years ago, and finding informed experts is really hard to do on this case. And every once in a while they get one, but then, they'll go and get a body language expert and something like that. So it's just, I understand it's been hard for them to try to find the good guests and stuff like that. But there really are only a handful of people that know most of the evidence on this case. And it's
Right.
You're kind of limited on that,
Well, those three people are based out of Atlanta, where they're based. So, they end up doing different things. And it's little stuff. I get it. No one's perfect. They'll say 223 Google search instead of 227.
Right.
I mean, to them, it's all minute details. But one thing I have noticed is some of the free Karen Reed people. I was on with someone the other night, and a defense attorney that I have not talked to in a really long time watched it, called me afterwards, and said, the people on her side, he lives in another state. He's now interested in it, but he said, this case just has to be proven, but they act as though the whole night has to be reconstructed, every little detail, or otherwise she walks free. And he's right. Like the woman I'm on with, they pick apart, Kevin. They're still going after these little details that, as you've said, you drop 2 plates in a room, they're going to break differently. He said, if somebody robs a bank, I don't have to know what they made in their omelet that morning before they did it. These people get caught up. Like, oh no, if you don't know that, and blah, 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 and all this little stuff. I don't think this jury works that way. I don't think any jury works that way.
It's unreasonable doubt is what I call it. That's what I called it in the book.
Yeah,
It's
I like
unreasonable
that.
doubt.
Agreed.
Yeah.
And one of the things you'll hear Wayne say a lot, Margaret, is the
Yeah.
tie goes to the defense. Well, if there's only one piece of key evidence, then yes. But if you're looking at, but the problem is they're not looking at the totality of the evidence. So if there's this little 10 or 20% of doubt regarding one aspect of the evidence, but you have to look at the totality, and that doesn't seem to be something that Wayne, who I like a lot, and Peter seems like a nice guy too. It doesn't seem to be something they really even understand, and I don't really get that.
And Kevin, you know what else they always throw out is, remember, the defense doesn't have to prove anything.
Anything,
Well,
I know.
in theory, that's true. But when you stand up in opening arguments and say, and we have witnesses who are going to place him inside the house, I think you just set a bar for yourself on that.
Speaking of that, speaking of the opening statements, I was on with Wayne Dennison last night in Court TV, and I had a spiel on how I thought Jackson way overpromised, and Dennison agreed with me on that. So
wow,
and it's not good. Yeah, he did. Right, John, you watched it.
I watched it. Yeah.
So that was something. I mean, he was the fact that he seems to support the other side, but that's one thing I learned way back when in law school and teaching. Part of my class was trial practice. Like, you just can't overpromise. That's a huge mistake.
Yeah.
And
Kevin, two other quick things. I don't know if you guys saw. So the New York Post, and I'm psyched about this, they picked up on her weird faces and sneering at people in the courtroom. So New York Post has a huge negative story on Karen, and they're talking about her mannerisms in the courtroom. And you guys, I lived in New York City in the 90s, and that's where I really learned media and everything else. And from day one, I've told people I've never been comfortable the way the Boston media, they cater to her, they laugh with her, they chat with her, they try to curry her favor. I'm far more used to the aggressive. If this trial were in New York City, they'd be all over her and
But
killing
usually
her
the
with
Post
questions.
caters to her too. Like the Post has had on Sean McDonough on the front page and stuff like that. So I mean, that's why I said wow when you said that.
Oh,
no, the
okay.
Post is usually all in on Free Karen Reed.
Wow,
I didn't see that either.
realize that. I didn't see that. Huh.
Yeah. No,
The other thing is, did you really? I didn't know that. Sean from the Gulf is in the New York Post.
Well, if this was months ago, several months ago.
Okay.
So it was
I think
a while
this
back,
just
but
hit today. The other thing, did you guys see this video of Karen walking back from a sidebar, and she is snarling at Joe Krowski's dad?
No way.
Yeah, wait till you see the video. Because she's,
I caught that. I did catch.
You see that, Kate?
Yeah, because I have the camera up the whole time on the. Yeah, so I saw. I thought maybe she was making a face at her father, but when I ran it back and looked over the break, it looks like she's definitely looking at Krowski Sr.
Oh yeah.
How did they get in?
Who? How did who get in?
How did Krowski and the dad get in the trial?
Well, I'll let Kevin. I mean, Margaret, you would actually. I mean, they're established
I tried to
attorneys.
get. I've tried to
Oh,
get
I
in.
see.
I actually
And they tell you
emailed
no?
the. Well, they didn't even get back to me.
Eesh.
They just blew
Well,
me off.
They're a little. I am in for next. I'm an alternate for next week, but that makes me feel good. So, if it's opening arguments on Monday or the verdict, that should
Well,
get
you
me
mean
inside
no, not
the
opening,
courtroom.
closing arguments.
Closing, excuse me, closing. Yes, that's
Wa-
right.
was
Don't
Mr.
even
Krusky-
joke like
out-of-state
that.
people.
Was
Yeah.
Mr. Krusky
Scares.
with the media or was he with the family?
No, he sits on the end, and then the court officer sits between him and Bill Reed. So
That's
he's just sitting
interesting.
there very leisurely, and I mean, she is literally snarling at him. So
Maybe he's helping Hank Brennan out.
I don't know, but I mean, you'd think at this point she'd be able to contain composure a little bit. I thought it was
Yeah,
a
so
bad
actually,
look.
that's a good point, Margaret. Is it possible
Yeah.
the prosecution hired him as a jury watcher?
Well, or maybe he's just doing it as a friend. I know. Well, yeah. So I don't know. It's just a possibility. I don't know. But all I know is I've tried. It's hard to get in there. That's all. So
Boston
I think he's got to
25
be associated with one or the other. Boston 25.
just reported that the defense has officially rested in the Karen Reed
Woo!
trial. Yeah.
Woohoo!
Although I
Yay!
didn't hear. So
I didn't hear
Jackson
it.
must have said that. Yeah, right before they.
No, I
Yeah.
think they wanted to enter a
The slideshow.
a
Yeah.
PowerPoint, which is bizarre.
Okay.
Where Karen just sat at home and made a like, whose PowerPoint is this? I don't know. Can you do
Well,
that?
it's Dr. Rentler's. It's Dr. Rentler's PowerPoint. That's the one they were arguing about yesterday morning. Or yesterday during lunch. That kept us up during lunch, remember?
No, but Rentler's gone. Rentler stepped down. He's done.
Yeah.
So it's not Rentler's.
I know, I'm pretty sure it was still his. They could have still introduced it, just like the video clips that Hank was introducing.
I don't think they can. I don't think they can just introduce Rentler's PowerPoint without Rentler. I think he has to
Right
be
now-
the one to do that.
Hey
Right
guys,
now,
I have
Ted
to
Daniel-
go.
Oh,
Ted Daniel
Sorry, I
is
have
the
an
only-
appointment at 4:30
No
that I'm
problem.
going to be
What?
late for. But thank you so much, everyone. Thanks,
Yes.
chat.
Good luck tonight.
Thank you very much,
Yes.
Margaret.
Oh, no, I'm not. I'm on tomorrow. It is Wednesday.
Oh,
But
tomorrow
thank
night.
you, and
Okay.
good luck to you, whoever's on
Yes.
tonight. And see you all in the morning.
Have a good one, Margaret.
Thank you. Bye-bye.
Thanks, Margaret.
Right now, they're the only ones, Kevin. Ted Daniel is the only one reporting that they've rested. So I wonder if they jumped the gun on that.
No, I'm seeing a couple other news sources doing it. NBC 10 is reporting it. Yeah, they're all starting to report it now.
Oh,
yeah.
Okay.
Yeah, I'm seeing a bunch doing it. WBZ News Radio is reporting it. My goddamn voice. Yeah, Boston 25. Yeah, there's a bunch reporting it. So
okay.
So they've
Man.
rested. So next up will be the rebuttal tomorrow morning, and I think it'll probably be done tomorrow morning, right? Who's coming on rebuttal, Kate? Just Dr. Rentler? I mean, yeah, Dr. Rent.
It might just be just Dr. Rentler, maybe dog DNA.
I mean, not Rentler. I mean,
Yeah. Oh my God, we did the same thing.
Oh,
that
no.
Jackson was
I'm doing the
Yeah,
same thing.
that was huge, yeah.
Now it's the Alan Jackson effect.
Kevin, it's Terry Kuhn, the dog DNA,
Okay.
and Maureen Harnett of the crime lab is also going to test.
Right. She's the one that
those are
swabbed the DNA. She
and
swabbed it,
Walter.
not Michael Proctor.
Yeah, that's right.
I don't know if I would call him. Honestly, I don't know if I would call him if I were him. I know that he said that he intended to, and he may, but I don't think that I would at this point because it's so weak. He's already introduced that there's no dog DNA, so he can use that in closing, and it's already been introduced to the jury anyway. And I don't know if I'd want to open up the jury to the bullshit. You know, they're gonna cross Maureen Hartman on the holes in the sweatshirt a bunch, and it just seems redundant for something that it doesn't make any sense. And they've heard more experts than not refer to them as superficial abrasions, including Rentler over and over again just now. So I think that, yeah, I don't know. I don't know that I would do it. We'll see what he does.
Well, I think Hank has a way of doing things very efficiently, so I think it'll be a
Yeah.
relatively quick examination just to get it on the record. Because you've had now a couple witnesses implying, or at least both one testifying and one sneaking in testimony that these were from an animal. So I think it's important to get that up there with the DNA stuff.
And also, during defense, we haven't seen, he hasn't been able to play the Karen clips. So if there's some way that by playing one of her own clips could rebut something that came in with the defense, then to me, you look for any opportunity to play her.
Oh yeah,
because
the clips
right,
rule.
yeah, and you guys also. I think there's a false, and we can all tell there's a false sense with the supporters that because the defense is up, that they're like, here we go, and they're turning the tide. But I think it's a false sense of strength that they're feeling right now, because we know Hank's going to get rebuttal, and then his closing is going to be strong. So I think he's in a really good position.
My guess is that both sides feel confident, because that's just kind of the nature of the beast here. That's what I've been hearing. That happened in the first trial too. There's a tendency both sides spends a long time preparing their witnesses and going over their evidence. And I think both sides are probably confident right now. That would be my guess.
Okay.
I think they feel that Renshaw did a good job. I think they feel like Lapalato, whatever the hell name is, did a good job yesterday. So, so I think both sides are probably fairly confident and are willing to let a jury make the decision on it.
Yeah. And they're ready. I mean, the judges, think of that, 8 weeks with these, and it's the same 18. And every time you got to sit in the room with them, and you got to listen to them chomp their sandwich and small talk and all their noises that oh my God, it is like, this is a long time. It's a good thing they're
And
not
yesterday, the
families
judge
as
mentioned,
jurors.
you were probably listening yesterday when the judge mentioned that the jury looked fed up
Yes.
to her. So that's
Yeah.
pretty strong to hear a judge say that.
I think so. Yeah, and I think she's right on. I know Karen addressed that outside of court, saying, and the jury's not fed up. I mean,
Is that what she said?
Yeah, she said that
Wow.
outside. Yeah. Well, she's always trying to, as if they're enjoying it in some way or something. So,
And if you listen to Sue O'Connell, they're only fed up with Hank Brennan.
Yeah.
No doubt.
Wow. I mean, those people, their end game is just, it's ridiculous. If you want to, you can just sit there and then say, oh, the jury's really writing now. Oh, they're frowning. I mean, what Dr. Brennan, what Hank Brennan just said about, does common sense come into the equation? To me, that's for the jury also. To me, it's just so preposterous at this point that this whole no collision. If there's no collision, why have we seen all these videos of them backing up the car and hitting the arm? I mean, I think that's a lose. I think that's a lose, Kevin. I think they should have focused more on, you can't prove intent, or she didn't know, and it was an act, should have gone more to that it wasn't intentional, because instead they're just going for that it never even happened. So, and when Hank went through, when they wanted to get the mistrial, he talked about, she intentionally went forward and then she intentionally went back. And I think they should have focused. I think their whole approach on this thing has been wrong. I do.
I really think, as I said before, a fulcrum of this case is going to come down to whether or not the jury, was the contrast between Dr. Welcher, who said there were too many variables. Now, you can look at that and say, maybe this guy isn't as competent, or you can also look at it and say, maybe this guy is just more honest because there are a lot more variables here. And contrast that with Dr. Rensler and Arca, who seem very certain of things, who were very certain of things, despite only considering a very small number of possibilities.
Yes.
And doing a very limited number of tests that really don't necessarily tell you all that much. So how the jury settles on the contrast between those two, if they believe, to the extent that they believe Dr. Welcher, and that he makes sense when he talks about the number of variables, to the extent they believe that, then that makes them determine that Dr. Rensler and the Arca guys were just biased here, and they weren't trying to get to the truth. They were just trying to help the defendant. Or if they believe that Dr. Rensler has a more scientific explanation, then that leads to reasonable doubt. I don't know how that's going to come down, but
yeah.
And a lot's going to come down with what Dr. Welcher says tomorrow, I guess, right?
Yes. Yeah. I think it's also just going on too long. I'm just curious, but Kate and Boomer, what do you guys think when you hear these attorneys? And again, they get someone on and they say, well, now remember, it only takes one. You only need one. I mean, next week will be 9 weeks. Are these people really going to be stuck in a room and there's one person saying, I know 11 of you feel it's guilty, but not me. I don't see, like, I don't think
that's
people operate that way. Yeah.
That's desperation talking, right? It's well-wishing. I mean, I get it, like, as a scenario that would be a problem, and it could possibly lead to another sort of hung jury. But after this case, the way things have played out, I just don't see that. I think it's just desperation peeking through.
Kevin, I view it as, I was asked doing some segment today, and Kevin, I view it, I mean, we both know that in the last spring, they were 9-3. Lally got them to 9-3 on the manslaughter. And as we now look at, that case was a mess and it was a circus. So to me, if Lally got 9-3, I mean, I could be wrong, but I view the manslaughter as a lock. And now Hank just really has to thread the needle to make them realize that this is, in fact, a murder 2 case.
It's hard to know because it's such a different case here, right? I mean, Hank has chosen a completely different strategy, and the defense has chosen a significantly different strategy too. And the state has brought in new evidence that was pretty powerful, such as the pocket state of the battery and the battery temperature and things like that. More vehicle data, but the defense has had a chance. Their experts have had time to sharpen their arguments. Dr. Marie Russell essentially came in last year and said, I looked at a picture in the Globe and I thought these were dog bites. But she's now had a year to develop under the tutelage of Alessi how to say she had a method. And she points to things like that. And the same thing with the ARCA guys. They've had a year to kind of practice. And even some of their witnesses like Barrows have had time to kind of help decide that they think they wanted to help. And so I don't know. It's really hard to say. Because if one of these particular witnesses was effective in convincing the jury, then that could be a huge factor. So I think it's hard to say. And the jury's going to be a very different composition. We don't know exactly. It's the jury foreman they got last year. You could just tell from his notes was really intelligent.
Yes, and we don't know who the 12 are.
Right.
Of the 18. So
I don't know if you heard, John, but on Turtle Boy's show tonight, I guess the dismissed juror, the controversial dismissed juror, is supposedly going on his show tonight. I'm not going to listen to the show.
Laura, is that who you're talking about?
From the first trial.
Say her name.
From the first trial.
Oh, I just did. I didn't throw out a last name, but
is this the VFW person?
Yes.
Okay.
It's actually, I think it's American Legion Post, but yes.
Oh, American Legion Post.
Same difference, right? But yeah.
I mean, she is a fan, right, of his and supporter and so forth. So,
but she's going to go on and spin lies tonight, and I know the whole story. And I've avoided saying it because I do, even though she doesn't necessarily deserve it, I do believe in trying to protect the jurors.
Yes,
but I know the whole story in detail from more than one source, and it's a truly sordid tale.
Yeah,
she's not even a juror. That's right, Kate.
She's not a juror. I respect you. I understand. Yeah. I feel that she's entitled absolutely no protection from her own behavior and actions. I believe that if she thinks she can get up and lie with impunity, that the only remedy would be the truth. And I have absolutely no sympathy for what she's about to bring upon herself in getting involved in this and contributing to this circus. She's not a juror. She's not a deliberating juror. She was kicked off because of her conduct. That's fine. If that was the only thing, whatever. But if she wants to go in public and she wants to tell a story, then it is not, how do I put this? It is not improper at that point for the story that she wants to spin to be corrected with the truth. All of it.
Well, we'll see what she says, because I think her motive here is she is a jilted lover, essentially.
Right.
And she wants to destroy I think you know the person's name too, Kate. I'm not going to say it. But she wants to destroy this poor guy, she was trying to basically stalk him that night, the night before she was dismissed. So, and the Boston police had to get involved in this. It's a complicated tale, but I know the story.
Right.
So if this juror is listening, don't go on that show and don't lie on that show.
Yeah.
Just move on. Move on. I've been willing to let you move on despite what you've done to affect this trial. Because she also was conspiring to get the first juror that got thrown off through what seemed to be her lies. And we know that from the judge, what she revealed about the sidebar early on in the trial. But I mean, so by all intents and purposes, this person really should probably be charged with a crime because she seemingly got onto that jury by pretending she hadn't followed it in the media. And then every morning had to raise her hand to say that she hadn't, and basically lie under oath. And based on the evidence we have, she had to have been lying under oath. So, and to me, I wish they had charged her with a crime before, because how else are you going to protect future juries? How else are you going to protect the current jury if you don't send that message that you can't lie under oath?
100%.
Oh, I'm anxious to see who makes the cut for this one, and because I have very detailed descriptions, which I don't talk about, of the 18, and so I have some thoughts about the 18, but I'm curious to see how this shakes out and who's actually going to be the ones making the decision. And then, after this, you guys, I mean, we keep hearing there's then going to be more charges coming on them for witness intimidation and Karen with conspiracy. And I mean, it sounds like there's this trial needs to end. And then, the civil case will be more of the same. And then her facing additional charges.
Right.
Along with the blogger.
I agree.
Quite frankly, with the civil case coming up, I wouldn't be surprised if a new witness intimidation scheme emerges, because I don't think that she and Turtle Boy, either separately or collectively, have any other way to cope with these legal issues than, answering witness intimidation with more witness intimidation. So I don't think that she can behave through the civil trials either. The woman is a psychopath.
Well, I next week, as deliberations are going on, at least I feel good. I mean, I'm listed as an alternate, but I think that should be able to get me in. So, and then I know, there was someone that the cult or the free Karen Read people all kept complaining, she should be in there, she should be in there. And then she was in this week, and then she didn't go because she was sick. I mean, I never missed a day when I was on the list. Of course, those people don't say anything about that, but I want to see who the 12 are. When we get the 12, I think I even have a good handle, until we see them. But there's definitely, of the 18, there are some people that I would put, just by the way they carry themselves, I describe them as potentially a leader, and then some of the other ones you can tell are definitely followers.
Right.
So that's why I push back on that whole thing of, it only takes one. Anyone I've talked to so many times, if the vote comes down 10-2, if one of the two caves, the other one is like, forget it then. I mean, who wants to stand up against the mob? Not a lot. Unless there's a ringer. Kevin, unless there's a ringer in there.
Yeah. I think it's if the majority do argue for manslaughter here, say, and it really does depend on who the leader is in there, which may or may not be the foreman. It may just be someone else that's convincing and kind of a dominant personality in that room.
Yeah.
They may do a lot towards leading the other people in a direction, including if there's one holdout. That one holdout will feel a lot of peer pressure.
Right.
So we'll see.
There is one individual that very seldom takes notes, does lean his head against the wall. I've caught him napping. If he's chosen, there is no way. He is like, what's the group voting? I'm just telling, there's no way he's going against the tide. He's not swimming upstream. So I was laughing. How about Margaret? I was the only one I'm laughing. Came confidential, but of course. What are you kidding me? Of course, they're singing her praises. Oh, she's fantastic. I mean, that show. I like that. I was the only one that had a problem with Lapizada. I'm surprised Sue didn't give the Dr. Lapizada a ride back to Federal Hill. Jesus.
See, I don't even understand either. Like, if you've reached this point of prominence now by covering this case and by being in the documentary, wouldn't the best thing for your career be, Sue, to actually at least somewhat try to appear objective and not one-sided in your coverage on this? But she's not even trying to do that. So it almost feels like she's a plant, or like Turtle Boy has some dirt on her or something like that. I don't really understand it, because it'd be best for your career just to try to appear neutral and objective. And she tries to take that tone, but everything is still to try to give out that one-sided information.
Yeah.
That would make more sense. Yeah.
I think, not to go too long, but some of the, I mean, I think it'd be safe to say that individual we would put more as an MSNBC progressive watcher than certainly not a Fox News channel. But there's some of them, they have this bias towards police. And they don't view, as I've talked, they don't view John O'Keefe as the loving son and the guardian. They view him as a cop, and a bunch of police are ganging up on a woman. And that is the lens of which they approach this. So, you know, she's the same person that said, boy, there's a lot of similarities between Black Lives Matter and the free charity people. I mean, who would, that is like ludicrous.
I know.
It's a total loony bin out there. And these people, by the way, they still think, you know, Proctor's going to flip. You know, they're going to drag Higgins in cuffs into the court. He's going to spill. I mean, it's the guy walking with the sign, the world's ending tomorrow. He just continues to say that. Yes.
Yeah, it's fan fiction.
And I see some of the comments. Something big is coming. There's going to be a
Feds.
defense bombshell.
All right, we're back in court.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
It's exactly the substance of this.
Which was not objected to, right? But did he object to the PowerPoint coming in?
We're all under pressure. I don't know what Mr. Lesson's going to do regarding the PowerPoint. That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay. Our discussion, the opinions and thoughts, thought processes. These are all the tests that were completed and done exactly as Dr. Wolf's PowerPoint was done. Dr. Wolf's PowerPoint was evidence. This PowerPoint should be evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are most of the videos are included. Oh, no, I'm wrong. Things have been slowed down. So the videos are the same, but the videos that Dr. Richland used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, which he testified. So what he did, I remember asking him this before I ever saw the PowerPoint, was there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need them.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the board suggesting that it's not elect just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay? So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess, only a select amount of documents were allowed. I wanted the whole thing in. I was included properly for introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. They had an objection to the PowerPoint. They should have posed that objection before it was displayed for the jury.
Well,
the jury's not seeing the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it goes to the case. If they didn't want to think certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed in, not in part, in whole, as it now assists for the jury, assists for the court for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Leslie needs to, I didn't need to interrupt.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
Your Honor, it's late in the day. We would like to renew our motion to require finding of not guilty at the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it?
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
The technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're private markets exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor.
Are they?
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, they're exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this word's parlance. Yes, it's Y, Z, A, B.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
What number are we at, Madam Court Reporter?
For the 230.
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have. I don't think I have. Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow we need to physically put the sticker on those.
Can I skip another public meetings?
Yes.
230A,
I'm sorry, say that one.
230A through C, 230C.
All right.
Council, there are four, A through D.
Just so the record, this is limited in saying different things. The remark for identification is triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole points marking. So as we do that, I'm good and I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
All right. We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay.
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters for the argument. Last year, we were relegated to 1 hour. I would ask 1 hour and a half.
Please, just let this pass. No, I got it, but yeah, you can go.
I would ask for. I would ask for an hour and a half for a final summation, given the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the
I
same?
don't have a position. I'll take whatever the defense gets.
Let me think about it.
Yes,
All right.
Your Honor.
So we will see.
Thank you.
All right. So I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you.
All right. We'll see you tomorrow morning.
All rise for court, please.
Okay, guys. So there we go. There's our final curveball. No rebuttal.
Mm-hmm. I think honestly, it leaves Hank looking strong, like he's got nothing left to prove. Like I understand that the rebuttal could be useful, but this is just like, to me, in my opinion, it's a strong ending. He's got nothing left to prove. He doesn't want to burn the jury out anymore, and they already are. Might be a safe bet.
To play devil's advocate, could it be because they don't want the X-ray conversation to happen with Welcher?
Could be.
It's possible. It's possible. But either
So
way,
we're
I think
giving the defense the last word, and their last 2 witnesses were pretty solid witnesses. I'm a little worried about that.
I don't know. I wouldn't say they were both solid. I would say that out of the 2, Lapalato was probably more convincing than the display we got out of Rentschler. By the end, Rentschler looked very questionable. I don't know.
I mean, there were some chinks in the armor, but both of them were definitely qualified in their fields, and both of them were used to testifying, so they knew how to testify, and they scored their points. Is that enough to create reasonable doubt?
Kevin, two things. One, Kate was right. Kate predicted, maybe said no rebuttal. But if there is someone on that jury that either through their own belief or that just Alan Jackson played to him or her, I agree with you, Kevin, that if you're of that mindset, what they did do was maybe give you some ammunition to hold out on the guilty.
Yeah, absolutely. Absolutely.
Yeah.
So, I wouldn't want to be a betting man on this case right now, to be honest with you. I don't think there's any chance at acquittal, but
No.
I guess if I
don't see
had
that.
if I had to bet my life, I would choose on a hung jury again.
Really?
Yeah. I don't
Wow,
think
even on the
state's case-
manslaughter?
I just don't know if the state's case was convincing enough to get 12 jurors. And the combination of the jury pool contamination that took place for the last couple of years that was very effective, and some of the witnesses for the defense were somewhat effective, and the state didn't give a perfect case. They did much better this time around, but they still didn't have a very clear explanation for things like John's injuries. So, I mean, they offered a lot of other evidence, but this was weeks ago. Will it all be remembered? I don't know. To get 12 is going to be tough.
Well, I think Hank, strong close, and remember to me the ace in the hole are the Karen clips. So
Oh, God.
her own words about that when we talk about common sense, you don't talk about could I have clipped him if it's dog bites and someone planted stuff. I mean, again, we'll know after closing unless Alan Jackson pulls something really out or Hank somehow, which I don't think he will, bungled it. But Kevin, we're going to disagree. I think Hank has gotten the guilty on the murder too.
I hope so.
do.
I hope you're right,
Yep.
man. I hope you're right.
Yeah.
On the murder too. You think you got the murder? You got the whole. You
I
got the
do.
whole thing then.
Yeah,
I do.
Yeah.
I'm kind of in between you guys, your opinions. I think the manslaughter is going to be the slam dunk, but I lean towards murder 2 is more than on the table, though. I don't know if I'm as confident as you are, John, with murder 2, but I don't negate it, though. I think it's definitely on the table.
For me, as a guy that didn't watch the first trial, I felt that the prosecution of the Commonwealth did their job in this case. I think that my biggest concern is jury tampering. Is there a juror that is free Karen Reed? If they actually got a unbiased jury, I'd have no worries whatsoever about the ruling in this case. In the end, though, I think that it's going to depend on how Hank articulates murder 2. If he can get it across and through to the jury that in that state that intent isn't the main focal point for this reason being it's for this being murder 2, and it's just basically the act, and that a reasonable person would believe that her traveling at over 70% throttle in reverse while intoxicated in those weather conditions, that a reasonable person would believe that could cause death. If he can get that through to the jury, I think they got her on murder 2.
Yeah.
I want to say too, watching chat, it's like deja vu. Man, you can go back to watch the first trial. Go back and look to the chat, because I did this for the book. And all the comments were almost exactly as the same. I mean, in fact, someone back then said, Kev, you're Debbie Downer. Everybody in our chat, everybody was convinced that she was going to be convicted. Everybody except me. And I said it was going to be a hung jury. It was a hung jury. Now, I hope I'm wrong. I hope all you guys are right. But just as a cautionary tale, if you go back to the end of the last trial, you're going to see you all made exactly the same comments. Exactly the same. Even Debbie Downer was repeated. So this is a stronger case this time, as expected. So I'm hoping that won't be the case. There's more than enough evidence to convict her on manslaughter. So I hope you guys are all right. But I just, like I said, as a cautionary tale, go back and you can look at those. And everybody said the same thing. Everybody called me the same names, said I was Debbie Downer, and said I'm too negative. And they said it all then too. But,
Kevin,
But
just
if we
something
all
that
said
I
the same
oh,
thing,
go ahead.
oh, just real quick, if we all said the same thing, how useless would that be too? Like, I'm glad you have your own take, Kevin. Please do. Like, that's no matter what they call you, Debbie Downer or not. Like, come on.
Kevin, why I think that is, to me, there's a couple of differences and three quick ones. One, I just don't think they're going to let Hank down. He's been right there in front of them. He's not Lally. He's made a really strong connection with this jury. He knows who to tap into.
Right.
They all
Good point.
follow him. Number two, Peg O'Keefe. Remember, they look straight across through Karen at Peg O'Keefe. Her taking the stand. That was a powerful moment in there. And then the jurors, are they really going to walk out and watch Peg O'Keefe standing there crying? And then the third thing is, I think Boston media really has dropped the ball on how unappealing Karen Reed is in that courtroom. Because strutting up to the sidebars and then all those Karen clips and saying things, to me, if you're on that jury and you want to convict her, they have given you the tools to do that. And what I think Hank has really drilled down far better than Lally ever did was the act of, it doesn't matter if she was unaware she hit him. It doesn't matter if she just meant to scare him. It doesn't matter if, as she says, you notice that he said he dropped that into Wentzler, other than maybe if you hit him. I think he was mocking Karen when he said that. You know, the video of her saying, I didn't think I hit him, which to me reminds me of Bill Clinton. Like, it depends on what the definition of is. But I think those Karen clips, they're really powerful. There's nothing appealing about her. And, you know, she's talking about the case, and, you know, we know all of the clips of did I clip them and the mocking Peg O'Keefe. I'm telling you right now, this jury is not going to walk out of there and let down Hank Brennan and Peg O'Keefe. And I firmly believe that.
You willing to bet a ham sandwich, John?
Wow. Only if I can eat it in the corner.
Yeah, right.
God, those guys are so repulsive. I have a friend that works for the NHL. I texted him and said, you better revise that and look at that contract. These guys are so unappealing.
Right.
So,
I think we can't forget how much money they must get from the federal government too. And that's
Good
why
point. Yeah.
this to me has always been the big thing here. The federal government would have winked and nodded. They would have found ways to subtly tell them, this is what we want. And we're your biggest customer.
Yeah.
And they would have made sure.
Kevin, that's going to be your story to unearth what drove that.
We're trying.
So, I'll drop something. I may have an in with the DOJ in the next couple of weeks and months. Stay tuned.
Keep in touch, my man. Keep in touch.
Oh, are you kidding
feed each
me?
other. Let's feed each other what we have, you know.
This administration and Josh Levy, a Democrat, and what he did here, I think that's a good story if it gets to the right person.
Yeah. Hopefully somebody will find potential in that where they can take advantage of it for their own purposes, whether it's somebody in the U.S. Attorney's Office, someone in the Trump administration, someone in the media, someone that can find some personal way of benefiting from getting that story out and getting to the truth.
And Kevin, as you say, I mean, for Josh Levy to stand there in a grand jury and he's pulling up the idiot's blog, that's another level. Like, I still can't wrap my head around that. That is sheer lunacy. What is wrong with him? God. And
the arrogance of it, to think that you can get away with whatever you want. It's sheer arrogance. Sheer arrogance.
Of all your sources. Jesus. That's the last person I would ask. But Kate was right. And you know what else? I think it was Boomer that said, I forget who said it, but number one, why revisit the x-rays? But also, listen, the jury's tired. I think they get that phone call. They're going to be excited. And, that means they start deliberating on Friday. So I think Hank maybe did play that right. Why keep dragging this out? Who knows what could then who knows what could fall out of the trunk if you just keep, I agree. Close it up.
Well,
It's
guys,
so hard
I'm
to know.
gonna get
Go ahead.
going. It was good. It was good to talk to everybody and watch the trial today or the hearing today with you guys. I look forward to how this closes out. You guys have a great night.
All right.
Thank you, Dan. Thanks for being here.
Yes, sir. Yes, sir. You have a great
Absolutely.
night. All right. Bye.
Yeah. I also
And so
gotta-
just for people that are still here, I just wanted to announce too, as I've been talking about, we're going to start discussing a different case